Good morning. Good morning. Good morning. It is Thursday, March 30th. I know when I get the day wrong, it freaks all of you out, but trial is like a time warp for me, so I don't always remember what day it is. Today is the day. Today is the day. We're going to hear the final legal arguments in court and then the final arguments before the jury, the closing arguments, my favorite part of trial. I missed all of you yesterday. It looks like Owens has finally entered the chat and had a great cross-examination of the plaintiff, who travels more than anyone I know. What a wild afternoon yesterday. I can't wait to see what these arguments are. We're going to put up a bunch of polls today. How many times will a dollar get waved around? How many objections are we going to have during these closing arguments, which is really not the way. We have so much to talk about today. I hope you're as pumped as I am. Get ready. The adrenaline rush is from now until noon, the court standard time. This judge is hoping to get this to the jury by lunch, if not just after. I think we'll hear jury instructions first, but we're going to go to court live now at 1.25 because they've started doing their legal arguments on the record. And it's actually been really nice to be able to do it at 1.25. I will be monitoring court the entire time. Don't worry, we will have a plan for jury watch. So I think there is a possibility we get a verdict later today. There's a real possibility, and I think almost more of a probability, that we get a verdict tomorrow. So don't forget to sign up for the Law Nerd Alert. We need to get to court already in progress. But again, we get to zhuzh it a little at 1.25, which is kind of my favorite. And I'm kind of on time this morning. Look, I stayed up last night refreshing the dew because I've got some TV appearances today and because I wanted to look spanking new for the Law Nerds for closing arguments. It is my favorite day of trial ever. Let's go.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
All right, I have to do that one more time because I was in the wrong browser. So I'm going to share screen again, but I was in the wrong browser. This is, look, it's too early to be professionals, but we are. That's where we are. That's just what's happening this morning, even though it's way too early for that nonsense. So hold on, let me back up to the feed and get this shared. And off and away we go. Why won't you find my feed? Find my feed. Find my feed. It's so early. It's so early to do this to me, computer. It is way too early. Oh, that's not going to work. I am having nothing but tech issues real quick. Give me one moment. I'm going to switch browsers for both to see if that fixes it. Mingolina, will you put up our Be Right Back? Because I've got to switch browsers or today is going to be an absolute nightmare. Do you mind putting that up so we can hold it? Thank you. Thanks. Okay, Mingolina, I am back. Thank you. All right. I know I put on background music. What do we think? What do we think of the background music? It was a vibe. It was a vibe for a minute. We're gonna have to kill it in just a second once I figure out how. Because we've girl bossed too close to the sun, and now we've forgotten how to turn off our music. There we go. There we go. All right. This is a much better option. We actually can share our screen now. Oh, technology. Isn't it a delight? This is why I don't do live television. All right. Let's go to court. Law Nerds, thank you for your patience.
All right,
We are joining Owens
5 minutes of adjusting.
in progress.
A directed verdict motion may be made at any time.
He was asking for 5 minutes of adjusted
I
time.
think it'll be affected by the exhibits.
All right, great.
I'm going to
For the record,
speed us up
it'll speed things up.
to 1.25.
Bueller,
And then I'm
whoever's
going
gonna make the
to,
motion, why don't you go ahead and
Sit down
proceed?
and just make those, or would you like me to stand up?
they are
Why don't you come up
making
here so I can.
their motions for directed verdict
Stand on the-
first thing this
Okay.
morning. The music wasn't spicy enough. I'll find new music. All right, we'll find new
Thank you, Your
music.
Honor. This motion is a motion for directed verdict on Ms. Paltrow's claim for attorney's fees.
Oh, well, this only goes to the court. This
Under
is not
Utah
something the
Code
jury considers.
78E5-825, attorney's fees are only available in Utah where there is an action or defense in bad faith. In civil actions, as you're aware, Your Honor, there's only attorney's fees to a prevailing
Interesting.
party if the court determines that the action or defense was without merit and not brought or asserted in good faith.
Ah,
These are two independent
if it's a money grab.
requirements. They have not been met in this case. As the court's aware, we filed a motion for summary judgment earlier on in the case when Your Honor was
This
not
is
the presiding
interesting.
judge. That was denied based on questions that the judge had regarding the press conference that was held. And so what I want to talk about first is the standard for the court to utilize in the bad faith statute. It is narrowly drawn, and it's not meant to be applied to all prevailing parties in all civil suits. An action or defense is without merit if it is frivolous, if it is of little weight or importance, having no basis in law or fact, or clearly lacks a legal basis
Wonderful.
for recovery. A finding of bad faith turns on a factual determination of a party's subjective intent. A party acts in bad faith when he brings an action or defense and either lacks an honest belief in the propriety of the
Mr. Ramon's
activities
in
question,
court. Are they gonna
intends
recall
to
him? I
take
bet they do.
unconscionable advantage of others,
I bet they
or
do.
intends to or has knowledge of the fact
'Cause
that
he's
his
sitting
actions
right
will hinder,
there.
delay, or defraud. So therefore, Your Honor, an unmeritorious action, if that's how this turned out, and who knows, that's up to the jury, an unmeritorious action may still be in good faith as long as there is an honest belief that it is appropriate and as long as there is no intent to hinder, delay, defraud, or take advantage of the other party.
Well,
That's what's key in this particular case, Your Honor.
that's not what the plaintiff
As the
thinks.
court's aware, the reason for awarding attorney's fees based on bad faith is to punish the wrongdoer, not to compensate the victim. And that fees should therefore
Well-
only be awarded upon specific evidence of bad faith. There is no specific evidence. There is no evidence of bad faith in this case. This
I
is
don't know,
clearly
chat.
a
What do
he
you
said,
think?
She said ski accident. We've heard the testimony
think
of
it's bad
witnesses,
faith?
of eyewitnesses. Mr. Sanderson
Shouldn't have
had an
been brought?
independent witness that saw the
Should I
accident.
put up a poll?
There were also
I can put up a poll.
experts who have testified that
me
because
1
of
second.
the location of his rib injuries, that he had to have been struck from behind by Ms. Paltrow.
Oh,
There's
I'm going to
clearly,
put up
and
a,
obviously the defense has their own side of the story.
I'm gonna
There
put
is
up a
clearly
poll.
a evidence-based support for his
Give me
claims
one
in this
moment.
case.
good to see you,
Further,
chat.
his damages. The damages are clear. There's no dispute that he sustained 4 broken ribs. And then, obviously, there's the claims for the brain injury. Yesterday, there was a great deal of medical testimony that was brought by the defense. They all agreed that Mr. Sanderson was not malingering, so he is not, fraudulently or lying about his injuries in whatsoever. Ms. Paltrow, from the very beginning, has brought this claim for bad faith and attorney's fees as a weapon to try and compel Mr.
Well-
Sanderson to dismiss this case. As I said,
Or
summary
because she
judgment was
thinks
denied because of this
it's a,
allegation, this loose allegation that, well, there was a press conference. So we've now
Or
heard from
because
the
she
defense.
thinks it's a,
There has been nothing,
money
no
grab.
evidence brought forth by the
He
defense
traveled more
that
than
the press
anybody I've ever
conference
seen in my
was,
life
brought
after this
to take
accident.
advantage of Ms. Paltrow's celebrity, or that it was in bad faith. In fact, the only evidence regarding the press conference was brought through my questioning of Mr. Sanderson, and he testified that it was his personal injury counsel that held the press conference, that it was their idea. and that the purpose of that press conference was to seek to find witnesses to the accident.
So that there was a motion in limine that sought to exclude evidence that related, or I don't know, I don't
the press
remember what
conference.
the motion
Yes, there
sought,
was.
but the result of it was an order from the court saying that evidence that
Unless the door
relates
was
solely
opened.
to the bad faith claim isn't part of the jury trial.
That's true too.
And so the court was contemplating that there would be, that if the jury found for the defendant, that the court would
like you don't
take
need to order
additional
this.
evidence on
Order
the
this
bad
now.
faith issues, or those that related solely to the bad faith.
He's like, you don't need to
Is that
argue
your
this
understanding
now.
as well? And what do you think, what are
This
your
is
thoughts on
premature
that?
argument.
Well, I think, Your Honor, that there's been sufficient evidence that has come through through the trial, that there is no evidence of bad faith. It's a very, very
It's
high
kept
standard
out.
to meet, and there's so much evidence here that shows it is clearly a he said, she said case. This was not based on Mr. Sanderson trying to have an ill motive. And there's a great deal of case law that I could go into, but I don't
They
want to
would
take the court's
present
time
more
right now on that.
evidence. They would present more
I think that
evidence.
the evidence that has been presented has been very clear that there is no bad faith in this case, that they could not prevail on that. And at this point, I really think that a directed verdict on the attorney's fees would be appropriate.
Okay, thank you. Mr. Owens,
No.
do you have, well, first of all, I had two questions. Do you have more evidence?
Oh,
other than
I
what
did
came in
this
here
wrong.
today
Hold on.
To support a bad faith claim? And number two,
Give me 1 second.
isn't the
I did
fact
the
that
poll
your
wrong.
directed
I did the
verdict
poll
motion
wrong.
was denied
I know.
evidence that there is a
We're professionals,
basis
chat.
for the plaintiff's claims?
Yes and yes.
Okay.
I was precluded from talking about this stuff by their motion, so I can't be handcuffed and then slapped. I need to be able to
Okay,
defend a claim.
Owens.
I specifically
That's an
wanted to
interesting
talk about this
analogy.
stuff, but based on Kristen's motion, I couldn't, and now I shouldn't be slapped down about it.
So I would take the
Agree.
motion under advisement. Ms. Orman, I'd like to hear what additional evidence the defense has on the issue.
Your Honor, may I ask when you anticipate doing that?
I-
At a later date, or
After
would that, is
a
that today?
verdict.
At a later date? Well, I guess it depends. I mean, if,
After verdict.
when the verdict comes in, then we can make a decision about when to hear the additional evidence.
Owens,
I remember raising this issue and said, Your Honor, did you envision then?
I remember that.
A later hearing
Right.
at a time convenient to the parties?
Yes.
Thank you.
Mr. Bueller?
Bueller.
Your Honor, on the issue of spoliation, there's a jury instruction, and we believe there's been no shred of evidence presented in this case that the plaintiff had a GoPro video. He denied he had a GoPro video. The only evidence is an email from his daughter who says, "Oh, I can't believe there's a GoPro." And
The testimony of the daughter as well, Shay.
Yes.
yeah, that's who I'm but that doesn't mean, I mean, it could be anyone that had the GoPro video. Could have been
They're
could have been
arguing
anyone, but
that
there's just absolutely no
they
evidence.
did
It was a
not
mistake.
destroy
And,
evidence.
it
That's
would be
the
absolutely
argument
erroneous
here.
if the court gives this jury instruction, because other than that mentioned in that email, which the defense, and there's been no evidence at all brought in this case that there's anything to it, would be clearly erroneous, and therefore we request that the spoliation issue be stricken from.
Y'all don't forget to share the feed with a friend.
As it would prejudice
Sharing
the plaintiff.
is caring.
On something that has no basis, has not been proven, they have nothing. In fact, the late produced meetup.com comments
Was
verified that, because the defender, Shay, and there's just nothing there.
Okay. Thank you. Thank you. So I'm going to deny the directed verdict motion on the spoliation instruction. The defense,
Oh.
have you reviewed the instruction?
the
There's a
jury's
new
going to
one that
get
came
to
out
hear
removing
the
word- removing the word
spoliation
"the" from the bottom.
instruction.
It's acceptable.
Okay.
That's
And,
interesting.
Mr. Bueller?
Bueller.
I mean, you're
I
certainly
realize
welcome
that he's apparently related to
submit a
Ferris, I've
request to the
heard.
court, some additional interrogatories.
We're gonna
so
talk
that
about
it's clear from the
spoliation,
record
not
whether the jury
exfoliation.
made findings under spoliation or not.
Exfoliation is important,
I
though.
think it could track the instruction itself. That way, if there's a verdict that's adverse to your client, you would know whether
We'll
the
get there. We'll
spoliation
get there, don't
instruction, whether there was any inference taken by the jury on the GoPro video.
Yeah, it gives more credence to the lack of
Attorneys
evidence
to
of
the
this,
bad faith.
So we'll consider that, and I guess we would have to do that pretty darn quick.
Yes, we would. I think that the daughter Shay testified that when she got off the phone,
Yep.
she thought there was a GoPro video. And I
Yep.
think reasonable inference from that, the jury could decide that there was a GoPro video and that
Yep.
your client had some control over that video.
Agreed.
They could make that decision.
Right, but there was no evidence that he had control over it. It was just there was one. It was mentioned,
Inference.
and,
He said inference, Bueller.
It means that every time a piece of evidence that's mentioned that turns out to not have any basis, then it becomes.
It was in an
spoliation issue. I
email
think
from
that's,
him.
An erroneous.
Well, from
level
her to
of
him.
Proof. I've got two others, or actually, and then finally, do you mind if I go ahead now, Your Honor?
Go ahead, please.
Okay. On the issue of negligence, and I'm going to talk about both defendant's negligence and plaintiff's negligence. On defendant's negligence,
I promise I'll
at least for the
explain.
record, we assert that there should be a directed verdict on liability, causation, and damages, and that is based on the evidence
No.
that's been brought before the court.
It's not going to happen.
Likewise, on the plaintiff's side, on the defendant's side, we should have a directed verdict in favor of the plaintiff. On the plaintiff's side, the charges from the defense against the plaintiff on the issues of liability, causation, and
I
damages.
promise I'll explain.
should
Bueller, we're
also
pausing
be
you. We'll
brought in.
catch up. Don't worry. The court's going to take a break. Okay. Real quick. The thing they were just arguing about spoliation was an instruction that will be given a jury that allows them to make an inference if they find that evidence has been damaged, destroyed, lost by the other side. They're allowed, the jury instruction tells the jury they are allowed to assume that that evidence would have been bad for the party against whom they find spoiled the evidence. So if they think the plaintiff had a GoPro and now we don't have GoPro footage, they're allowed to assume that that GoPro footage is bad for him. That's a very big jury instruction to lose for them, because I will ask again, do you think there was a GoPro video that this plaintiff destroyed? And if you do you think that the GoPro video then shows that he, in fact, ran into Gwyneth Paltrow, and it tells the jury they can make that assumption? It is a huge, huge instruction for Gwyneth Paltrow. And I know these moments in court go very fast that are a big deal, but that moment in court is a very, very big deal for Paltrow and a very bad instruction for plaintiff, because it is something they have to deal with. So if this jury says, well, did they get rid of the GoPro? They're allowed to make the assumption that it was bad for plaintiff. So you're now allowed to assume as the jury that that video showed Gwyneth Paltrow being hit. That's what the jury is allowed to assume if they believe that there was a GoPro video. Massive, massive ruling that happened very quickly. So they are going to get that spoliation instruction to the jury. Did you spoil the evidence? Did you destroy it? That's a very, very big moment. That's a very, very big moment for this. So with that, we are going to get into a motion for directed verdict, meaning, Your Honor, the jury can't find anything on this. You have to give the verdict now. It's like the motion for judgment notwithstanding a verdict or motion to dismiss in criminal. It is, hey, the other side didn't prove it. You have to direct a verdict, judge. So we're going to get there here. Ashley, does that not bias the jury? It does bias the jury. But that's the point. If a party destroys evidence, so if you had a party that was wilding out on Twitter and saying a bunch of shit, and then they destroyed all that evidence after they were obligated not to, after litigation had begun, shouldn't it count against them? This is a rule in civil, because a lot of times in civil, you get notice that there's going to be litigation and you're told you cannot destroy evidence. You can't just Enron documents. But if you do, and there's evidence that you have, it will get held against you in court to the jury. And normally the notice says that. It says you are obligated to preserve evidence. If you fail to preserve evidence, it can be held against you in court. And these jury instructions are aggressive, especially in civil law. There's different obligations in criminal to prevent this from happening and much stricter repercussions. But in civil law, the repercussion is the jury gets to hear about what you did and they get to assume that it means the evidence was bad for you. So that's where we're at. So does it impact the jury? Yes, it can, but that's the point. Don't destroy evidence. And if you didn't destroy evidence, then you have to explain it well enough to the jury so that the jury knows that you didn't spoil evidence and that this was just an impression. They have to argue it well because it's only if the jury believes it. It's only if the jury believes it. All right, let's continue on. Aaron K., I have to pause because if I don't pause, I can't explain and everybody's going to be like, but we need to explain spoliation. So, and I can't talk over it. That was more of an explanation, but that was a huge moment in court this morning, so we're going to explain it.
I could summarize the whole case, but I don't think it's necessary. I think the court realizes that, but if you'd like, I could add more detail.
Lou, I
on the
heard
basis
it.
of
I
that
didn't
directed
believe
verdict
it.
motion.
I didn't believe
Two of
Epstein
them.
Island popped up.
$1.
Yes, the $1.
Yes,
that,
I've used it as a verb now.
LU, that's the second one. The first one is a directed verdict in our
Well,
favor
they're gonna have to
for our
find time.
damages, liability causation, and the only issue would be the amount of the damages for us. So I combined them two, so it's actually two directed verdicts.
Yeah, we needed to
with
talk about
3
that. That's a big
subparts
deal.
each, liability, causation, and damages.
And I have given it some thought, anticipating your motion. And based on my review of the evidence, I
Yep,
would deny.
there's no directed verdict.
Both motions with all 3 parts in both motions.
Okay, thank you, Your Honor. Then I have one other, it's not a directed verdict motion, but it's a.
One more.
It's a motion.
All right, Bueller, third time's the
To take
charm.
judicial notice of Terry Sanderson's life expectancy according to the Social Security Administration.
Oh, hell no,
life
that wasn't
expectancy
admitted
tables and
into
calculations.
evidence.
This is something that's commonly done. I'll just advise the defense that we're planning to use in our closing reference to the life expectancy of Terry to calculate a per diem.
Have you disclosed to them what number that you plan to use?
Yes, I'm ready to do that right now. It's, they change with each day.
Right.
And,
Oh, civil law.
or two.
In principle, does the defense have any issue with that?
Well, he's got 20 some odd health conditions, some of which are
Yes.
impact life expectancy.
Yes.
So I have some problems about it, but it'd be nice to know what they want.
We're actually going to go lower than that. We'd like,
This should have been done
10
earlier.
additional years.
yeah, just 10 years, even though it says 10.8.
Life expectancy of 10 more years.
He's a non-smoker,
So
there's other health
86?
factors in his favor that he's conscious about his health, and so we just want to, in closing argument, mention that
They didn't bring in
he has
any
a
evidence on it.
potential life expectancy of this, and then argue that on a per diem basis for his future non-economic damages. Non-economic damages, as you know, are not precisely derived. They have, it's more of a subjective viewpoint of the jury and the parties' arguments in favor of.
To address the defendant's issues with, the.
You guys have great
the,
questions this morning. I'm
comorbidities, let's
grabbing
call
them
them.
as they're
They
coming
can argue
in.
that too.
I realize they can argue that, but how about to address that if what the court takes judicial notice of is that a person who is 76 years old has an approximate life expectancy based on the Social Security tables
Approximate.
of 10 additional years?
Yes.
Is that,
Your Honor.
that way I'm not taking judicial notice of the plaintiff's life expectancy, but rather what the Social Security tables say.
And then it can
Right,
be
Your Honor.
argued.
And,
Or I'll give you 5.
Smart.
here,
As it relates to Terry.
let me, I know what they are, counsel. Let me just say this. We don't plan to reference the Social Security tables. It would be just
Oh.
a simple that.
The judge
statement
doesn't like that.
Terry's life expectancy could be calculated at approximately 10 years. And the past 7 years since the trial date, it's like taking cognizance of the.
Make that conclusion because it involves an individual.
Oh, you don't have to make the conclusion. I'm just.
You just laid it out, I would.
I'm just.
This judge is patient but
previewing what
sassy.
the closing argument will mention.
Small but
And that
mighty.
it's not evidence in the case, it's argument.
If I'm taking judicial notice of it, it is evidence.
Well, I don't think the court needs to take judicial notice, but if the court would like that, we did produce this. I'm just giving you a preview in the defense counsel that we will be making this argument that he could potentially
You're
have 10 years
asking
of
for
life,
judicial
and that,
notice. You're not just
that's the
arguing,
basis
you're
for our
asking for
damage claim.
judicial notice because it's not in
It's-
evidence.
We're not raising it to the level of something evidentiary, it's pure argument for calculating non-economic damages.
Okay. Mr. Owens?
I don't have an objection to Your Honor's approach, which is under Social Security tables, a 76-year-old man is expected to live 10 more years.
And Mr. Bueller's is proposing that not what happened,
Well,
but
yeah.
that they just refer to it in closing argument. I mean,
Yes.
not, that they don't refer to any particular table, but they just say, a man at his age, he's probably got about 10 years. Do you have any objection to that?
In its argument. But if the court is inclined to not prohibit the plaintiff from making that argument, then we would ask that the court take judicial notice of what I just gave you.
They can argue it. They can argue it.
Okay, so you can argue it without any reference to the table or me taking any judicial notice.
Unless counsel wants reference to it, or the court does.
If you're going to talk about Terry, I'll stipulate to 5.
No.
Okay, then we'll keep it as argument.
Okay, which brings up a very important point I wanted to raise.
This goes to damages.
There have been a lot of evidentiary objections during the trial that a particular question misstates prior testimony in the case. What I want to avoid is a lot of that kind of objection happening during closing argument.
Yes.
That, hey, he's not saying what really happened here in trial, or he's misstating
That's
what really
argument.
happened here in trial.
I like this judge a lot.
I don't want to see a lot of that objection during closing arguments, because my reaction will be the same as it has been throughout the trial.
It's up to the
jury
jury.
will remember what people said. So if you think that the other lawyer or lawyers say things that aren't supported in the record, then bring that up in your part of the argument.
Though, okay, if it grossly misstates it,
And
though,
so
they have to say it.
Because what I expect you to
They
do
have
with
to
this one
make
exception
a
of
record.
this 10-year thing, I expect you to tether your arguments to the evidence that was in front of the jury and any reasonable inferences from them.
Reasonable
Not to bring in
inferences,
outside data,
counsels.
not to bring in outside evidence, but just the evidence that was here in this courtroom.
That's going to be hard
Okay.
for both
Just
sides,
to-
because both sides
to
have
give you a
brought up
sample,
stuff
you would
that's
argue
not
that
in
Terry
evidence,
has
like Owens
Approximately 10 years left.
bringing up Jenny's
At least in his
depo
life.
and never
He's lived,
putting it
healthy.
in evidence.
He's not non-smoker.
And there's not any objection to that.
Thank you.
Okay. Turning now to the jury instructions, does anyone wish to object to any of the closing jury instructions that the court put together?
We're reviewing them.
For those
I
asking
know you
about the
gave them to us
reference
yesterday.
table, it goes to damages.
Give us one moment, please.
The only one that we might have a small suggested change or objection to, Your Honor, is the spoliation.
Can you speak up?
Sorry, it's the spoliation instruction we have here.
Okay.
It's that first sentence.
Oh, dear.
We
Here's
don't
the
believe
instruction.
that There's been
I hope he reads it into the record. Please read it in the record. We want to hear everything about this instruction. This is the instruction that allows the jury to make those inferences about the GoPro video. Let's hear the argument over that. I'm very excited to hear more about this GoPro video instruction.
any evidence that Mr. Sanderson was in possession of a GoPro, and so we would want the first sentence to be changed to, Ms. Paltrow has presented evidence that a GoPro video of the ski collision may have existed. Sanderson asserts that the GoPro video of the ski collision never existed. So it'd be, because there's been no evidence put on that he possessed
judge
it.
is gonna do
There's
that.
been
They're trying
inference
to
of that, maybe
minimize it.
at best, but it's, again, coming through his daughter's email to him.
I think that's a reasonable request.
Because there's been no evidence of his possession.
It's more neutral, I think.
It is more
So it
neutral.
would read now.
Ms. Paltrow has presented evidence that a GoPro video of the ski collision may have existed, period, and everything else remains the same.
Yeah.
Okay.
Any other objections from the plaintiff to the jury instructions?
No, Your Honor, as we looked through them yesterday, we were, that was.
Okay. How about the defense?
Your Honor, one thing I noted on the violation of a safety law instruction, the last sentence reads, if you decide that Mr. Sanderson and/or
That's not as
Ms.
strong
Paltrow
of
did
an
not violate
instruction.
safety law, you must disregard the
Depending on what the
violation.
rest
And I'm
says.
thinking maybe that should read safety law, because in the
Yes.
prior clause, there's no violation.
Thank you. That's correct.
Thanks, James.
And then I did not include the inherent risk of skiing that the defendant
The law
requested.
nerds are
Is that
cheering
one
for
that
you
you're-
at this
Are you
point.
dropping that request, or would you like me to give my reasoning why?
We want it, and we would like your reasoning.
Okay, here's my reasoning. So the defendants have requested a jury instruction that was entitled "The Inherent Risk of Skiing," and they were basing that on Utah Code 78B-4-401 and what follows, as well as the Donovan versus Sutton case, and so the courts reviewed those very carefully. A plaintiff asserting that a statute, and basically they're asserting that this statute provides support for the applicable standard of care, or that relates to the standard of care in a tort claim. And if a party is planning or is asserting that, they must demonstrate that the purpose of the statute was to protect a class of persons of which the plaintiff in this case is a member, or the parties in this case are a member, and to protect them against injury or death resulting from the kind of harm contemplated by the legislature. And that comes from the Colosimo versus Gateway case. Further, a plaintiff must show that the law was intended to protect persons in the plaintiff's or the defendant's shoes from the type of harm that befell them. So the Utah Code 78B-4-401, the Inherent Risks of Skiing Act, is not a safety statute as is anticipated to be read through a jury instruction, but a limitation
Molly,
of
I also think all the
liability
lawyers
statute
showed
in
up
which the
today.
persons protected are ski area
We're hearing it
operators,
from the lawyers.
not skiers. The act is not affording any protection to the skiers against injury, which is the type of harm at issue here. So looking specifically at this instruction as it has been submitted to the court believes that this inherent risk of skiing proposal, this jury instruction proposal, circumvents the proper application of the elements of a cause of action for negligence to the extent it allows the jury to reach a result without following the principles set out in the usual negligence instruction. It also creates a substantial potential for confusing and misleading the jury. A jury could rely on a more general understanding of inherent risk of skiing and that it is simply an unfortunate and unavoidable injury-causing event for which there is no responsibility, even though under traditional tort concepts the accident was caused by negligence. Compounding this confusion is the implication that the inherent risk of skiing constitutes a second ground of non-liability. An instruction carries a substantial risk. This instruction carries a substantial risk of diverting the attention of the jury from the primary issue of negligence and has a significant chance of creating the impression in the minds of the jurors of a second hurdle that the plaintiff must overcome if he is to prevail. This instruction creates a spurious additional issue in the case when in fact the sole issue is the presence or absence of negligence proximately causing the accident. The jury is faced with complex, conflicting, and less than compelling evidence, and the imprecise rules of causation and comparative fault create a significant temptation to abandon a rigorous application of the instruction and the elements of negligence and the burden of proof and return a verdict based on the simple notion that an accident was an inherent risk of skiing or somehow unavoidable. Apart from the inherent confusion, the instruction tends to re-emphasize the defendant's theory of the case that the defendant was not negligent. To that extent, the instruction then constitutes an inappropriate judicial comment on the evidence. Of course, there are collisions caused by the inherent risk of skiing for which the defendant or defendants are not negligent. In such cases, if supported by the evidence, the defendant can certainly argue that they were not negligent and that the accident was the result of an inherent risk of skiing. And I think that would be appropriate argument in this case. So defense can certainly argue inherent risk of skiing. There's been evidence of inherent risk of skiing. They can argue that neither party was negligent and this was purely an accident, and that neither party was negligent. But in terms of the court reading the instruction, those would be the reasons why I've declined to do so.
Your Honor, I actually misspoke earlier. I think I've got one thing that I just noticed to other instructions if we're ready to move on.
Sure.
On jury instruction, page 16, mitigation of damages, I believe the second sentence, it says, any damages awarded should not include those that could have, and I think, been avoided needs to be added in there.
Thank you.
Thank you.
Do the defendant have any other exceptions they want to take to the jury instructions?
Yes, Your Honor, thanks. Yesterday, are you okay if I sit here?
Sure.
Yesterday, Your Honor granted a directed verdict on behalf of the defendant on the issue of post-collision hit and run. Help me if I'm missing something, but we previously provided to the court the defendant's proposed instruction 45, entitled
They're still
Gwyneth
arguing
Paltrow
over
did
the
not hit and
final
run
jury
and flee the
instructions.
scene.
This is
I
tough
have a
because they use these in
copy.
closing
It's
and
marked
it's
up if you want it.
late
I've got it
to
here.
be finalizing these. It's very late to be finalizing these.
Your Honor, I think the denial of the directed verdict, it doesn't use the word hit and run, and what we talked about yesterday was post-impact or post-crash conduct is still relevant to the...
Yeah, the failure to render aid portion of the ordinance is still being read. It's the failure to give
not done yet.
phone address and contact information that was directed out. So if you have an instruction
Oh,
that
yeah, we
relates
could
to
do
that,
more
I'd
likes
be
than
glad
that.
to consider that.
And it also included Dr. Goldstein's testimony. That was also the basis to demonstrate the...
Gwyneth is normally in the holding room in the
availability
back.
of the post-crash actions or events.
So do you have another instruction that's more closely tailored?
I think the first sentence of the two sentences. So Your Honor chose to split the issue, and this is the heading. So the first sentence is what we want. I have already determined that Gwyneth Paltrow did not hit and run and acted...
Brent, they are, but I am on Central, so the jury will be
Maybe
back
that's
at
the
10 my
extent
time.
of
So I
it.
put things in
Your
my
Honor,
time
I
or
think
I'll
that's
get
inappropriate.
confused.
It's preloading an issue that what isn't an issue. It's not something that we're asserting, and that there's the motion in limine stands for, and we think that we could put in a lot of things.
Your Honor,
on both
leave the
sides that
lemonade alone.
are at this stage irrelevant and distracting.
Yeah, the courtroom is very full
There's been
because
some-
closing is the
There's been
best.
evidence as well as argument, well,
Also,
opening
there's no
statement
storm
and
today.
cross-examination implying that the defendant left the scene without giving,
Yeah,
in violation
there
of
is.
some ordinance or some requirement that
Yes,
she give
there
her
was.
contact information.
I agree.
So what I could read is that I have already determined that Gwyneth Paltrow did not leave the scene of the accident without giving her contact information.
Thank you.
That's reasonable, Your Honor.
I'm glad you think it's reasonable. Yeah, courtroom is very full today. Very much fuller than it normally is. But
Any other? From the
Closing
defendant, any
arguments
other
are the best.
exceptions?
Yes, Your Honor, and you did rule on this, so I don't want to irritate you, but Deer Valley's
the
resort's
self-awareness
dismissal.
from Owens at this point.
I do like the words "for no payment," and this was previously argued. I'm rendering an objection. I always
Okay.
get a kick out of this idea. It's so obvious we don't have to say it. Well, then why don't we just say it?
That's noted. I mean, the instruction's already been read. It's in the opening instructions. Any others?
Closing is my favorite part of any trial.
Your Honor, I've had a lot of paper thrown at me. Is the oral argument, jury instruction that says
I'd
if
want to throw paper at
you
him
find
too.
that there was no negligence, you can disregard the remaining damages instructions?
You'll see that when we get to the special verdict form. It's incorporated into the special verdict form. It indicates that if you find no negligence on the part of either party, you sign and date the form and turn it into the court.
Okay.
So I think in the opening instructions, it said something to that effect. There is a standard Muji that says, I'm now going to instruct you on damages. If you find that there's no negligence,
conversations
you
on
should disregard
stationery.
these instructions.
Okay, yeah, it looks like it's on the introduction to tort damages page. I think it's 12 or 13 in your
The
packet.
Muji is the Model Utah Jury Instructions, MUJI. In California, they
Okay.
were CalJIC.
Turning to the special verdict form, I realize you just got my version of it. Have you had a
looks like
chance
Jessica
to
did
decide
just
whether this
walk in.
meets your needs? I took this from the Florida claim, counterclaim verdict form. I took the concepts here.
Paltrow is not there when the lawyers are
Oh, you
arguing at the
printed it.
table.
Sorry,
It
I was looking at
seems
my email.
because she
I
doesn't
see.
want to
Thank
be
you.
on camera. And when the lawyers are arguing at the
Did you get
table.
that, Mr. Bueller?
Yes, we
Then
did. We're just
she
wondering
will
if, before.
Also, when
closing
I hear
argument,
Muji, I think
get another
Mubi.
copy, Because two counsel, I think.
So at the back of the courtroom, there's that
I just wanted
little
to-
like
there's one
window.
change that I think I might
mirror.
need to address with you.
She's only
whenever you're
there
ready, and
when the
then
jury
You'll
comes
have to
in.
print out new copies.
Because the decorum order has been violated. I was violated by the gum, but they were violated by the camera pointing at counsel table. So when they're at counsel table, the camera is allowed to point at counsel table when they're arguing from there, but then it would be on Paltrow while the attorneys are arguing. So you can see her talking to somebody in the back of the courtroom.
I mean, we can wait to look at this until, just before reading jury instructions, because I would like to read this to the jury during that part of things.
I think
If
this will
you're
be
not
a
quite
pretty
ready.
quick deliberation. I think
Can we tell you in 2 minutes?
it'll be
Sure.
a quick deliberation. Shay said, so there's no
The one-
GoPro,
I can
correct?
tell you when you're
Well,
ready, it's the one change that I see.
there may have been, but there is not now.
It's 2/3 of the way down on page 2.
I'm so
When you
ready
go-
for
when
closing
you get past-
arguments.
When you get to the bottom of the comparative fault questions, there's that separate section.
We'll talk about
Just
comparative
above-
fault
Just
at the
above the
break.
damages line, it says, if Terry Sanderson's fault is 50% or more, rather than proceed to question 9, because that one's already filled in, I suggest that we just say, sign and date the form and turn it into the court.
Does that still address our counterclaim?
Yep.
Oh, I absolutely understand this too. I think after we saw the memes from Depp Heard, Paltrow very much does not want to be on camera.
Am I thinking that through right on the comparative fault? If Terry Sanderson's fault is less than 50%, then you answer the damages question.
In this trial, there is a time
If it's 50% or
limit.
more, you just sign and date it, and that means that the $1 that's been assigned to Gwyneth Paltrow is the counterclaim.
They did already address the GoPro instruction. I want to hear the closing. I think it's going to be hard for the jury to find a lot of damages, even if they do find the collision, because of all the travel after and how much he downplayed it.
If Terry's fault is 50% or more, that
I
the
think they could
defendants,
easily get to 50-50 on
doesn't
this.
have 50% or more either. Or, stuff happens, inherent risk of skiing, accidents happen. The jury could deny awarding the.
I'll tell you my
$1 to
order of
Ms. Paltrow,
surprise in a little bit.
Well, if they put 50-50 on the comparative fault questions,
Y'all are done.
Then it would.
Then you're done. You're done.
right?
Right, but
Yeah,
there's
done.
a possibility of, I guess they'd have to do that exactly, but if there's this other, is that what we're thinking, co-counsel? Pete?
In other words, I guess what I'm saying is I think there's enough information in these answers to help us to create a judgment based on any scenario that they come up with.
50-50 is a huge win for Paltrow.
It seems like that to me, Your Honor, as well, but I just want to make sure that one of
Sometimes
the.
a flow chart's helpful.
Yeah, that's true. It'd be nice if one of the questions, or it's important, obviously, that one of the questions allows them to connect Terry Sanderson's fault to say that it caused Ms. Paltrow's damages. And do you see that as covered by comparative fault questions? Because number 4 just asks whether his fault is a cause of his own harm, not of Ms. Paltrow's harm. So I just want to make sure that causation
Oh, I see that.
question
I see
is
that.
addressed.
Should 4 read just like 2, counsel?
That was my thought, and then the comparative fault questions address whether Terry Sanderson's
It's so odd
fault
to me that
caused
they're
his own
just
harm, or to what
finishing this
extent.
now.
In other words, if.
'Cause you
if
need to
the
argue
party's
this in
fault
closing
caused
in
the
like
other
5
party's
minutes.
harm,
You
is
need to
that
know.
sufficient? Or do we need another question, or does that question need to be modified to
Like,
say?
this could change your
Was a party's
closing.
fault the cause of their own and the other person's harm? The other party's harm? How would you like that to read? I'm fine with it, just, with
I'm
us.
grabbing your questions as they come in.
Redrafting 4 to read like question 2.
In court, it seems like everybody is now sick,
Any
except maybe the judge.
Self-harm is captured by the comparative fault questions.
Maybe another reason we don't see
That
Gwyneth
seems
Paltrow
reasonable.
at the table.
That seems reasonable to us too, Your Honor.
Okay. So the question 4 will read now, was Terry Sanderson's fault a cause of Gwyneth Paltrow's harm?
So Peter has been going back and forth to talk to Paltrow, who's in the back of the courtroom. I did refresh my hair last night. Well, early this morning.
The
It
title of
was.
these,
It was a. I'll get to the poll results in a minute. It was a. It was an
sections were
ADHD
Paltrow
overnight
questions.
choice.
That, should it be like defendant Gwyneth Paltrow questions?
I
or
should go to
we
bed, but I
eliminate
want to
that
dye
at
my
all?
hair.
I'm just posing that as a question because it seems kind of, she's not asking that, we're asking that, and the vice versa.
Questions on Gwyneth Paltrow?
Yeah, above number 1, is the title underlined in bold says Gwyneth Paltrow.
Oh, I saw all
Just
the
take the word
pictures
questions
yesterday.
out?
I just.
I want to travel as much as Terry Sanderson
Makes it
traveled
sound
after
like
this
when
accident.
they're
I'll
asking,
tell you
but
what.
In reality, we're asking, was Gwyneth Paltrow at fault, not Gwyneth Paltrow?
So how about if we just label it Gwyneth Paltrow?
Right, or does it need a title?
Gwyneth.
I think it helps direct their attention that we're talking about her actions.
Right, I see that.
Just eliminate the word questions on each of the headings?
Yeah.
Let's do that.
Because it implies that she's asking that, and
And I can also delete it under comparative fault, and we'll just call it comparative fault.
yeah, I think that makes more sense.
May I go to 8 and 9 just for one
I
moment?
forgot my
Yes.
water. I needed to phone a
We're
friend.
nitpicking, but Judge Tom Green used to say, if we don't get this right, we get nothing right. So, number 8, what if we said, what amount fairly compensates Terry Sanders for non-economic damages? There's a bullet point that I don't understand.
Yeah, I took this off of the plaintiff's form. That's the way the
Thanks for
standard.
doing the
Muji
subscribey things. Don't
does
forget
it,
to do the
but
likey things.
It does it when there are more than one
helps
category.
more people
too.
find the channel.
So, yeah, that could simply be added to
So
it.
that, for non.
The only thing I
economic
thought about
damages.
was that it clearly says non-economic damages, and there is a jury instruction that is entitled that, as well as the number 9 clearly says economic damage, and there is a
No,
jury
we'll celebrate the
instruction
bang in a
entitled
minute.
And for the economic damages jury instruction, perhaps it should just say, Gwyneth Paltrow seeks $1. I don't think they need to even
Decide it.
need
I
this
think you're
big
right.
instruction on economic damages.
It's
What
stipulated.
did the
They need
plaintiffs
it
want on
put in
economic
there.
damage?
Well, I
Just
think
put it in
as
there.
the court pointed out, I think we already have the instruction. We've been working on the instructions for a while. We like to have it in there, and I think it clearly is indicated here on the special verdict.
What I like about it, Mr. Owens, is that it distinguishes the non-economic damage.
Okay.
Yep.
And then number 9, I would just say, what amount fairly compensates Gwyneth Paltrow for economic damages? Delete the bullet point and the ...
Okay. Is the plaintiff okay with deleting bullet points and the ...
and the empty space. to
Never.
the right.
Give me the ... and the blank space.
On 8, I think it's
I'll
just
This
write
is
your
a
name.
line to fill
This is
out,
on
right?
9.
8 and 9, just take out the bullet point and the dots.
Just include it as part of the sentence.
Yeah. And then what's this business of a blank space?
Oh, Stardust.
Under where
You're the best.
think
I forgot.
number
Hold on.
8, There's a missing line to fill out. That line for.
I have a
damages
story
for
about when my
Sanderson.
phone went off in court. Anyone remember what my ringtone was, chat?
I'm not following you.
Hold
You
on.
want to blank
I bet I have
after
a
the
dollar.
dollar sign?
No,
What?
no, there was just,
Thanks, Dr. B.
there's a line underneath
I've got to get my money out to wave it at the chat.
fill out.
On question 9.
Well, it doesn't matter.
Agreed.
Oh, Chad, I
That-
see the
that
answer.
line shouldn't be there.
I'll do my best.
I'm dropping shit. I see the answer.
Version last night, their tables are part of it.
They are. They're tables.
Good to see you,
Why
law
don't we take
nerds.
just a short restroom break? Mr. Sykes is now here. Good morning, and then we'll bring the jury in.
Your Honor, can I mention one thing?
Bring the jury.
We filed a pretrial motion on rebuttal
Oh,
witnesses.
and we were so close to bringing the
number
jury.
12, defense pretrial 12. It was granted. It sought to give you a little bit of a bench brief on the narrow scope of rebuttal witnesses. In short, they are not to just
I remember this
state anything
from my
that could
podcast
have
episode
been
about
stated in
the
case in chief.
MILs.
I even had
Not
the
good
judge
paper
in
noise.
Logan
Bad
literally
paper
say
noise.
you can ask like 8 questions and then he can say yes or no with one sentence. I mean, and I was on and off in about 3 minutes because those were the only brand new issues that they couldn't have predicted. And so we asked that this rebuttal witness be strictly limited. It's not used as an opportunity for the plaintiff to just
Motions in limine.
restate and sort of get the last word on things that,
So we talked about this when the motion came up, and the court agreed that these are rebuttal witnesses. They're not to strike off into new territory.
They're limited
not
to the
clarify.
law
They're
of
to
evidence.
respond.
I love the
Correct.
motions
They're
in
just
limine that
issues
are like,
that
we want the
came
other
up
side
in
to
the
follow the
defendant's
rules.
Case. And then, of course, on the counterclaim. All right.
brand new issues.
That's all, basically 3 questions, Your Honor.
And who's the next witness?
It's Richard Boehme. We're just waiting for him to get on the Zoom.
Okay. While you do that, then we'll take a short recess. Thank you. As long,
As long as
unless,
it's needed.
unless it takes longer to get him on the Zoom. Let the bailiff know as soon as you get him on the Zoom.
All right, I'm going to try to catch us up to real time.
While you do that, then we'll take a short
Oh,
recess. Thank you.
We're caught up to real time, so we are going to a break. I get to
As
answer all
long-
your questions.
Unless it takes longer to get him on the Zoom. Let the bailiff know as soon as you get him on the Zoom.
Why so many people in attendance today? Because closing arguments are the best, and I think the general feeling is that this could be a very quick verdict. Good morning, law nerds. There are 28,000 of you here. Please hit the like. It helps bump us up and helps other people find not just my channel, but this particular video, because it really is the best place to watch a live trial. Today, we have closing arguments. We're on a court break for a moment, so I'm going to answer some questions and talk about what just happened this morning. So if you're just joining us, we're going to do a quick recap of this morning. The defense had a big win with a spoliation jury instruction. This allows the jury to make an inference that the other party has destroyed evidence relevant to the case, because if the jury finds that there ever was a GoPro video in existence. We'll hear that when they read it in. It is a very big instruction for the defense and a very potentially damaging instruction to the plaintiff, because there's that evidence that Terry Sanderson's daughter was left by him with the impression that there was a GoPro video after their conversation. And of course, that GoPro video has never been found, never been turned over. So if the jury believes that this wasn't just an assumption, they're going to have to argue it. If the jury believes this was more than just an assumption, then they can infer that the plaintiff destroyed it, and they can take that as a negative inference against them, meaning they can say, oh, the GoPro video would have shown something damaging to their side. It's a very big instruction for Gwyneth Paltrow to win this morning. They also went through I'm looking at my notes because lawyers need notes and I always need notes. They also went through their directed verdict motion saying, Your Honor, they've never even proven the case. And the judge was like, no, we're done. And then they finished going through jury instructions. This is giving me like literally a upset stomach. I can't even fathom what it would be like to be not that long away, not that far from giving your closing and not having the final jury instructions. I would pull jury instructions when I could before opening. And then we would try to agree on our set of jury instructions. You use the model jury instructions for these things. Each state has model jury instructions. In Utah, they're called the Muji. It's the best name I've ever heard for model jury instructions. It's way more entertaining than like Calgic. So I'm very excited by the Muji's model Utah jury instructions. So you have model jury instructions, and then sometimes they need to be modified for the case. But that's your closing. The outline and the roadmap for your closing is the law that the jury is going to be told by the judge. So to not have that until the end makes you have to be very flexible. These lawyers have not always shown their flexibility. I missed yesterday afternoon because I had some family obligations that were just unavoidable. And then I, panic dyed my hair last night. Well, this morning. So yesterday, while I was listening back, it was very interesting seeing the recall of the plaintiff, Terry Sanderson, and seeing Owens show up with a whole ass cross-examination. Like this. That man worked well under a time limit. I was like, they should have put a fake time limit on him the entire time. Give the man a time limit for every witness, because it was concise, it was linear, and it was a powerful and I think damaging cross-examination of Terry Sanderson. I'm going to put up a poll if you think that cross-examination of Terry Sanderson changed your opinion. His daughters at the beginning of this case painted a picture of someone who was severely impaired in their life. His joy was gone. Listening to his daughters was heartbreaking. And then they go picture after picture after picture after picture. And you're like, this man is living better than everyone I know. We do not travel this much. We definitely don't have this much fun. And Owens absolutely nailed it. I was actually disappointed about this for one reason. Where was this Owens the rest of the trial? Where was the Owens on fire with the concise, rapid fire questioning? Where? Owens! So put that man on a clock always. He did much better with that time. The only thing I wouldn't have done, and this is just for anyone who has to go into trial practice later, I would never have told the plaintiff that I only had 30 minutes. Because if I am a witness that is opposed to an attorney or a side, if I don't like Owens and I am sitting on the stand as a witness and you're like, I only have 30 minutes, my questions are going to be, I don't know. Well, then I'm going to have to go to your deposition. Then we're going to have to do that. Every single time. I would burn their time to the ground. So, but I could be petty like that. And I could see a lot of witnesses being petty like that. So telling the witness that you have 30 minutes gives them room to mess with your timing by not answering. So I think I think it was interesting that he said that, but it also explained why he was just, but the photos were so telling. The photos And the travel that was painted, and I think the photos were a really powerful use. I'm bummed that we didn't hear Jenny's deposition, but the photos were such a powerful juxtaposition to his daughter's testimony. It made me question their testimony. Did it do that for you, chat? Did you find yourself questioning everything his daughter said? Because their perception of their father and what was shown in those photos are two very different things. And I wonder if that amount of travel, and I'm not saying if you get injured, you can't live your life, you have to. There are plenty of people who live with very difficult, unseen illnesses that still have to live and try to. But it wasn't in this amount of time. And remember, the accident was 2016, and then we had travel shut down from like 2020 through at least 2021, right, to be fair. So we can assume a lot of these trips were 2016 to the end of 2019, at least. In 3 years, that's a lot of travel. I mean, God bless. You're retired, you've got the money, go travel. But your life isn't what your daughters said it was, clearly. And lots of people, you will see if they have unseen illnesses, will say, yes, I did 2 days at this place, and then I needed to rest for these days. You're not seeing them go country to country to country to country to country quite like this, and ziplining and the rest of it, and hiking Machu Picchu or whatever. It wasn't as if he took one trip a year and was like, that's all I can handle. It was trip after trip after trip to get that much travel in. It was substantial. And then he made a comment about not letting someone get away with it. And I was like, oh, he's still mad. He talked again about being insulted. I think this is going to change the way the jury sees him. And I think it changes the way the juries see his testimony and see his daughter's testimony. It changed things a bit for me. I was like, huh. So when he started talking about someone needs to be held accountable, it felt very pointed at Gwyneth Paltrow being a celebrity for me. And then he made an odd reference to J.E. Island and kids on an island, and comparing letting someone get away with a ski crash to things I probably can't say on YouTube, but to horrible harm of children. It was wild. I'm starting to hear, oh, we had a little bit of a mic. I think the court will be coming back in just a minute. So it was wild to me. And I think that also says that he feels, even if he's not in it for just money, he's looking to hold her accountable because she's a celebrity. And that testimony, I think, might be the end for him. He got off pretty clean the first testimony, but Terry Sanderson painted by his daughters and Terry Sanderson traveling the world is a very different person. And then the island reference was like, oh, he thinks he's doing the altruistic thing. He thinks he is holding Hollywood accountable, and these celebrities just think they can do anything. Woo! That was interesting to see, wasn't it? And I wonder if that changes this case. I do. I mean, I wonder if that changes this case. So Terry Sanderson is a very interesting human. I hope that they really focus on that in closing. We're going to see the attorney split closing. We're going to see James do the damages part. And we're going to see Owens do the liability part. I hope it's smoother. Let's get to some of your questions. You've got questions. I've got questions. Let me know where you're coming in from now that we've got 30,000 folks here. Let me know where you're coming in from. I know some of you are saying the chat was fast. I appreciate it. We do have a conversation. The chat gets fast. There were days in Deppy Heard we had 200, 300,000 people in chat. So for me, this chat doesn't feel super wild. It feels manageable. So let me know what you're coming in from, what you're drinking. I love to see it, even if I can't pull up every single one while we answer questions, because law nerds are international, yo. All right, to get to some of our questions, and I've been grabbing these all morning. DHEC, my hair is very purpley today. I overtoned it. I've used everything. I've used Arctic Fox and Manic Panic, but last night Overtone is what I had time for, and that is what I did. So that's where we're at. We needed it. I've got some TV appearances today, and I was ready to come into closing argument refreshed. I feel ready to take on the day, and my hair still smells like mint. Girl, you missed out. You missed an out of left field reference. Maybe TS saw House and Habit was in the gallery and decided to shoot his shot. Maybe so. It was wild. I saw it when I was watching on the replay. And again, it's a very busy week as a parent this week with kid stuff. April and Jack said, Owen, is this you in Germany, France, Austria, Sumatra, Micronesia, ziplining, kayaking, basically? What was interesting is that he didn't, it seemed that Owen didn't know Marrakesh. I thought that was funny because there's like music about Marrakesh. I thought that was amusing, but that's also something I would do in trial and be like, oh, I can't with this word. Marilyn says, well, our Clark has a baby and has music on Spotify. He has an amazing voice. We talked a lot about James Egan having music on Spotify and Apple Music. Natalie, and I'm not surprised he has a kiddo. I think he's like 33, 34. Natalie said, I'd love to get your view or reaction of Dr. Ashkenazi during verdict watch, if that's possible. Sorry if I spelled her name wrong. I might have pronounced that wrong as well, but I can go back. I will take under advisement, depending on time, going back and watching some of the stuff I missed yesterday during our verdict watch. Wait, you said he's 37? Lies. Is it the mountain air? Is it the fresh mountain air? Is it the kind demeanor? Do curse words age you? Is that my problem? Can Gwyneth Paltrow sue Terry for defamation? It was an insinuation. I don't know if it was directed directly at her, and it is in court. So for a lot of reasons, no. Who else noticed that Owens improved as his illness got worse? He actually looked like he would puke a couple of times. Owens looks like he is very sick, but his cross yesterday was his best witness examination in this trial by far. Cindy said, is there some type of grand jury type thingy for civil trials that look at the evidence to see if it's justified to waste the court's time? Not a grand jury, but there's a process. There's a couple processes. There's a process to remove it at or the beginning of case, depending on the type of case, and motions to dismiss 12b6. So you can dismiss them for failure to state a claim right out the gate. Then you can get to summary judgment, which these did, and some things did get dismissed at summary judgment. Summary judgment dismisses things that cannot be won in front of a jury, and then only things that need to go to a jury go to the jury. So there is still court time that is dealt with, but there is accommodation for jury time and when jury time is appropriate. So those motions for summary judgment are the thing. So there is kind of a process, but it's in front of a judge. Betsy said, I think no GoPro, no one involved had one. Anyone else that might have had one and sent it would still have it or say they had sent it to him. I don't know, but Sanderson wasn't wearing one. Husband does Machu Picchu, said not easy at age 32. I can imagine it's not. Cheryl said, Emily, would you recall Ramon? What could he rebut? He hasn't been a great witness. Seems risky. It does seem risky. I think they should mount up and ride and do their arguments. I love when you pause so you can explain certain points. It makes things clear about what's currently going on in court. I learned so much. Thank you. LJ, you're welcome. I try to pause rarely, but when there are big things and I can't talk over it, it's not a quick thing. I really try to pause. That spoliation jury instruction is a legal big thing that might not otherwise seem like a big thing till it's explained. I'd love to see you in court. Emily, you would be an epic judge. I would not. Chad, I appreciate your confidence in me. I appreciate how much you like me. Judges have to remain calm, patient, and neutral. I am terrible at remaining calm and patient. Neutral, I've got nailed. I can remain neutral, especially if it is my job to remain neutral. But I cannot remain calm and my face gives me away. Owens would see me rolling his eyes at him. So my judicial temperament is not on point, though my Judge Judy temperament is absolutely on point. So I am here to like solve disputes of Bravo celebrities. I am here to solve disputes of influencers. I am here for televised court. Real court, I would want to give commentary and I can't. The judges are neutral and calm, ordered presence. It is just, I have so much more fun doing this. Because at the end of the night, I'd come home and I would have to give my husband a rundown of commentary of the entire day and he'd be exhausted. I need to do this. I am meant to be a broadcaster and I love it. Shouldn't they need evidence to bring in his life expectancy? Rachel, they should. They are arguing his life expectancy based on the Social Security tables. This is pretty common in civil cases that they bring it in some way. I'm not surprised they just have to argue it. So I think they should have brought it in, but I think they're swinging for the fences on that one. I don't think they're getting damages like that. Kim said, why would anyone be able to discuss a depo without it being entered into evidence? Kim, this is a great question. I think it plays against Paltrow's team to bring in Jenny's deposition and refer to it so much and not actually admit it into evidence. I think it is a very bad look. And I think it could potentially be damaging. In my experience, living sweetly, thank you for the kind super chat. In my experience, high net worth individuals' security includes mitigating potential bodily harm and lawsuits. To reduce the risk, front and back body cameras are often worn when the high-risk target environments such as skiing. I can't fathom why she was not protected. It seemed like she didn't have security on the mountain at all, just the ski instructors. And I can't fathom it either. But thank you for the insight. Please do a recorded commentary on yesterday's trial. Missed you so much. Watch with Runkle. Kept hearing you in my head. My trial life is missing now. I'm sorry. I know Runkle had you in good hands.
Are we ready to bring the jury in?
Bring the jury. I'm sorry if I scared your pets.
All right.
Gwyneth is waiting in court and is now walking into court. Gwyneth was waiting. Is Gwyneth wearing purple or is it navy blue? In this back, like mirrored room, there's a witness room, and she was waiting in the witness room. Hello from Singapore. It's 10 p.m. here, listening to your stream while I get ready for bed. I'm so tempted to stay up late to see this through live. It's going to be an interesting one, and I will consider doing some of what I missed yesterday during Verdict Watch when I have time. After closing, I have one quick obligation, and then I will come back and we'll talk about doing that. Donna Shepard, I'm tremendously sorry for your loss. That is a hard loss. And hopefully the distraction here today is helpful. Emily, after the defense pummeled Terry Sanderson yesterday with a list of vacations he took post-accident, humiliating to him, in my opinion, could Terry withdraw the entire case at this point? Lori, this is a fantastic question. No. This case is going to the jury. No one's going to settle at this point. He can't just really drop it at this point. This needs to be seen through to the jury, and he won't drop it. Nancy said, Emily, you should be a newscaster contributor. That's what I'm doing. That's what we do. I am a courtcaster. As the law nerds helpfully pointed out during our last trial. No, that's what I do. I just do it here on YouTube. Though later today I will be on some traditional networks, and I do regularly contribute to traditional networks. I like YouTube best. Shh, don't tell them. They know it. They know it. A, I get more than like 3 seconds to say something. And B, I get to curse. And C, well, no, actually, let me reorder that. A, live chat with the law nerds is my favorite. B, I have more than 3 minutes to say something. C, I get to
Ready for the
curse.
jury?
So I love court casting, not court gesturing. I mean, sometimes it feels that way. I do have a screaming goat and a fucking pickle. I mean, I have no business being #1 on live trending, but I do though, because it's your favorite place to watch live trials. Okay. If you keep thumbsing it up, we will keep being #1 on live trending. And then all the networks will be like, what is she doing over there? I'm like, get a goat.
And figure it out.
Thank you.
There's a guy sitting behind Gwyneth with a brown patterned shirt. He was sitting in the middle yesterday. He looks so familiar. Do you know who he is? Did you hear that Terry Sanderson compared GP? I heard the comparison. Oh, did I insult the pickle? I have a pickle too. It's just further away. I've got to grab it. I personally think Terry had no idea what happened to him and has relied on what Ramon told him. I think so. I think so too. I do think his bell was rung in this collision. Who caused it, right? Question, could it be 50-50 but still award both damages? Tree G, this is a great question. No. If it's 50-50, everyone walks away, no one gets damages. What's most important in closing arguments? Lucille. This is such a great question. Thank you for asking. I would love to tell you.
Counsel approach the bench.
Okay, as they approach, we're going to get audio cut anyway, so here we go.
Show you.
For me, I think what's most important is walking the jury clearly through what they need to decide and what facts go to them deciding it. Hey, it doesn't look like there's a green screen today. That's going to be much better. You need to help the jury understand the jury instructions make you decide this, and the facts that go to that are these things. A clear roadmap. It's like showing them the picture on the front of a puzzle box because a trial's got all these pieces and you have to put all the pieces together. But without seeing the picture on the front of the box, how do you know where the pieces go? You have to paint the picture of how they decide this case in your favor. And it needs to be clear. It needs to be clear. That is what it is. So that's what I think is most important. IMO, in my opinion, Ramon is the person at the greatest fault here. I personally believe he misled Sanderson from the beginning. Possible. Ramon, I was very interested to learn how much Ramon was chit-chatting with those who worked at the mountains about who was coming in. I was on So Bad It's Good with Ryan Bailey's podcast yesterday. That comes out today. And we were talking about this a little bit. When you work in an area where celebrities come in, if any of you have had this experience in the chat, please share your experience. But if you work in a location where celebrities come in or celebrities are around, I don't care if it's a restaurant that they frequent, a spa, Disneyland, the Sports Chalet in Marina Del Rey, or whatever it is. When celebrities come into your workplace, everybody knows. And so knowing that Ramon is such a frequent skier and is friends with quite a lot of the staff at different locations and the ski instructors and everybody, and they were talking about, oh, Gwyneth is staying here and this and that. There was the rumble, right, of where the celebrities are, and he knew. And they were gossiping about it. And I am no harm with the gossip, but he knew. And so he loved kind of the chisme of it, like, ooh, Gwyneth Paltrow's on the mountain today. And so I think when Terry was saying, oh, it was cool that we ran into her, I also wonder if that was Ramon's opinion. Like, oh my God, that's Gwyneth Paltrow. That's so cool. Like, I just wonder. I just have to wonder. And I wonder if the jury will wonder too. So, but you hear it, right? You hear it when you are somewhere where there is a celebrity, especially an A-list celebrity like this. Even when we had celebrities in the courthouse, you knew. Everyone knew. Even in the courtrooms that weren't dealing with it, everyone working in the courthouse knew the days in the courthouse that I worked at when there were celebrities in the courthouse. A, there's more of a security push. And B, there's just celebrities have this different air, especially when they're A-lists like that. And people know when they're there and want to see them in real life. So the days, particularly when Lindsay Lohan was in court, it was a big deal. It was a really big deal. So I think the jury is walking in. This trial has made me miss being a litigation defense paralegal, currently working in regulatory law now. Litigation is
Just be assured
a
that
whole
we've been
trip.
working very hard, and
I saw
think the rest of
that.
the morning, as a result, is going to go much smoother and much faster.
James will do part of it.
Thank you.
I bet this jury beats Murdaugh in jury's time. I think they'll be back quick. Can we have 1 minute of silence of James's patience?
Terry Sanderson calls Dr. Richard Boehme on rebuttal.
All right, Dr. Boehme on rebuttal.
See me, this is Judge Holmberg speaking. If you could please raise your right hand to be sworn in as a witness.
I will get to more questions.
I do not see you. I just see myself.
Do you swear that the testimony you are about to give in the case now before the court will be the truth, the whole truth, and nothing but the truth, so help you
There
God?
are other people on this Zoom call.
I do, reporter.
Once again, Dr. Boehme, if you could state your full name and spell it, please.
It's Richard Boehme, spelled B-O.
We'll hear the full set of instructions. We will. I always cover the jury instructions. We need them. No green screen. Much better with no green screen.
Boehme.
Oh dear.
Dr. Bain?
That's affirmed. I can hear you loud and clear.
This is a
Okay.
rough connection.
Thank you. I understand you're on vacation, and we appreciate your time. Dr. Bain,
Yes, I am.
Dr. Boehme, in trial testimony this week, the defendant's expert, Dr. Irving Scher, disputed your findings regarding the ski collision between Terry Sanderson and Gwyneth Paltrow on February 26, 2016. Have you had a chance to read his trial testimony?
Did you
Did you
answer?
say something?
Oh,
I
fuck.
have. I read his.
Okay.
Cue the can you hear me now of it all.
We're losing a few of the words there. Yes.
He brought his suit on vacation because he knew this was
Maybe, Dr.
likely.
Boehme, if you would start off your speech with something that will then kick in the audio.
He would have had to
so
have brought it. He would have
here-
known
so
that this was possible.
Here's my answer, something like
But I
that.
think he's
before
also at
you
a
answer.
wedding.
Roger that.
Okay. Dr. Scher suggests that you made an error in your calculations. How would you respond to his suggestion?
Here is my answer. Dr. Scher mischaracterized my analysis, which led to his analysis being misleading and incorrect.
I don't know if this is a good use of your time.
Okay.
I don't know if anybody remembers
Could you
the math after
ex-
Terry testifying yesterday.
Could
Do
you explain
you?
that in more detail? What
Do you
the
want to know more about
analysis
the
is
math, or
that,
do you want to know more about Sanderson? Let's put up a
you
poll.
want to correct?
Sure. Well, Dr. Scher first wrote up the impact force formulas, and he labeled one of them wrong and one of them correct. And both of them are wrong. And why? First of all, the equation F equals 1/2 md squared over d, where he substituted 1/2 AT squared or 1/2 AT, and
Oh my
then
God, you've
AT
killed my
in
entire
the
morning.
parentheses for velocity. You
He's
can't
at a
do that
disadvantage
without,
not being there
solving
live,
for time or
'cause I
t
can't visualize
first.
anything
Basically, what
he's
you
saying.
have from a mathematical
A over T over
standpoint,
B D
you
E.
have
What is
force
happening?
and time, which you don't know. So you have two unknowns.
My brain
in
immediately
one
went numb.
equation. So basically, the equation is unsolvable. So you have to first solve for time. And you guys have there. So if you go
that's
over
the
to
connection.
the first one where you have x equals x0 plus b0t plus 1/2 AT squared, you have to know the
R.I.P.
height
to my attention.
at which Mr. Sanderson fell to the ground.
Dr. Bain, could you share your screen and show us your calculation? Let's see if I
Chat, y'all are going to help me get through this. I think this is I don't think this is a good use of time
Here, and I'm trying to figure.
at all. Not even a little bit. And then
Pull it
you
up.
get the connection issues.
Over here.
Eesh.
Do you have it?
Not yet. We'll try to share it.
Oh boy. I think this is a very poor decision. I'm sure they think they need to do it. They think that expert did damage. They need
I'm going
to,
to show it to you.
they need to let Terry Sanderson explain all the vacations maybe, or just go to closing. This
right.
has been forgotten after Sanderson's testimony. The jury has moved on. This is not their focus any longer.
All right, I'm just had to unblur my screen, show it to you, but for my exhibit, 0 plus b half AT squared for time. So the height at which
I mean, this expert's trying, but it's tough.
Sanderson fell, which is x over t, and you can see that
Oh gosh.
less than a.
This is a
4,
nightmare for
6.
these attorneys right now.
Okay. The second, are you substitute time in for to determine the who are falling downward? We know it is because it's Earth.
Dr. Bain?
Everywhere on this property is
Shit, this is so bad. I feel bad for them at this
If
point.
you,
Dr.
I
Bain,
really
we're
do.
having trouble hearing you. If you could avoid the pauses, it might work better.
He's not pausing. He's not pausing. How do you not get that that's a connection issue? He's not
so you
pausing.
s- the one hat
How do you not understand that?
with it there.
Your
Now,
Honor, we're getting about a
been
fourth
working
of
out-
what he's saying, so this either needs to
Dr.
be
Bain?
fixed or stopped, is our motion.
Yeah, Your Honor, let me just try one last thing.
Okay.
Dr. Bain, could you stop your video and then just talk once you've shown the formulas? That way the signal might be clearer.
right IT guy, well,
Yikes. This is tough for them.
now,
Sorry, counsel, but it doesn't sound like it's going to work.
Nope. And that is the risk that you take.
Phone would work?
Yeah. Dr. Bain? Dr. Bain,
sir.
They're gonna court call him in.
can you hear me?
Yes, I
What a waste of their time.
Can we call you on your phone and, because we're having technical difficulties with the video and the.
He's having connection difficulties
Roger that.
at his vacation.
Should I call your cell number?
Don't put it on the record. Don't put it on the record. Don't put it on the record.
iPad. If that gives you,
Type it in the chat. Type it in the chat.
I don't see that. I've got other numbers for you. Can you?
They did not test the feed. That was me. I mean, I had tech issues this morning too. I get it. And I really feel badly for these attorneys. This is a very,
Call your cell number.
they clearly think this is important. They want to make sure that they're getting it. They should have used the court phone call system, the court call system. What an unfortunate thing for them. I really think this was not testimony that they needed. Like, what do you need this badly? I'm gonna start singing telephone. Oh gosh, now Lady Gaga's stuck in my head. It's fantastic. Okay, good job, Emily. Keep it together. Oh gosh, it is awkward, and the jury's got to be like, can we just not? Because they're not going to take anything away from this. What does this help? What does this help?
I'd like it removed from the jury's view until it's discussed.
We're in court. We're trying to talk to you on the phone during the trial.
Oh, Denise, welcome.
What number should I call?
Welcome, new law nerds. Go ahead and do the YouTube things, like, subscribe, hit the thumbs up if you want the technology to work. This is so terribly awkward for these attorneys. We're just going to sit here in the discomfort of it all. I'm uncomfortable. Like, this is making me uncomfortable. I think, and let's go see what the poll is saying. As a juror, with over 6,000 of you voting, look, there's 30,000 of you in the chat. You can vote at the top of chat if you're in the live chat. As a juror, what would you be more focused on at this point? The expert disagreements, Terry Sanderson's vacations. 79% of you said Terry Sanderson's vacations, and that's where they should have focused their rebuttal. They're trying to phone a friend. Oh, man, oh, man, oh, man. All right, well, I'm going to answer some questions. Hey, Owens, let them burn their time, big guy.
What their time is that they have left, so.
Was that a Roger that? Was Owens just like,
you want want me to FaceTime or what?
They're burning their
No,
time.
we're just going to do it by audio.
You're on the record now, sir.
No?
Yeah, just, you're live in court, the jury can hear you.
You're not a cat. You're here live.
And so do you have my equations up?
Can they give Gwyneth more than $1?
Are those
No.
equations?
They've made sure that they can't. It's a stipulated amount. IDK James, my last week with PD, then I retire. Whoop whoop. Can I watch?
There they are.
Can watch a full stream soon.
Okay,
We're
Dr.
always happy
Boehme?
to have you, James.
Sure.
We've got your equations up.
Okay.
We're gonna talk
so
about that,
do you have
Snazzy.
the sheet where it starts off with X equals X0 plus V0T and so on?
Yes.
Uh-huh.
Okay, perfect. All right, so as I was saying, should I continue, sir?
Yes, please.
Roger that. So
Roger, Roger.
in order to make the equation work, you have to solve for time, which is T.
Technology is your friend. I'm laughing because I'm so uncomfortable. Like, I feel so bad for these lawyers right now, but this is
Does it
just
make sense to
unbelievable.
take your next witness while
Yes.
someone is outside trying to
Yes. Yes.
establish?
This is our only witness.
Okay.
And, Your Honor, may we approach for one moment?
This is the only witness they're
Seeing a
calling.
Potential problem. I guess I could just bring it out while they're calling. I was prepared in cross to
James.
maybe show Dr. Boehme some documents or even draw some things. I wasn't sure whether I'd get into that, but depending on what I hear, I was going to do that. I know I don't have a
How
ton
can
of
he
time.
effectively cross-examine
Maybe I
him?
decide not to, but this obviously makes it so I can't do that, which is a problem. If I decided that I
both
wanted
parties
to.
are going to be hamstrung on this.
James, I think you're
So
right.
why don't we take it as it comes?
That was a good objection from James. Hey, how can I effectively cross-examine someone when I can't show them and they're there to refute our expert? I think this is a waste of time. Sometimes you get too close to the thing and you're like, no, we have to prove this point. This point has been lost. This point has been lost a long time
Look
ago.
at the phone to see if we're still connected, but in any event, once you get the time.
Oh, they know this is terrible.
0.466 seconds.
They know
that's
this
the
is
time
terrible.
It takes to free fall
This
from
whole-
a specific height, X, which
Yeah,
is
James is my
measured
favorite
on
attorney in this
Mr.
whole thing.
Sanderson, which is 3.5 feet.
James
to
was
his
right. It
ribs.
was a fair objection. It's a fair concern.
And
And he
then
did it
you
in a very
substitute
kind way, knowing that this is
P
mortifying for
into
everybody
the
involved.
equation velocity equals 1/2 AT squared. In this case, typically.
Yeah,
for
I don't give a shit about these
free fall,
equations anymore. Does anyone
equation
care about
is
this?
V equals AT.
Does this help any of you make a decision in the chat about who hit
Now,
who in this ski
The
collision?
reason
Does
I
this
put
help
the
any of us at
1/2
this
in
point?
there
We've all
with the
moved on.
asterisk, and keep
It's
in
like
mind,
Jack's
I've
trying to
been
get
on
back
this
with
case
Stassi for
2
the ninth
years,
time. We've
and
moved
up until
on.
this point, no one has ever asked me why that asterisk is there with the 1/2. Well, keep in mind that those equations.
Let's talk about the
are for
asterisk.
Free fall events. So
None of you
if
care
you're
anymore.
suspended in the air by X, 3.5 feet, and you
Wait,
are
who's
dropped
suspended
to
in the air?
ground, that's the velocity that you would get.
We're suspended in the
However,
air?
We know that Mr. Sanderson is not
This lawyer is like,
suspended in the
shit,
air
shit,
when he
shit.
collides or when he makes contact with Ms. Paltrow.
Yeah, we're all lost at
But
this
he's
point.
actually standing on his skis, so
I
he's
feel bad for
standing
Bueller.
upright.
I really do.
So
I feel
when he
really bad
falls
for
to the
him.
ground, it's not a free falling event. And you can appreciate that because when he falls over, the speed of his feet that hit the ground is 0, whereas the velocity of his head is
Is he
certainly
giving us the
much
physics
greater
explanation
than
for
the
ass over
velocity at
tea
his
kettle?
feet.
Is that what just happened?
So you have to know, which I took his measurement in the office, how high the point of interest is, which is his ribs, because that's what he fractured in the collision. So once you do that, you substitute the 1/2 AT squared asterisk
into the,
This
and that
is
turns
hard
out to be
testimony to pay attention to
2.29
anyway.
meters per second.
This jury is
And you
done.
put that into the impact formula.
This doesn't, I think, help them
And
determine who
then
did it.
You obtain.
At this point, who collided with who?
What the impact force is. So the equation should be written Fi.
This doctor's
impact
like,
force
do not
equals
tell me I am
1.5,
wrong.
In parentheses, V
I'm gonna
sub
need a
T
vacation after this.
asterisk, all squared, and then over D, the distance through which the energy is transferred from the
The
ground
audience is also like
to his ribs, which I measured in the office. So you have to know those quantities and understand that this is not a free falling event.
Every time he says
So
ribs,
that's
my
the-
brain goes like
that's
this.
the big difference here.
I
And
want my
once
baby
you
back, baby
have
back, baby
the
back.
2.29 meters per second and you substitute that in,
My brain
and
is
you
looking
just
for something
use
entertaining.
Mr. Sanderson's weight as the mass in that equation, you realize that there is not enough impact force to fracture those ribs. So there has to be a mitigating circumstance, i.e., something fell on
Well, you've
top
all
of
checked
him
out due to
in
physics.
addition to
Why
him
don't we see if we
falling
can get to
the
10,000
ground
likes?
to cause those ribs
That would be great.
to fracture.
We got 30,000
in an
people in here.
otherwise
Give some
healthy
memberships. It'll be
male.
great.
And so
Let's do
when
that.
you do the calculation,
I think that'd
the
be great.
object
I should have gifted memberships when we
typically
binged.
to
Maybe I'll
fracture
just do
ribs
both.
on the lateral side, which is where he fractured his ribs, takes about 4,000 newtons thereabouts, plus or minus.
I don't know if I'd
400
waste my time
newtons,
cross-examining this
4,000
guy.
newtons plus or minus 400 newtons to fracture those ribs. And when you work backwards, the mass required to do that indicates that the object that fell on Mr. Sanderson had to weigh at least 100
Oh, we're
pounds.
at 10,000 likes. All right,
So,
next goal,
Based
20.
on what I know
Let's give some
about,
memberships.
this case, any human that weighs greater than 100 pounds falling on Mr. Sanderson.
I'm going to do it. You don't have to do it. I'm going to do it. Thank you
his
to all
right
who've
side
done it.
fracturing those ribs would qualify as a traumatic event from an
Just give me a
impact force
second.
calculation standpoint. Now, so once you understand that, then you start to consider other possible
right, next goal, we're doing 50.
scenarios as to, is there any other way he could have fractured those ribs? The only other way he could have, if you consider him striking Miss Paltrow from behind, is that if he were to do that, he would have to generate a rotational force on him and Miss Paltrow, resulting in him falling on the ground and Miss Paltrow falling on top of him. Okay.
This brings us
Now,
back again
keep
to,
in
it wasn't
mind,
my
as I
ambition that
already
broke her leg,
calculated,
when
if
really
you
it
look
was
up
the
there,
angle at which
it
she hit the
took
ground.
less than half a
Physics!
second
Bring it on,
to
teaches
fall
us
to
so
the
much.
ground. And so for him to ski into Miss
I want
Paltrow
closing arguments to happen
and then
so bad
rotate 180
that I can't-
degrees to
I'm
the ground in
struggling to
less
pay
than
attention.
a half a second.
And then they put this
requires
giant
a
board up
rotation
there.
rate of greater than 400 degrees.
We can't see
per
what's on the
second.
board.
Now, Olympic divers, that is, when they do their
We have an Olympic swimmer in the
twisting and
chat most
turning
days.
on
Amy.
their competition dives don't generate any greater than 400 degrees per
What do you think of
second
physics?
on their dives. And then when you take into consideration Newton's first and third laws, you know, Miss Paltrow is
Newton's
certainly
like,
not,
"Can you please exclude me from the
twisting and turning if
conversation?"
she's struck from behind. So in order for her to rotate around with
Poor
Mr.
Bueller.
Sanderson, Mr. Sanderson
Projection
has
narrative.
to, according to Newton's first and third laws, grab her
The
and
audience
then
looks
take her to
bored.
the ground in a twisting fashion where she lands on top of him. Now, Olympic swimmers,
everyone's-
if they were to grab 100-pound weight or more and try to do those rotations, that's just not going to happen because
Swimmers
the
or
center of
divers?
gravity is too far away from
Divers.
the moment or the initial point for rotation.
So I played Division I
that's
college water
probably
polo.
not going to happen.
We had a diving
But
program.
let's hypothesize.
And they had all these really cool trampolines.
this
I was
did
never
in
allowed to
fact
play on them.
happen,
I probably
which
would
is
have hurt
highly
myself.
unlikely.
But I always wanted to do it. And the diving
If
coach would
Miss
be like,
Paltrow landed on
Water polo players
Sanderson,
don't spin. And
and
I was
he
like, I
landed
want
on
to.
his
That looks
back.
so fun. I want to play on the
That
trampoline. He's
means
like, it's not a
She
toy.
landed on his chest.
I picked the wrong sport.
And if that were to happen,
But I get very motion
the
sick,
ribs
so
would
spinning through
not
the air is probably
fracture
bad.
on the lateral aspect of his chest, as we see in the medical
Court TV is.
records. So
Are they
we
focusing
know,
on the dude
based on
sleeping?
that and the low probability of the rotational.
Court TV,
or
what are
the
you trying to
angular,
show us this morning?
velocity, that did not happen.
Are people sleeping
So
in
that
court?
only leaves one
Is Austin Habit
possible
wearing
scenario
sunglasses?
To satisfy
Is everyone asleep?
Newtonian physics.
You can't show us the jury, but you can show us the
Of
audience.
Mr. Sanderson's measurements and his medical records, and that means
That
that
dude's
he was
double
struck from
laptopping.
behind,
How do you double
went
laptop?
down onto his right
Oh, wait, no.
side, made
They're sitting
contact
close to
with
each
the
other.
ground with his elbow. The energy was transferred
Court TV's also
into
bored.
his ribs that fractured the ribs. Now, I would like to add that had the rib fracture
Court TV
not
is bored.
occurred, no one would be able to do this analysis, period. And that's all I got to say about it.
Thank you.
That's all I have to say about that. The Court TV operator is like, ugh, sigh.
Roger that.
Thank you, Court TV. Roger, Roger. Terry, congratulations.
Mr. Egan?
Thanks,
Good
Your
luck,
Honor.
Mr. Egan.
Am I to talk through this? Can you hear me, Dr. Boehme?
Barely. Is this Mr. Egan?
Yes, it's Mr. Egan.
Hi,
Mr.
good morning,
Egan.
Mr. Egan.
Good morning. Given the limitations we have, I'm not going to ask you some things I prepared. I can't show you a number of things. So this may take a second, less than we'd
This is
planned here. But let me
Causing some
start this
flexibility
way.
for Mr. Egan.
Dr.
You've got this,
Scher,
James.
You watched Dr. Scher's or read Dr. Scher's trial testimony, right?
Yes, I read it. I did not watch it.
And so you didn't see him writing up the equations on the board for the jury and discussing those for them?
I did get a text picture of his equations.
Okay. But did you get a text picture of the drawings that he drew for the jury?
Yes, I did.
And Dr. Scher has significant experience applying the principles of biomechanics to skiing, correct?
To my knowledge, he does. I don't know him personally or professionally.
And you do not have
like
that
we don't
kind of
know her.
experience, correct?
No, he works with
regards
divers.
To what, sir?
Applying the principles of biomechanics to skiing?
He works with divers.
I have not worked on skiing problems, if you will.
Okay.
But certainly,
And Dr. Scher has studied the physics of skiing and ski equipment, correct?
Good cross,
yeah,
James.
That's my understanding of primarily bindings with skis.
Yeah, I think it goes beyond that, but that's right. And you have not done such studies, correct?
No, not on ski bindings, sir.
And did you learn anything from Dr. Scher's testimony, given his experience with ski? Applying
making it work.
biomechanics to skiing and your lack of it? Did you learn anything
This is
from
going to be
him?
one of the hardest crosses he's ever done because
Did
of
I learn
the
anything?
flexibility
I mean,
required.
All I learned was that he assumed a free fall event, and it's not a free fall event. That's what I learned primarily, and that's why that basic assumption flaw is analysis.
I think it's a good reminder to everyone to just keep it simple.
But that's the only
myself
thing you
included.
learned.
I'm sorry, I didn't hear that. Mr.
And that's the only thing you learned.
Talking to the.
Yes, that was basically that's why I'm here today.
Bueller, don't tell our James what to do. We've adopted him. The law nerds have adopted
I hear
him.
you much. I hear you much better now. Absolutely, absolutely.
I'm just, leaning in front of the jury there.
No, I appreciate that. I can hear you really good now. 5 by 5.
Thanks, yeah, it's
Thanks, Peter.
a first, okay.
Hey,
So,
Peter with the
Do you know
assist.
anything about DIN settings? Those are the settings that dictate when ski
Teamwork. We love to
bindings
see it. What a Peter did a solid.
Do not
Okay,
know
so-
anything about that.
Peter, you've redeemed
I
yourself.
haven't skied in 40 years.
Right, okay, and you, also.
Good job,
that means
Peter.
You wouldn't know how much force it would have taken to release Mr. Sanderson's boots from his skis, correct?
I did not calculate
Not just that you didn't.
Snaps for Peter,
calculate it,
everybody.
You don't even know what force it would require.
We
Is that
also
right?
have loved the fits. They've been great.
Okay. Did you catch in Dr. Scher's testimony that he's read the
I like the
voluminous
tie. The tie's got like a
literature
subtle
on
check.
rib fractures and the biomechanics
Jacket looks like
of
it
rib
navy
fractures?
velvet. Peter's got the entire swag for the whole law firm. I will say, now that the gum is gone.
We did experiments in the lab in the military doing that, so.
Oh,
we're
okay,
very,
but my
very
question was
familiar
just,
with-
did you see?
Yeah, Peter's got all the
did you,
swag going today. I'm here for
see
it.
that part of or read that part of his testimony?
Oh, don't tell me there's
That's what
gum.
he, portrayed.
Chat, let me have my
Okay,
moment and
it
admire
sounds
the
like
jacket.
You dispute his reading of that literature?
No, I don't. I mean, he portrays that he knows a lot about biomechanics. I don't know. I've never been in a discussion with him to familiarize myself with his level of knowledge in that field.
Yeah, I like the tie. The subtle, like, black on black check.
You said earlier that
Digging it.
part of Dr. Scher's mistake in your mind is that he didn't acknowledge that he didn't solve for T. Is that what you said?
Well, that's one of them.
Okay, so
I'll
we're
solve
just
for
gonna
T.
Stay on that one for a second.
Can we get back to,
Did you
Objection, let the witness finish his answer, counsel.
it's cross-examination.
he answered my question. I was just going.
Mr. Boehme, did you have anything else that you needed to say to respond to the previous answer?
No, we can move on, Your Honor.
Okay, thanks, Dr. Boehme. I don't mean to interrupt. I'm just trying to be quick because I don't have much time.
I understand, Mr. Egan.
So did you?
I'm in a hurry too. I'm trying to make a luncheon.
I got it. Yeah, well, we appreciate you making time during your vacation. So, did you miss
No,
in Dr. Scher's testimony
doesn't
where
give a
he
fuck.
pointed to the pages in your equations where you solved for T and he just assumed
He
what
agreed
you
to come
had
in.
done?
Right. I mean, basically, he did an analysis or a critique, I might add, on my analysis. I don't see where he calculated it himself.
Right. He was just working off yours, just assuming what you had done and then doing his own calculations.
That is correct.
Okay. Thanks. That's all the questions I have. Thanks.
Thanks, James.
Thank you, Mr. Egan. Appreciate it.
This is the
Mr.
most
Bueller?
wild shit. Court is always unexpected. I just think this has got to be painful for these attorneys to try to do this.
Okay. So you did see the calculations from Dr. Scher.
Well, I saw what he did, which was critique my analysis, and that was it.
Well, he critiqued your math.
I don't know if he did any calculations based on what I saw in his testimony.
He critiqued your maths.
If you could quickly focus in on what is the error that you think Dr. Scher made?
Well, the biggest one, well, there's two of them. First of all, with the
He critiqued
rotational
me.
aspect, he did not consider Newton's first and third laws, so that's a violation of classical physics.
He
And then
forgot
second of all,
Newton.
he assumed a free fall, and we know that Mr. Sanderson did not free fall to the ground because he was standing up and he fell over, and it's the velocity when you hit the ground, when you fall over, is much less than a free fall. And we did those studies at the
The court's going to take a break after
Naval
this.
Research Laboratory because we were interested in that
sure.
research for our
I'm ready for
military
closing.
personnel. So knowing what, because
we're gonna
you
be
can
done by
appreciate
lunch.
standing up, when you fall over, the speed of your
10
feet
o'clock
is
there.
0, whereas the speed of your head is something else. And it's much different
not
in a
gonna be
free
done by
fall
lunch.
event.
Okay, thank you, that's all I have. Counsel?
Thank you. And am I allowed to leave? Over?
Am I done?
That's okay, Your Honor.
James Egan has one more question.
Oh, okay. Mr. Egan.
He's like, am I done? Over?
Thanks. Yep. Thank you, Lawrence.
10-4.
I'm back, Dr. Boehme.
That's great.
One
That's
last
great.
question. You were talking about free fall. Do you recall the testimony from Mr. Sanderson that he went airborne during the accident?
Because I'm free.
I don't recall that.
Okay, thank you.
Anything else?
Just one question. Is it possible for Terry Sanderson to have gone airborne when his skis were on the snow?
Are you contradicting your client, counsel?
No, that's not going to happen because the skier would have to go, that hit him from behind would have to be going in excess of 50 or 60 miles an hour, which I think is
So
highly unlikely.
Terry
unless
lied,
we're dealing
counsel.
with an Olympic downhill skier here.
You
Okay.
used your
That's all I
time
have.
to
Thank you,
use
Dr.
your
Boehme.
expert
No more
to
questions.
say.
Thank you. And Your Honor, am I excused?
Yes, you are.
Sir.
Thank you, Mr. Boehme.
Bueller, you used your
Thank you, Your Honor.
time
Thank you, guys.
to use your
Guys, have a
expert to
great
say
day
that your
out there in
client
Utah.
is not correct
Thank you.
and can't be correct, and that your client's version can't be correct.
That's all I
Sir,
have. No more witnesses, Your Honor.
So you rest your rebuttal case?
We rest our rebuttal case, yes.
Okay. So you've now received all of the evidence.
Your Honor, we were thinking of calling somebody, but we decided not to.
Okay.
I don't need your
So
exposition.
you've now received all of the
Sykes.
evidence. I just need to ask the lawyers a couple questions and then we'll proceed. So could you approach the bench, please?
Well, that was a delightful use of time. Not all experts can be in court when things finally go to trial. They hire these experts years before things go to trial. This expert had a family wedding. And so I hope the expert enjoys their wedding. It's a tough thing. Though I've had subpoenaed witnesses go on vacation and have to have had them come back to court. I'm like, well, we'll either have to issue a bench warrant for you or you're going to have to come back. You accepted your subpoena and then left anyway. And they're like, we didn't think it was really going to go to trial. I understand why you would think that, but yes, this is in trial. And yes, you need to be here. So I will see you in the morning. Let's get to a few questions where they're at sidebar. Olga said, I know you get this a lot, but I think you're an inspiration and truly love your channel. Thank you. The law nerds inspire me. Your confidence has inspired me to not be afraid to ask questions and advocate for myself. Yay! Ask questions and advocate for yourself. The law nerds have proven so much how much we learn from just talking with each other with kindness. We have great conversations. We can have fun and we can still have great conversations and we can have large conversations with, tens and tens of thousands of people. Pink said, Emily, I would love to see your reactions to the two neuropsychologists yesterday. To me, the first was Dr. Curry 2.0, jaw-dropping revelations. Sykes tried to discredit them, but they were amazing. I might pull up some other testimony while we are on jury watch. We'll just take a vote as a community and decide what we want to look at while we are on jury watch. So that. What about Jenny's depo not reading it into evidence? Appeal chances. If the jury 50-50s this, nobody's appealing. If the jury finds liability against Sanderson for Paltrow, if he chooses to spend the money to appeal, which I don't think would help him, then yes, that will come up. They used it quite a lot without ever bringing it into evidence, which didn't sit great with me. If you know you're not going to bring it in, don't use it. It needs to be in evidence. I know you can use it with your experts, but it felt like he was trying to really backdoor it through not bringing in the evidence and not bringing in the downsides and only bringing in the upsides, which I don't love. Question, did Sanderson wear a GoPro on his subsequent travels after the accident? I don't know. Nobody ever asked.
Okay, members of the jury, you have been handed the closing
Jury
jury
instructions.
There's one more document.
They get to
you'll
read
before
along? I love it when
parties
courts do
argue,
that.
but we're
I
gonna-
need to read
we're gonna,
along.
Give that to you right after the break. I'm going to read through these and then we'll take a short break.
Jury instructions.
So these are jury instructions 18 and 22 through 42. If you turn to page 2, and you can make.
It is 11:07 my
notes on these if you'd
time.
like.
It is
So
10:07
page 2 is
local
jury
time for the
instruction
court.
number 18, which has already been read to you, most of it, as modified, because I did modify it during the trial, and I read it to you during the trial as it stated right here. So now you've got the complete 18, the modified 18. Turning then to jury instruction 22.
Oh, let me
which
turn
was
this up.
also read to you during the trial.
My
on
bad.
Limited purpose evidence. Turning then to 23, a
that's
closing roadmap. Members of the jury,
We
you
are
have now
gathered here
received
today
all of the evidence. Three things remain to
celebrate
be
the
done.
conclusion of this
First,
case.
I will give you additional instructions that you will follow in deciding this case. Second, the lawyers will give their closing arguments. The plaintiff will go first, then the defendant, then the plaintiff may give a rebuttal. Finally, you will go to the jury room to decide the case. In the jury room, you will have two main duties as jurors.
Duty to
First, you will
deliberate.
decide from the evidence what the facts are. You may draw all reasonable inferences from that evidence. Second, you will take the law I give you in the instructions, apply it to the facts, and reach a verdict. Instruction 24, closing arguments. When the lawyers give their closing arguments, keep in mind that they are advocating their views of the case.
Closing
What they
arguments are
say
not
during their
evidence.
closing arguments is not evidence. If the lawyers say anything about the evidence that conflicts with what you remember, you are to rely on your memory of the evidence.
Just ignore them,
If
boo.
they say anything about the law that conflicts with these instructions, you are to rely on these instructions. Counsel, could you remove that easel? It's kind of blocking my view of the jury. Number 25.
A fair point.
You can just shove it over next to the screen.
The judge is like,
Legal
shove it
rulings.
anywhere,
During the
Your
trial, I
Honor.
have made certain
Not with this
legal-
audience. You don't want to
or
offer
certain
that.
rulings. I made those rulings based on the law and not because I favor one side or the other. However, if I sustained an objection, if I did not accept evidence offered by one side or the other, or if I ordered that certain testimony be stricken, then you must not consider those things in reaching your verdict. 26, fault defined. Your goal as jurors is to decide whether Terry Sanderson was harmed, and if so, whether anyone is at fault for that harm. You must also decide whether Gwyneth Paltrow was harmed, and if so, whether anyone is at fault for that harm. If you decide that more than one person is at fault, you must then allocate fault among them. Fault means any wrongful act or failure to act. The wrongful act or failure to act alleged in this case is negligence. Your answers to the questions on the verdict form will determine whether anyone is at fault. We will review the verdict form in a few minutes after your break. Instruction 27, negligence defined. You must decide whether Gwyneth Paltrow or Terry Sanderson was negligent, or whether they were both negligent. Negligence means that a person did not use reasonable care. We all have a duty to use reasonable care to avoid injuring others. Reasonable care is simply what a reasonably careful person would do in a similar situation. A person may be negligent in acting or in failing to act. The amount of care that is reasonable depends on the situation. Ordinary circumstances do not require extraordinary caution. But some situations require more care because a reasonably careful person would understand that more danger is involved.
Skiing.
To establish
Like
negligence,
skiing.
Terry Sanderson has the burden of proving that 1, Gwyneth Paltrow was negligent, and 2, this negligence was a cause of Terry Sanders' harm. If you find that Gwyneth Paltrow was negligent, then you must determine whether that negligence was a cause of Terry Sanderson's harm and whether Terry Sanderson sustained damages. Gwyneth Paltrow claims that Terry Sanderson was negligent in causing his own harm, and that should read, and in causing her harm. To establish Terry Sanderson's negligence, Gwyneth Paltrow has the burden of proving.
He's making a note on the jury instructions. Some of you have had some stream issues. Just refresh your feed, whatever device you're
Gwyneth
on.
Paltrow has the burden of proving that 1, Terry Sanderson was negligent, and 2, that this negligence was a cause of Terry Sanders' harm and her own harm. I'll send in a corrected instruction 27. If you find that Terry Sanderson was negligent, then you must determine whether his negligence was a cause of his own harm and her own and Ms. Paltrow's harm and whether Paltrow sustained damages. Instruction 28, allocation of fault. If you decide that more than one person is at fault, you must decide each person's percentage of fault that caused the harm you determine was suffered in this case. This allocation must total 100%. Mr. Sanderson's
This is your
total recovery
the
will be
apportionment of
reduced
damage.
by the percentage of fault that you attribute to him. If you decide that this percentage is 50% or greater, he will recover nothing. The same
If
is
he's
true of Ms.
50% at
Paltrow's
fault,
recovery.
he gets nothing.
When you answer the question on damages, do not reduce the award by Mr. Sanderson's or Ms. Paltrow's percentages. I will calculate that later. Instruction 29, violation of a safety law. Violation of a safety law is evidence of negligence. Terry Sanderson claims that Gwyneth Paltrow violated Parts A and B of the following safety law, and Gwyneth Paltrow claims that Terry Sanderson violated Part A of the following safety law. This is Summit County Ordinance, Section 523, reckless skiing. A, reckless skiing prohibited. No person shall ski in a reckless or negligent manner so as to endanger the life, limb, or property of any person. B, skier's duty to injured party in the event of collision. Any skier involved in a collision resulting in injury to any person shall immediately stop at the scene of such collision and render to such person injured in such collision reasonable assistance, including the caring or the making of arrangements for the caring of such person by a physician, surgeon, or hospital for medical or surgical treatment, if it is apparent that such treatment is necessary, or if such caring is requested by the injured party. If you decide that Mr. Sanderson and/or Ms. Paltrow violated the safety law, you may consider the violation as evidence of negligence. If you decide that Mr. Sanderson and/or Ms. Paltrow did not violate the safety law, you must disregard the safety law, and decide
This happens
whether they
all
acted
the
with
time when the
reasonable
judge is
care
reading them
under
and
the
finds
circumstances.
little quirks within the jury instruction that they're giving.
Jury
especially
instruction
when
30.
they just finalize
I've
them.
already determined that Gwyneth Paltrow did not leave the scene of the accident without giving her contact
That's a good
information.
instruction for them.
Jury instruction 31, spoliation.
Ooh,
Ms. Paltrow has presented evidence that a GoPro video of the ski collision may have existed. Sanderson asserts that the GoPro video of the ski collision never existed. If you find that, 1, a GoPro video of the collision likely existed,
they get to make the assumption.
and 2, that any
inference.
such GoPro video was in the possession or control of Sanderson, and 3, that the plaintiff intentionally or negligently disposed of or lost the GoPro video of the collision, or otherwise failed to offer a reasonable excuse for failing to preserve the GoPro video of the collision before a defendant had an opportunity to review and evaluate it. Then you may, but are not required to, conclude that the evidence would have been unfavorable to
That's
Sanderson.
a big instruction. They are
Instruction
allowed to
32,
conclude it's
introduction to
unfavorable.
tort damages.
That it would have shown something
economic
opposite of what
and
he said.
non-economic damages introduced.
That's a big
I will now
instruction for
instruct you about
Paltrow.
damages. My instructions are given as a guide for calculating what damages should be if you find that either Terry Sanderson or Gwyneth Paltrow is entitled to them. However, if you decide no one is entitled to recover damages, then you must disregard these instructions. If you decide that Ms. Paltrow's fault caused Mr. Sanderson's harm, you must decide how much money will fairly and compensate him for that harm. If you decide that Mr. Sanderson's fault caused Ms. Paltrow's harm, then you may award Ms. Paltrow $1, which is the maximum amount she seeks. There are two kinds of damages, economic and non-economic. I would explain the difference between them. 33, proof of damages. To be entitled to damages, a party must prove 2 points. First, that
Rob, I
damages
agree with
occurred.
you. That instruction
There must be a reasonable
shifts this
probability,
case,
not
I
just
think.
speculation, that a
Oh, I'm going to get to questions after this.
party
That instruction can shift this case.
suffered damages from the other party's fault. Second, the amount of damages. The level of evidence required to prove the amount of damages is not as high as what is required to prove the occurrence of damages. There must still be evidence, not just speculation, that gives a reasonable estimate of the amount of damages, but the law does not require a mathematical certainty. In other words, if a party has proved that they have been damaged and they have established a reasonable estimate of those damages, the other party may not escape liability because of some uncertainty in the amount of damages. 34, economic damages defined. Economic damages are the amount of money that will fairly and adequately compensate a party for measurable losses of money or property caused by another party's fault. Mr. Sanderson is not claiming any economic damages. Therefore, you should not award Mr. Sanderson any economic damages. Ms. Paltrow is seeking $1 in economic damages. 35, non-economic damages defined. Mr. Sanderson is
I'm gonna
seeking
explain this at the break.
non-economic damages. Non-economic
This is what
damages
the
are the
jury needs
amount
to
of money
pay.
that will fairly and adequately compensate Mr. Sanderson for losses other than economic losses. Non-economic damages are not capable of being exactly measured, and there is no fixed rule, standard, or formula for them. Non-economic damage may still be awarded even though they may be difficult to compute. It is your duty to make this determination with calm and reasonable judgment. The law does not require the testimony of any witness to establish the amount of non-economic damages. In awarding non-economic damages, among the things that you may consider are 1, the nature and extent of injuries, 2, the pain and suffering, both mental and physical, 3, the extent to which Mr. Sanderson has been prevented from pursuing his ordinary affairs, 4, the degree and character of any disfigurement, 5, the extent to which Mr. Sanderson has been limited in the enjoyment of life, and 6, whether the consequences of these injuries are likely to continue and for how long. While you may not award damages based on speculation, the law requires only that the evidence provide a reasonable basis for assessing the damages, but does not require a mathematical certainty. I will now instruct you on particular items of economic and non-economic damages presented in this case. Instruction 36, pre-existing
Non-economic
conditions.
damages are your pain, suffering,
Terry Sanderson
all that.
is alleged to have had physical, emotional, or mental conditions before the time of the ski collision. He is not entitled to recover damages for those conditions. However, he is entitled to recover damages for any aggravation of the conditions caused by Gwyneth Paltrow's fault, even if those conditions made him more vulnerable to physical or emotional harm than the average person. This is true even if another person may not have suffered any harm from the event at all. Gwyneth Paltrow has the burden to prove what portion of the alleged
his
harm
enjoyment of life
is the
limited?
result of pre-existing conditions.
Or is he living a better
If
life
you are
than most
unable
of
to
us?
make such an apportionment, then you must conclude that all damages, if any, you find were suffered by Mr. Sanderson were caused by Ms. Paltrow. 37, mitigation of damages. Each party had a duty to exercise reasonable diligence and ordinary care to minimize the damages caused by the other's fault. Any damages award should not include those that could have been avoided by taking reasonable steps. Terry Sanderson has the burden to prove that Gwyneth Paltrow could have minimized her damages but failed to do so. Gwyneth Paltrow has the burden to prove that Terry Sanderson could have minimized his damages but failed to do so. If a party made reasonable efforts to minimize damages, then your award to that party should include the amounts that he or she reasonably incurred to minimize them.
Your Honor, my memory is that jury instruction 38 was stricken by both parties yesterday.
Okay.
Is that your memory?
It wasn't.
They already
It was
read
not.
It was
spoliation.
not stricken.
I apologize. Please proceed.
Okay, 38, collateral source payments.
Oh, boy.
You shall award damages in an amount that fully compensates Terry Sanderson. Do not speculate on or consider
I will be
any
right
other
back from
possible
Gwyneth.
sources of benefit Terry Sanderson may have received. After you have received your verdict, I will make whatever adjustments may be appropriate. 39, four-person selection and duties and jury deliberations. Among the first things you should do when you go to the jury room to deliberate is to appoint someone to serve as the jury foreperson. The foreperson should not dominate the jury's discussion, but rather should facilitate the discussion of the evidence and make sure that all members of the jury get the chance to speak. The foreperson's opinions should be given the same weight as those of other members of the jury. Once the jury has reached a verdict, the foreperson is responsible for filling out and signing the verdict form on behalf of the entire jury. In the jury room, discuss the evidence and speak your minds with each other. Open discussion should help you reach an agreement on a verdict. Listen carefully and respectfully to each other's views and keep an open mind about what others have to say. I recommend that you not commit yourself to a particular verdict before discussing all the evidence. Try to reach an
I like the way they
agreement,
word these
but only if you
instructions.
can do so honestly and in good conscience.
They don't have to
If
be
there is a
unanimous.
difference of opinion about the evidence or the verdict, do not hesitate to change your mind if you become convinced that your position is wrong. On the other hand, do not give up your honestly held views about the evidence simply to agree on a verdict, to give in to pressure from other jurors, or just to get the case over with. In the end, your vote must be your own.
Just to get the case over with.
In reaching your verdict, you
is
may
always
not
a
use methods
concern.
of chance, such as drawing straws or flipping a coin. The verdict must reflect your individual, careful, and conscientious judgment. Instruction 40, do not resort to chance. When you deliberate, do not flip a coin, draw straws, choose opinions at random, or use other methods of chance.
No
Instead,
chance.
you must weigh the evidence carefully and come to a decision that is supported by the evidence. If you decide that a party is entitled to
No rock,
recover
paper, scissors,
damages,
chat.
you must then agree upon the amount of money to award that party. Each of you should state your own independent judgment on what the amount should be. You must thoughtfully consider the amount suggested, evaluate them according to these instructions and the evidence,
Yeah, this is
and reach an
important
agreement
stuff for
on the amount.
gallery and the jury.
You must
This is
not agree
way
in
more
advance
interesting than
to
math.
average the
me.
estimates. Instruction 41, agreement on special verdict.
A bad Zoom call is a hard thing.
After the break, I'm going to give you a form called the special verdict that contains several questions and instructions. You must answer the questions based on the instructions and the evidence that you have seen and heard during this trial. Because this is not a criminal case, your verdict does not have to be unanimous.
Yep.
At least 6 jurors must agree on the answer to each question, but they do not have to be the same 6 jurors on each question. As soon as 6 or more of you agree on the answer to all of the required questions, the foreperson should sign and date the verdict form and tell the bailiff that you have finished. The bailiff will escort you back to this courtroom. You should bring the completed special verdict form with you. And then jury instruction 42, I'll read to you at the end of the trial. So that completes these instructions. I wonder if you could write your names on the top
Oh,
of that.
No, Rob, I think they come back. I think it's possible they come back
I did make some
tonight.
changes to a few of the instructions as we went along. And
I think it's very
I'll have the
possible they come
bailiff
back tonight.
insert the new and take out the old, if you could do that, the new instructions, before they're given back to you. Yes?
The juror had
Pardon
a
me?
question.
Names and numbers, or just names?
On the verdict form, the foreperson will write their number and their name when they sign it. And there's only be one signature on it, which would be the foreperson.
They're
And when
ready.
I select the two jurors that will unfortunately have to leave us before deliberations.
Two alternates.
I'll just tell you your juror number. I won't say your name, and I'll give you further instructions about those two individuals.
They're ready.
So I'll do that in a few minutes after all the arguments are completed.
Yeah, jury watch might be short on this one.
At this time, we'll take a recess, and thank you.
All rise for the jury.
I'm going to wait to see how long the judge is recessing for before starting closing, because they are supposed to start the lunch break in just about a half an hour. So I'm going to wait and see what the court tells the lawyers about when they're coming back, because this is going to go till after lunch. I still think this jury could come back with a verdict today. We're going to be here on verdict watch quite actively, because I don't think this will be a long verdict. Excuse me, the court is talking. Can we have
Defendants?
Thank you.
No, I would like to get a hard copy of the special verdict form, just so I can read it one more time.
We've got some issues with the verdict form. I wonder if you could come into chambers and we could kind of go through that.
Thank you. And then can Peter Jensen have the defense binder index? And certainly one of the plaintiff's lawyers is welcome to be present to do the final
wanna go
swap out
through-
with the new index. He's
Sure.
not adding one thing. He's deducting.
And is that something we need to do before closings?
No.
No. He could do it at the moment. They're discharged to deliberate.
Normally, sure. Well, if you want to get those into evidence, I suggest you try as soon as possible.
Well, I do move to admit the new index, all those documents on the new index, which they have. Any objection?
Are there any objections to the index of defendants?
They're
trial
redoing
exhibits?
the trial exhibit
All
book
of the
that's going to go
exhibits
back to the
received.
jury
So
and
it's
taking
on
out
the
things
new
they didn't
index, and now
admit.
he just needs to make the changes,
appropriate.
including blacking out Mr. Sanderson's
Contact information.
contact information.
Social Security, birth date.
Address is the one that's
Address.
most common.
Okay. All right, so take a quick break and then have the bailiff bring you back to my chambers on the special verdict form.
How long are you taking the break for, Your Honor? The audience at home would like to know. Sir, how long are we on break for? I'm going to turn the volume down so I don't jump out of my skin when they come back on the record. I'm assuming 10 minutes, but when they go back in chambers, it could be a little more. So I'm going to answer as many questions as I can. So as we get into closing argument, we will very quickly be dumped into verdict watch. So not only, well, let's talk about that real quick. Our fastest and most reliable way to let you know when I am going live, if I even have a chance to break before they come back with a verdict, is at lawnerdalert.com. It is our email list. We will keep you in the loop, let you know when there's new podcasts, new live streams. But when things change quickly and I populate a stream, I do not rely on YouTube to let you know that I have populated a new stream. It does not always do it well. If I am moving quickly, I will not always hit all of the social medias. I try very hard, but I don't always. So with all of that, sign up at lawnerdalert.com if you want to be kept in the loop for Verdict Watch. The second we populate a stream, I will send it out. The second I know something, I will send it out. And I will also keep you in the loop where I'm going to be. I will be on Extra a little bit later today. And then I believe I will be on the Lorraine Show again. I just don't know which day yet over in the UK. So there's a lot coming up. This is the best place for me to keep you in the loop. For the members, I will always hit the member spaces. So if you are a member here and a member on Patreon, I will hit the member spaces to make sure you are in the loop. YouTube's notifications can be difficult. So with that, lawnerdalert.com, the mods will put a link in the chat so you can click it. There's also a link in the description down below. Thank you for staying in the loop with me. Then you won't miss trial coverage. You won't miss next trial coverage, and you won't miss my spontaneous, like, oh, now we're going live. Okay, we're going live right now. It happens. It happens. We aren't going to fax you. There's no, we're not, what did Ryan call them in the office? A woof? Were they a woof where it faxed and called and no woofing? We're not paging you. But we will law nerd alert you. So with all of that, that's what we are doing. So Octo, we're not going to fax. App alerts first. So with all of that, let's get to your questions while we wait for court to come back for the day. Because they should be back in about 10 minutes for closing. I will have to take a brief break when we go to lunch, but I will be back shortly. So if I do have to take a break, I will let you know how long that will be for. And we'll take a human comfort break together. I'll go do my interview with Extra, and then I'll be back to answer more questions because I don't think they're going to finish. I don't think they're going to finish closing arguments. They don't have time to finish. So we're going to get the beginning of the plaintiff's closing right now. Plaintiff has to apportion time. Let's just talk about what's coming next. As we get into closing arguments, the jury has already heard the jury instructions. Plaintiff will get to argue, then defense, then plaintiff. What I like that Judge A did in Depp v. Heard was because there were counterclaims, both sides got a rebuttal. We don't get that here, and we're not going to get that here. So we're not going to have a rebuttal on both sides. Plaintiff will go, defense will go, plaintiff will get a rebuttal. They only get the same amount of time, so they have to apportion their time well. It seems that everybody's going to have just about an hour, and that's really it. It's going to have just about an hour for closing. If they have a little bit of time left over on their 20 hours of trial time each, they can use that towards their closing. So closings are timed based on how much trial time they have left. I don't know if we'll hear that from the judge, but we might. Brittany, can I please get a birthday shout out?
Yes, Brittany, you can. You can get a birthday pickle. For all of the law nerds in the chat, if it is your birthday, go shorty. It's your birthday. We're going to party like it's your birthday. We're going to drink Bacardi like it's your birthday. And we don't give a fuck because it's your birthday. Happy birthday, Brittany.
I hope that is everything you imagined when you sent that super chat, and perhaps more. Terry said, Emily, why did they call two daughters and not Jenny? Love doing this court thing with you. I love doing this court thing with all of you too. I don't know why they didn't call Jenny. I think they should have, at least by deposition. But here's the thing. What we heard at the very beginning of this is that Jenny was improperly subpoenaed and could not be compelled to come to court. So they did not properly subpoena Jenny, and Jenny did not want to come. So Jenny did not come. Why they didn't read in the deposition, I don't know. I think they could have limited some of their experts. I think Jenny's deposition was important. It's left a lingering question in my mind, and it makes me wonder. Let me know what it makes you wonder. Do you think, oh, they must have run out of time? Or do you think, oh, it might not have been that good for them? They picked out the parts that were best for them, and there's more there that we don't know about. It makes me a little sus. So Sharon said, I'm currently stuck at home waiting for knee surgery. I'm so glad I found your channel. Sharon, been there, done that. I played a lot of video games. Sure wish I had been on YouTube. I played a lot of video games. There was one about zombies at a mall. I don't remember the name of it. There was a lot of Xbox during my knee surgery recovery. Amber, I now feel like the daughters tried to manipulate our emotions. I don't know if the daughters were trying to manipulate things. I just wonder if their perception of their father is colored by their relationship, like filtered through their relationship. And yes, Dead Rising. Thank you, chat. And they want to honor what he's telling them, and they're not questioning that much more. So he's telling them how impaired his life is, and they're believing him and kind of tilting it through the lens of their experience with him. But they didn't account for so much travel. It was just such a disconnect. So that. Jonathan said, could a court jury decide not to award attorney's fees if the plaintiff is determined to be of diminished capacity? This is a broader hypothetical, and law is very fact and trial specific. It's what I love about the facts of a case. Cases are very fact specific. So in this case, Jonathan, I'm just going to answer in this case. In this case, to get jury fees, they argued about this earlier today. They have to know that this case was brought maliciously, essentially. So that's one of the things they argued earlier today. Let me see when. So did I make a note of it? The bad faith argument was at the very beginning of today. So for jury fees to be awarded, they have to find by evidence that Terry Sanderson brought this case in bad faith. But they're going to be allowed to bring more evidence. If the jury finds for Paltrow, we're not done, because they will be allowed to bring evidence to show Sanderson brought this in bad faith and argue that to the judge at another hearing. So even if there is a verdict and it is for Paltrow, we might not be done. Verdict options. You heard the judge talk a lot about damages, and some of that might have been a bit confusing. If Sanderson is found 50-50 at fault, so 50-50 liable with Paltrow, nobody recovers. If Sanderson is 60% at fault, 70% at fault, 80% at fault, 90% at fault, Paltrow recovers. Same with Paltrow. If Paltrow is over 50% at fault, Sanderson recovers. So when the jury comes back, what we are looking for is not a liable, not liable, guilty, innocent, or guilty, not guilty. What we're looking for is who is more than 50% liable. Or is it 50-50 and the jury's like, y'all ran into each other on a ski slope. Be gone. But with that spoliation and with Sanderson presenting in court so differently than his daughters presented him to be, this jury could find him liable. My order of not surprised. And I generally don't tell you what I think a jury's going to do. It's within their provenance. Here's my level of not surprised. 50-50, not surprised. Finding for Gwyneth Paltrow, not surprised. Finding for Sanderson, more surprised. So in my chart of surprised, 50, Paltrow, Sanderson. That's where I think we're at. That for me. This jury could find either way. They could believe that Deer Valley's covering for Paltrow. I think if they find for Paltrow, the thing that did Terry Sanderson in is all of the travel. I think he overstated how impacted he was. And I don't think he was not impacted at all. He was impacted some, but it seems to have been overstated, and that is a problem. He clearly had broken ribs. He clearly had a head injury. For me, some kind of head injury. It could have exasperated what he had going on. But the life he presented through testimony and the life we saw through cross-examination are two very different things. And that matters. All right, let's keep going to questions. I'm watching closing while drinking my coffee, Nespresso Irish Cream from my Utah coffee mug so that I'm on theme. We love a theme, Shauna. Cheers to you and all the law nerds in the chat. I am still drinking coffee as well. Paul Printed Heart said, I believe Terry is a master manipulator and played up his brain injury to his girls, and they believed it. Do you think Ramon is part of the problem? I think Terry's memory is impacted by Ramon's retelling of events. And I think Terry believes that that is Terry's memory, even though I believe that memory comes from Ramon's version of events. The daughter's statements and the defense photos put his credibility in question. I think it does. Unfortunately, it looks like he was living it up and hoping to cash grab from a celebrity. This is something we didn't talk about, chat. I want to know your thoughts. I want to know your thoughts on this too. Does the amount of travel make it look to you like he is trying to fund his travel fund? Like, this is a lot of travel. And I get that I have kids in school and I can't travel this much and getting on planes makes me exhausted. But does this level of travel make you wonder where his money's going? Like, it's not just he's driving around the US on a road trip. I love a road trip. This is lots of exotic international travel. All of the chat is like, yup. And I wonder how much that part of it hurt him. Not that he was capable of traveling, but the volume of travel and the locations of travel. Like, he's in Marrakesh and he's in Norway and he's just everywhere. Is this I'm going to travel for the next 10 years of my life on Gwyneth Paltrow's dime? Does it start to look that way to this jury? Christina said, every time you decipher Neil Patrick Harris, I smile because in med school, MPH symptoms, mnemonic is wacky, wobbly, wet. That needs to be the name of an album, Wacky, Wobbly, Wet, but it's a good mnemonic. I associate MPH equals wacky, LOL. This case counts as studying, right? Yes, this case counts as studying. This case is wacky, wobbly, and wet. And Neil Patrick Harris has entered the chat every single day. I love that so much. Thank you for sharing that. That's a delight. Maybe GoPro is just the aftermath. We don't know what it is, but the jury gets to count it against Sanderson. Let's keep going. Emily, as a judge, stop facking around, counsel. Yeah. Counsel, I will yeet you from this courtroom if you do not get on point. My ADHD cannot handle these types of arguments. I need you to be more linear. Counsel. Now. Yeah, that exactly. VR said hello from Scotland. Firstly, my best friend Sam and I adore you. Hello, best friend Sam. Secondly, have you thought about doing highlight videos from trials? Not a ton, but I do shorter versions on my Quick Bits channel and my Quick Bits podcast. So those are kind of just the highlights, but they're not like clipped highlight reels. This is my sweet spot, not clipped highlight reels. So I maybe later, but let's see. But I will no, I'll just send you to Quick Bits. That's really where it goes. I saw the comment that someone in Runkle's chat said they are a flight attendant and Terry travels more than them. My mom's a reflyered. That's exactly what retired flight attendants are now called, reflyered. My mother is a reflyered flight attendant. And in her retirement, even with the flight benefits she has from retirement, does not travel nearly this much. And my mother really enjoys traveling, but it takes a toll on her. And Mother, I would never tell your age, but she is in the Sanderson group. I would not be surprised if they graduated high school within a few years of one another. My mother gets the younger benefit of that. Mom, you're 50. Everybody knows it. It's fine. Brianna said, as a 22-year-old with asthma and prior spinal fusion who has dived often, scuba diving 4 times in a week is insane, even for me, let alone older man with brain issues. He was trying to say those were all in 1 week. The defense was trying to say those were 4 separate occasions. And he's like, oh, it was all in 1 week. Runkle of the Bailey, my mother will come for you. I would be afraid. You do not know my mother. I would be afraid. I think David Spade should play Owens in a movie. I imagine there will be a Saturday Night Live sketch about this at some point. I'm surprised the court's not back. I wonder if they're just going to call it good and go to lunch. I worked at a place where celebrities came in. I would say to fellow workers, that person looks like so-and-so, and they would be confused like, yeah, kind of. CB, exactly. Shore Life Creation said at this point, who gives a flying flip about the math? I'm sure the jury's glazed over. Yeah, it wasn't the way to end today. I'm not sure this is helpful. I'm not either. Is the jury allowed to take notes? I'm always curious since we weren't allowed to when I was a juror for a criminal trial. I don't know about this jury, but we will, I'm sure, hear from those that were in court about whether they were or not. I do not know for this jury. It really, really varies by jurisdiction. It would make me so uncomfortable if I couldn't take notes. Ruth said off topic, but wondering if you'll do a quick bit or a podcast about gun violence in this country. I don't know. I have not had time to process what's been going on in my jurisdiction because I can't separate well at the moment, and I've not had time to parse the feelings. For those of you that are new to me, when I parse difficult information, things that are emotionally charged and things that are very big, for me, I need to parse through the emotions first before I can get to the logical. And while I'm covering trial, I don't have the bandwidth to work through that process first. It's one of the reasons that the mods are so helpful with the no breaking news in the chat, because it has happened that there have been tragic real world events while I'm covering trial that have been a very difficult derail for me to recover from. And so as a streamer, I want to be here with you and bring you this content. As an audience, I want you to know that you're not going to get sideswiped by something that you're not expecting, because so many in our audience deal with different types of trauma, different types of PTSD, and different types of of neurospiciness that can send your day spiraling. And I never want to do that to you. If you are listening, excuse me, at work, at the dentist office, at a doctor's office, I don't want to catch you sideways talking about those topics when we're in the middle of just chatting about a trial and a ski wreck. So it's part of the reason I don't allow or address breaking news in the chat, because I don't have the bandwidth to process it and address it well in real time. So that's part of how I do it. I need to process the feelings first, because me spewing my feelings on y'all means we all just sit and cry together. And that's not what I want to do while I'm covering trial, because you don't expect it. In a trial like the Brooks case, we knew there were going to be really difficult days. I was able to warn you about the days that were going to be the most difficult for me and for you. And we all chose that together. We knew what we were watching when we were watching victim impact statements. We knew what we were getting in for when we turned on the stream. I don't want to catch you unaware. So I will figure out how and in what space I will, but I tend to not address news outside of the legal, other than to say it takes me time to first parse out the emotion, and then second, parse out my thoughts on it. And that does take me time to process. And I just want to give you all grace if it takes you time to process as well, because it really does. And I can't process it and stream the way that I stream at contemporaneously. And I understand you guys wanting my thoughts. I completely get it. And I appreciate that you respect me that much to ask. And I respect you enough to tell you I need to process first and then have a conversation. And I don't know how and when I want to do that yet. I have kids in school and it is tremendously difficult for me to process. So that's why we stick to the topics. And that's why the mods really help me with no breaking news, because I just don't have time and bandwidth to process and be here with you on this. And so I really tune out breaking news when I do court coverage. I appreciate you asking, but I wanted to also honor you all and your time and let you know how and when I decide to jump into things and how and when I process things. I need to process emotion first before I can talk about things. Otherwise, you just get the emotion. And I very much feel that we have a lot of that in the world, and it can get hard when the emotion is triggered to actually have a conversation. So that is why. So thank you very much for asking and giving me an opportunity to share again how I make those decisions. Because I don't want to catch you sideways. I know we have people in our community who are survivors of school violence. I don't want to catch them off guard either. So that. Can I please get a Lawyer Cat telling me he's not a lawyer? Thanks, love you. I have not reinstalled Lawyer Cat on this computer. We will do this. We will do Lawyer Cat another day. Perfect palate cleanser. So, we're just, that's why we just focus on the trial we're in when we do it. Lonnie said the horse has left the barn and it's currently in Thailand and the shit is all the way out. The only time I do break in for breaking news a little bit, if it's something really kind of light and fluffy that I've covered, like Vanderpump Rules, I occasionally will process in or quip in with that as my ADHD brain distracts me. The defense just needs to leave this witness alone and not ask questions. Yep. Motion to blow in the side of the computer. Excuse me, have you tried? Counsel, have you tried it like a Nintendo cartridge? Physics equations in court can't be a good thing. No, I don't know if they're helpful today. I feel the jury's pain. Agreed. Remember when Sheldon made himself a robot, but Wozniak was at restaurant? That's all I can see. Sheldon in a monitor. Fair enough. So math formulas or vacay stories discussions. Vacay stories. Stop pausing is merch worthy. I definitely interrupt myself. I can't believe they're not back. What the fuck are they doing in chambers? Like, how are they not back yet? How is this court not back yet? How is this court not back yet? Hold on. I've got to check other feeds just to make sure I have chat. How are they not back yet? Like, what in the world is happening that this court is still on break in chambers? We're not going to get to closings, I don't think, until after lunch. And I am very surprised by that. Just very surprised by that. I know Miguelina and the mods keep an eye on other feeds for me, which is so helpful because I couldn't do this without that support and help. But how are they not back yet? Like, how in the world are they still on break? They didn't tell us they were breaking for lunch. They didn't tell the jury they were breaking for lunch, but I think they might be. So if they're not back in a few minutes, we're just going to have to take a break. Miguelina, help. Help counsel, please. That was from earlier today. My brain shuts down when I see math and I can't even see it in my head. So it's very hard to follow without demonstratives. Loving the updated hair. Thank you. My delightful, lovely, and talented hairstylist. I was telling him how faded my hair had gotten. And I'm like, I kind of love it lavender, but I was ready for it to pop again. So in between appointments that I'm able to make, because streaming does tend to bump me out of normal business hours for most things I need to do in the day. I do use just depositing hair color, so I can do that at home in between. I don't skip the salon visits. This is just in between. V said, as a math major, this is so convoluted and really unnecessary, but if that is what they want to emphasize, I mean, maybe they're hoping the jury will forget about Terry's vacation. I can't. My partner and I are in Nash on vacay right now and are going to Adele's tonight. Kimberly, you are going to love it. Have the best time, have the best drinks. Their gnocchi is amazing. Everything is farm to table. It's made fresh. It's going to be so good. You are going to have the best time. Enjoy. Thanks for the recommendation. You are welcome. Have so much fun. Shay said, question, what is a good estimate of GP's legal fees at this point? It depends if these are insurance attorneys and if they were hired by insurance and if that was capped in any way. So it can really depend. But legal fees are going to be in the upper hundreds and hundreds of thousands of dollars, if not millions. This litigation's been going on since 2019. Yesterday was entertaining for sure. Definitely would love your take. I tweeted at you Judge Newman interview, and I love him so much. Haven't had a chance to see it yet, but I will. Truly, when I'm in trial, it is kind of laser focused on the trial. It is just a this, and I see a head bobbing around in court, but nobody's come back on the record. So it really is just a head down and focus on the trial. And it's kind of what my brain focuses on. I am now in season 6 of Vanderpump Rules. Y'all will remember when I told you at the beginning of the Scandival that I had not been watching Vanderpump Rules. So I am doing my due diligence to catch up. So those are the two things so that I don't get sidetracked, because streaming daily like this does take some focus and some energy. So hopefully not New York Marine or Travelers. Fair. 14,000 likes. When do you bing next? Oh, we did a bing. We're at 713, and I was going to gift more memberships when we hit 20,000 likes on the video. Amber said, healing thoughts, please. Law nerds, my heart is saddened with my best friend's dad was put on hospice yesterday. I am sorry for that. The law nerds will absolutely send you all of their positive vibes. Mr. Muggle, this is as awkward as me watching The Bachelor and seeing him kiss 6 women in the same night. These are the analogies that I live for. Yes, it is. In reference to the expert that had a stroke when he was younger, do you know any attorney that would have lit into him and not showed compassion? Just curious. No, it would have backfired in front of the jury. I think there's a respectful way to cross-examine sternly, and I think we saw that. I think we saw a good cross-examination, because there are some of the testimony that he gave that needed to be challenged, and they did it respectfully. So no, I think they would have lost the jury. Calico Jane said, at the dentist with my daughter and brought the law nerds with me. EDB, thanks for covering this and all you do. You're welcome. I'm an accountant and I'm not even into this math. Katie, fair enough. Didn't Terry Sanderson state he was airborne? Yes, he did. Wasn't it interesting, chat? What did you think? Tell me what you think. That his counsel and expert debunked his version or part of his version of the story. Like, well, that couldn't have possibly happened. Once his attorney is saying something once the plaintiff's attorney is saying on the record with an expert, something their client testified to couldn't possibly have happened, I think it gives the jury room to discount everything that he said. Don't you? How do you, if the lawyer is saying, yeah, but that part of his story didn't happen, do they even believe his side of the story then? And if I'm plaintiff's counsel or if I'm defense counsel, I'm using that argument in my bad faith. Like, I'm using that argument in bad faith. His lawyers on the record debunked his story. He said he was flying through the air, and they're like, well, that couldn't possibly have happened. So they don't even believe this lawsuit that they brought. Absolutely would argue it. Absolutely would argue it. EDB, I missed the memo about this and didn't take my Adderall today. Holly, while you're here, don't forget to take your meds. Required said, if I didn't have your commentary and was watching on LNC, I'd have waited too. Fast forward past this, and I think the jury would prefer that also. This was rough. So what's everyone doing this weekend? Oh, wait, court. No court this weekend. No court this weekend. None. We all need a break. I need a break. My kid has a competition this weekend. Newton's embarrassed right now. Newton wants to be excluded from this narrative. Newton does not want to be in this chat or on the bingo card. I think I'm going to make, and if you're on Law Nerds Alerts, I think I might send these to you guys. I kind of want to make digital bingo cards. And I think after this trial, chat, let me know. After this trial, I think we need to add, I'm just a country lawyer to the bingo card. It's come up in 2 trials on totally different ends of the country. So I think I'm just a country lawyer is on the bingo card now. Bring the jury is definitely on the bingo card. Terry probably fell in his ski pole. Let's get to closing. Lunch is in 1 minute. What are they doing? I might have to take a break because lunch is literally in 1 minute. Miguelina, will you just check in with Chris about my afternoon obligations? Because I think they're going to break for lunch. They just haven't said it yet. This trial needs more cowbell. Ooh, I'll make a note. We can add a cowbell to the soundboard. Do we have a cowbell? I have lots of sound making things. I don't think a cowbell is one of them. Do you think this testimony will hurt the plaintiff? Donna W.O. The testimony I think that will hurt the plaintiff is them saying that he couldn't have possibly been flying through the air. They debunked his own story. I just don't know if the defense caught it. I trust James to have caught it. Okay, I just turned in to hear you ask if I'm bored. What on earth is going on here? It was rough testimony this morning. Oh, I see the camera moving. Are we taking a break for lunch? We're going to have to at this point.
Jury?
Are you just going to excuse him for lunch? I think that's the only fair thing to do. I've not listened to James's music yet. I think you just give them the updated jury instructions and let them go. My grandfather thought you were one of my coworkers. Sandy, it's kind of true. I do co-work with y'all every day. I'm just the really talkative one. But if we work together in the same physical space, that would also be true. And I would keep you up to date on what's happening on all the reality TV shows. It's basically not very different than what I do now. So basically we are coworkers. Yeah, it's true. And I think my former coworkers would vouch for that. They'd be like, oh my God, I had the worst day in court. I'd be like, okay, I do want to hear about that. Tell me everything that happened in court, but also, did you watch Jersey Shore last night? Did you see TS face when the expert said he couldn't have gone airborne? Not happy. Oh no, because they debunked his testimony and told the jury essentially he wasn't accurate about that part. Question, who writes the instructions? The model jury instructions are written by groups of attorneys and judges, and they are based off of there are model jury instructions that they are based off of, and then they keep reiterating them. I think at some point we will see them taking out such gendered language. I think we will see kind of an updating and a refreshing of model jury instructions, and I think that's a good thing. But they are done by committees. So as part of in most places, part of committees that work with the state bar to do the model instructions, and they update them. So that's why they will say model jury instruction, this number, that number, this number. Did anyone say they saw him wearing a GoPro? No, it's just based on that phone conversation. Are they going to start closing? It's lunch. No, it's not. Oh, there's an hour till lunch. I was wrong. My time's off. I'm looking at my clock going, it's noon. It's 11 a.m. local time. Apologies, chat. Time zones fuck with me all the time. It's 11 a.m., so they've got an hour. All right, we've got an hour till lunch.
Okay, you should have on your chair.
Yep.
A document, 3 pages, called special verdict form. I'm going to go through that right now.
I like this judge too. Judge Holmberg is great.
Members of the jury, please answer the following questions in the order that they are presented.
These are the jury
If you find that the
verdict
issue has been
forms.
proved by a preponderance of the evidence, answer yes. If not, no.
Preponderance is
At
such
least
a low
6
standard.
jurors must agree on the answer to all of the required questions, but they need not be the same 6 on each question. When 6 or more of you have agreed on the answer to each question that is
Preponderance is
required
so
to be
low.
answered, your foreperson should
This is
sign
so
and date
weird.
the form and advise the bailiff that you have reached a verdict. Gwyneth Paltrow, question 1. Was Gwyneth Paltrow at fault? Yes or no? If you answer yes, go to question 2. If you answer no, go to question 3 below. Question number 2, was Gwyneth Paltrow's fault a cause of Terry Sanderson's harm? Yes or no? Regardless of your answer, go to question 3. Terry Sanderson, question 3. Was Terry Sanderson at fault? If you answer yes or no. If you answer yes, go to question 4. If you answer no, go to question 5 below. 4, was Terry Sanderson's fault a cause of Gwyneth Paltrow's harm? Yes or no? Regardless of your answer, go to number 5 below. Number 5, if your answers to question 1 and 3 are both no, you should not proceed further except to date and sign this verdict form and return it to the courtroom. Otherwise, continue to question 6. Comparative fault, question 6, Gwyneth Paltrow. What percentage of the fault
Grace,
do you
litigation
assign to
privilege.
Gwyneth Paltrow? If your answer to either questions 1 or 2 is no, then enter 0%. And there's a blank and a place for you to put your number in. Proceed to question 7. Question 7, Terry Sanderson. What percentage of the fault do you assign to Terry Sanderson? And there's a blank and a place for you to put your percentage in. If your answer to either questions 3 or 4 is no, then enter 0. The total must equal 100%. If Terry Sanderson's fault is less than 50%, answer question 8.
Bobby Cat, recover well.
Do not deduct from the damages any percentage of fault that you have assessed to Terry Sanderson. The judge will make any necessary deductions later. If Terry Sanderson's fault is 50% or more, do not answer question 8 and proceed to question 9.
I don't know,
Damages
Nadia.
Terry Sanderson, question 8. What amount fairly compensates Terry Sanderson
get there.
for non-economic damages, $blank.
Yeah, my
Damages
brain
Gwyneth
stopped on that.
Paltrow, number 9. What amount fairly compensates Gwyneth Paltrow for economic damages? This cannot exceed $1, $blank.
We were rooting for a James
When
Bendon
6 or more
snap.
of you have agreed on the answer to each question that is required to be answered, your foreperson should sign and date the form and advise the bailiff that you have reached a verdict. So we'll now hear from the lawyers
Y'all,
with their closing arguments.
Over 400
Plaintiff
of you
will go
signed up for
first.
Law Nerd Alert. Thank you. It's time for closing. We're here, y'all. Wait, no. It's closing time. Closing time.
We'll check with the expert here.
Last call for... God, I'm going to forget the lyrics of closing time.
Hello, hello?
You don't have to go home, but you can't stay here is where I got to.
Do it again.
Hello, hello?
Yes.
Nope. I can't hear you. Better.
Well, ladies and gentlemen of the jury,
One last
thank
call
you for
for
your attentiveness
alcohol. So
during these 2
gather your
weeks.
whiskey or beer.
It's been a hard, long case. I've tried a lot of cases in my lifetime. This has been a hard, long case. By the way, it's about an hour each way going to Salt Lake with traffic, so that
Oh,
adds to it.
sir.
But you've been very attentive. I've seen you taking notes and paying attention.
They're taking notes.
No one nodded off. So thank you again.
Is that your standard for juries paying
Yeah.
attention? How many jurors have fell
on
asleep
my-
on you, counsel?
Lawrence and I are going to split this.
Counsel, how many jurors have fallen asleep while you're talking? When no one nodded off is the
By the
first
way,
thing
I
you say.
apologize for my cold. You can't really choose when those come. I've got asthma, and it makes it worse. But I've done everything I can to try to resolve it. Took all the tests. I'm negative for COVID, et cetera.
I don't
but
have
still,
COVID,
it's
ladies
late,
and
so I
gentlemen.
apologize for the coughing.
I'm not getting you sick.
Maybe a little bit more of that.
I think that's a
Okay.
fair thing to say to the
There are really
jury.
3 issues in the case. Number 1, who hit whom? Okay? Number 2, did it cause any damage? Number 3, what are the damages? What are the
Yep.
damages? Now, Gwyneth Paltrow, in this case, is not a liar. Terry Sanderson is not a liar. Okay?
That's what we're starting with?
Gwyneth is a good person. Okay? She's a good mother, and she loves her children, and she's passionate about many things. Now, we don't usually say good things about other people in our closing, but I think that's an accurate statement. Okay? I think that she believes, and I believe Gwyneth Paltrow. What? She says she believes. She says, Terry hit me in the back.
It's her truth?
And she believes it. It's a sincere belief.
Counsel?
She's not a liar because of it. Pardon me. But the problem is, a sincere belief doesn't make it so. Now, excuse me. Some of you are skiers and some of you aren't. Okay.
I believe her?
Pardon me. When you're involved in a ski crash,
I did not have that. I did not see that
it
coming.
can be very confusing. I don't care who hit whom. You know, it can be very confusing. So I think she sincerely believes that she got hit in the back.
My ears!
The problem is, you have to make a decision based on the evidence that you've heard here. Okay, on the evidence. Now,
This is an odd closing already.
let me tell you, to illustrate this, about something that happened to me about 1.5 years ago. Okay?
Did you get hit skiing?
We live in downtown Salt Lake, and we use that Costco, or shop at that Costco on 17 South and 3rd West. Some of you probably
Car
know
accident?
this. Largest one in the world.
Dibs on car accident.
We are having a hard time hearing us.
That's not an objection. Don't count it yet. Let's end the objection poll.
Is it on your chest?
Maybe it's not turned
Oh gosh, don't let him cough into another mic. It's so loud on the ears.
Says on.
I know, I mean, I'm picking it up just fine on for the record, but no one else can hear you.
Maybe put it higher on your.
Oh boy. I don't know if he's going for 50-50 instead of being liable. Maybe? It's an odd tactic to take with the, I believe Gwyneth Paltrow. You're the side that's supposed to be going against her. It's a strange tactic. Sandra D., thank you so much. This is the highest praise I can ever hope for.
I just got gas at Costco. It was about July of
When he said I just got gas, I
2022.
didn't know where that was going, and my brain took it and
No,
ran.
2021. And I was at an intersection. This is a pretty busy intersection. There are
At the
2
Costco?
lanes, north and south.
Were you in the
2
shower?
lanes, east and west, 2 each.
Chutney.
And there's a left-hand turn lane. I had a red light. Okay. And I was the first one at the intersection. Got a good look at it. I looked in my rear view mirror on my left side, and there's a green arrow for each direction going east and west, turning south and turning north. You understand that? So I'm waiting because I have a red light. And there's a lady across the way from me, car heading west but turning south. She had a green arrow, like I saw one her heading north. I looked in my mirror, and here comes a guy at about 40, 45 miles an hour on the inside lane.
He wasn't going 18 miles an hour so everybody can
17
see
south.
you. Unfortunate.
I said, my goodness, he's going to hit that woman. She's making that turn. And sure enough, smacked her and smacked her hard. Okay? Didn't slow down at all. Well, I had a good view of it, and the car spun around, but I was able to get by. There's a Maverick on the southeast corner of that intersection.
Was Goose there too?
I pulled in there, ran to her car, and asked her, "Are you okay?" Like everybody does. She said, "Yeah, I think so." I didn't think she was, looking at her, but she said she was okay. Okay? So I ran over to the other guy. I was the first one there. Some people were beginning to stop.
I've done that.
And the guy that ran the red light said, "Are you okay?" He said, "Yeah, I think so." I said, "Well, why'd you run the red light?" You know what his answer was? "I didn't. It was green." Well, I wasn't going to sit there and argue with a guy like that under those circumstances, but he said it was green. So when the police came a couple minutes later, and you got to be careful as an attorney, I gave them my card, not to get the case. You know, you can't do that, it'd be unethical, but let people know who I was so they could call me. Give the cop
It's like I'm a witness.
a card, and I gave each of the persons a card. And about several months later, I started getting calls from insurance adjusters.
It's like, can I
want me
get
to
a
tell what
witness?
happened. And I tell you that story because so often, people that are in these types of events have a totally different viewpoint. So we don't hold anything against Gwyneth for her viewpoint.
She's just
It's
wrong.
sincerely expressed, but she's wrong based on the evidence. Okay?
Interesting.
And Terry's correct. Now, what's the evidence that Gwyneth hit Terry? Okay.
That he went
Number one,
flying through the
there's
air.
no
Oh,
particular
wait.
order on this, but Terry's a strong skier, advanced intermediate. Mr. Christensen said he saw him going down the hill doing wide radius turns. That's side to side, all the way, back and forth. Now, on a beginner's run, that's highly unlikely
Why
for
would
an
you do
advanced
wide
skier.
turns on a beginner run?
You don't do that. You don't do that. There's too many people.
Fair argument.
And so that doesn't make sense. Number two, I'll call it the scream heard around the world.
Oh
Okay?
gosh, that's
This is being
overstating
broadcast
it.
everywhere, by the way. It's on court TV.
It's on
I'm getting emails every day
EDB,
from
sir.
Canada, Great Britain.
We're currently number one on trending, but whatever.
There's a loud scream. Terry heard it. Loud scream. Craig Ramone heard it and looked
Chad,
over.
I'm teasing.
Several other people heard it. Carrie Oakes said she heard it. Peter Christensen heard it, so caused him to look over. It's before the impact. And you don't, if you're the downhill skier,
It's EDB TV.
like Gwyneth claims she was,
Thank you, Chad.
you don't scream at something you can't see. You don't.
Yeah, I want to be able to see Sanderson,
It's
so I'll be
the,
adjusting
uphill skier
as they switch
that's going to make
screens.
that scream. And that was Gwyneth Paltrow. Distraction. Everybody here probably been a parent.
Ding, ding,
Not
ding.
some of you maybe. But I've had my kids up there, and they want me to watch them ski. And mommy wants to ski. And Carrie Oakes said that, and that the deposition segment that you read.
But up
said that
higher
3
on the
times.
hill, though.
Okay, 3 times. And
But up higher
that's
on the hill,
important. Can
though.
we show Gwyneth's deposition up here?
No. It's not an exhibit, to the best of my knowledge. Did you introduce it?
What are we talking about here?
There's
Mr. Sykes,
objection
is
number
this
one.
Deposition testimony that was read into court?
Yes, exactly.
And is it only deposition testimony that was read? Okay.
Deposition, meaning trial testimony?
Well, it was read into court.
May we approach, Your Honor?
This
Sure.
is an appropriate objection. All right, y'all, we're going to answer some questions while they approach. You can't just show the text of the deposition up in court. It's not an exhibit. So with all of that, I'm just going to remind you, we will soon be on Verdict Watch. So for those of you just chatting in, there's 35,000 of you here. If you would like to join me and the rest of Law Nerds for Verdict Watch and like to know when I go streaming, because sometimes we do that randomly, lawnerdalert.com will go ahead. That's in the description below. And that's also a link will be in the chat as well. So you can just click that link and sign up with your email address, and then make sure you open that first email, the welcome email, that it doesn't go to promotions or spam or anything like that. you want to know when we are going live to talk about this, because I think this might be quick. If counsel believes Gwyneth, what's the jury to decide, right? He's like, it's just streaming everywhere. Why even bring that in? Why even talk about that with the jury? It's so odd. It's so odd. This is going to be for an hour. Maybe. Chat I just joined, was the math mistake explained in rebuttal? We're not there yet. We're just at the beginning of the plaintiff's closing. Question, I need to know what hair color you use. It's so pretty. I used a vibrant purple overtone last night. Question, how much,
You
if
could make the
anything, is
screen
awarded,
only
do you
show
think?
the part that was actually
Trying to
read
do
in
that.
court.
Is that okay, Judge, like that?
That looks good.
Okay. Now, Ms. Paltrow, isn't it true? Isn't it true? I'm just a country lawyer here, okay?
Oh, God.
Isn't it true?
Bing, bing, bing.
Let's see if I can move it over a little bit.
I'm just a country lawyer here. Even in his,
That
even
your
in the
kids wanted to watch you
deposition,
ski, or pardon me,
it's going
that
on the
kids
card.
wanted you to watch them ski. Isn't that true? Vegas the time. I can still watch my children ski and be skied directly into my back by someone, okay? Which is what happened. Now I'm going to omit Mr. Owen's statement and my own, and here's how it reads. Isn't it true that your kids want to watch you ski? Or pardon me, that the kids wanted you to watch them ski. I can still watch my children ski and be skied directly into my back by someone, which is what happened.
Okay.
Now,
Gwyneth's got like 4 different flare pens over there working today.
there's an eyewitness. And
You say there's an eyewitness.
we thought about having him testify again today about those drawings, but we decided not to do it. But
He read it twice.
he saw the whole thing. He saw the impact. And he's the only one that saw it. That's a key piece of evidence. Now, who is Craig Ramone? He's an acquaintance of Terry.
Not a friend,
He's
right?
part of a meetup group. He's not close to Terry. They went to get garlic burgers twice, okay?
Now I want a
He has no
garlic
dog in
burger.
the fight, ladies and gentlemen. No dog in the fight.
Steak and Shake. Great garlic burgers.
He's independently wealthy. You can tell that by what he does.
Your Honor, that's as soon as fact's not in evidence.
Well, it's,
Just a
Objection
minute.
number 2.
Objection overruled. The jury will have to recall what the evidence was, and
the evidence was he sold his business, I don't know, 10 years ago, and all he does now is ski and travel and scuba dive.
Must be nice.
Okay? He has no reason, no motive to falsify this. Okay?
That's why he
Confirmation, those meetup
That's why
emails
he
that you
went
saw.
to that. He has no reason, no motive, other
It was
than they
one
think
of the
it's
last
cool.
evidence, I think it was 44, was it? I won't go over it with you.
We're on objection number 2.
But we printed that out, I think,
Should
Saturday
we close our poll?
or
Let's close
Monday.
our poll.
It gives you the number
Lena.
of days since it was entered. And you add those up, you go right back to February 26, 27, 28, around there. Strong evidence. Terry has repeatedly said to his medical providers that he was hit in the back over a period of years. And that he has problems, medical problems from it. The broken ribs, that's one of the strongest pieces of evidence you have, that Terry was the guy that was hit. He was the downhill skier, okay? 4 broken ribs, 2 of them separated like that, weren't together. And that's very serious, it's very painful. But the pattern of those broken ribs, 2 MDs, one from Utah and Dr. Boehme, so that pattern of broken ribs supports the fact that he was hit from behind. Now, I'm not going to go into all the details of that. That's what he said.
You should go into all the details.
Dr. Boehme, who just testified again
That's
today,
what the jury needs to know.
said that Dr. Scher was simply
How do we know
wrong
he
in
was
his
hit?
philosophy.
Those details
or
are what
his
we need.
formula. He assumed it was a free fall, and it wasn't a free fall. Broken ribs.
He said he went flying for the email.
How do you get that without a significant impact? Now, the flaky Deer Valley investigation, I think, suggests a cover-up. Eric Christensen, I think, was unbelievable and
I'm
inconsistent.
going to ask you, Chad, if you think there was a cover up.
And there were a number of things. I'm not going to go over each one of them, but I will talk about one. The claim that Terry said he was okay. Now, some of you have probably had broken ribs or loved ones that have had them, you know. Even Steve Graff up here
I'm polling
said
the
it's
chat.
extremely painful. Now, this whole process took place between 11:55, which is the time of Graff's incident report, and 12:02, when Ramon flagged down the ski patrol, and 12:04 when Whitney Smith arrived. So we're talking about 7 to 9 minutes, okay? And they would have you believe
They would have you
that a
believe.
man with 4 broken ribs, 4, 2 separated, told not only Eric Christensen that he was okay, but 2 other unnamed, unidentified ski patrollers that never logged it in.
I
He told them
absolutely think he told them he was okay. I absolutely do.
Now, that's just unbelievable.
It's not.
That would happen.
It's
to
not.
A person with 4 broken ribs, not
People
just 1, but 4.
People say all kinds of stuff when they've been
ski
hurt. They
between
don't
the legs.
perceive it yet.
I don't know how many of you are skiers. I don't remember. You said it in your interviews.
I believe that he's like, I'm fine, I'm
3
fine. And then
weeks
went,
ago,
oh
but,
shit, no, I'm not.
To have someone ski between your legs, she thought it was a sexual assault. Okay? But to have someone with both skis, to someone that's moving and shooshing back and forth, it's just another unbelievable claim.
Shooshing.
That
I'm
can't
delighted.
Now,
Shoosh.
and then Gwyneth skis away to lunch.
And the ski instructor
The
stays.
only way that Terry Sanderson knew that this was Gwyneth Paltrow is Christensen got angry and said, your buddy just took out Gwyneth Paltrow, which is an odd comment to make. Like, just took out a person, you know, but
Terry
had
Sand-
to put in Gwyneth Paltrow. That's the only way we know that. That's why you're here. Now,
That's why you're here. You're
causation.
here because Eric Christensen said your buddy just took out Gwyneth Paltrow. That's why you're here, ladies and gentlemen of the jury.
This
Sir,
event
that's
caused-
not going to do it for me.
An injury. Well, I've already mentioned this, the impact was significant enough to break 4 ribs. You know, the impact
believe
of
he
the
broke
fall,
4 ribs.
That is a significant impact. The location, the right front, is where you would expect it under the circumstances. Loss of consciousness. You know,
That's in
it was only
controversy.
a few minutes, maybe 2, maybe 3.
2 or 3 minutes
But
is
there
a
was loss
substantial amount of loss of consciousness.
Widely reported in the medical records, and that day.
From him, though.
Widely
It's
reported. I mentioned the okay. Don't want to mention that again. So, it was significant enough at the time, the very first thing that anybody noticed was that Terry forgot how to ski. He was snow plowing down the hill, an advanced intermediate.
maybe because his
snowplowing
ribs hurt so
down the
fucking
hill.
bad. If he had a
Think about
3-minute
that
loss
for a
of
minute.
consciousness, he would have been
You know?
taken out in an ambulance.
And Craig Ramon says, hey, Terry, you forgot how to ski.
Are you
And that's when
disputing
Craig Ramon said,
Whitney's
I gotta flag something
testimony?
down. So he did, and he told that person, he's got a head injury. That's the words he used, a head injury. Now, it took him 5 seconds, and Craig acted it out up here.
Why didn't anyone tell
5
Ski
seconds
Patrol then?
to be able to tell him his name. He didn't know where he was at first. That's a significant
Why
impact.
didn't
That's a
his
concussion.
friend tell Ski Patrol
Now,
that he had a 2 to 3 minute loss of consciousness? That's substantial.
ski patrol flagged down at 12:02. Whitney Smith arrives. What a sweet person.
Yeah, Whitney
And
Smith
Terry's
is
taken
lovely.
off the hill in a toboggan. Now, that's no fun.
Whitney Smith
But it
was one of the
shows you
most
something.
helpful witnesses to me.
She rides disoriented, rib pain.
Oh no, Lydia, I'm
loss
going to
of
yell this much about the other side's
Alina Fong,
closing
which
too.
treats thousands and
I'm going to do this
thousands
to
and
both
thousands
sides.
of TBI victims, said loss of consciousness is not required
Yep, I do this to both
Okay.
both
Not the
attorneys.
point.
I'm the
Headache.
point counterpoint.
And that day, I think at the clinic in Park City, dullness in the front of the head. And Whitney Smith said, go to the ER. And Dr. McMahon said, go to the ER. So the next several months, you have numerous symptoms of TBI that show up in the VA records.
He said he wasn't hurt on the mountain and then didn't
personality,
go to the hospital
Social. and
until the
emotional.
next day. I can
I
absolutely
could
believe
go
on the
through and
mountain he
show
said
them
he was
to you, but
fine.
You all saw them.
He didn't go to the hospital
But
until
then-
the next day.
One of the most significant pieces of evidence here is a sudden and precipitous change in Terry Sanderson. Sudden and precipitous, okay? Now, I'm not talking about when he came home and Carlene, said he didn't want to be touched. He's got 4 broken ribs.
But he didn't
Carlene,
go to the
who
hospital
loved
that
him,
night.
said it was a love relationship. She wanted to marry him. They've been together 300 days a year up here and then down there in St. George for about a year and a half. It's a long time to look at someone. She loved him. She traveled with him. She wanted to marry him. And you saw how she choked up when she explained how the relationship ended, that he changed. His personality changed.
I believe he said he was fine on the
Gresham,
mountain.
Shay Hareth, same thing. Big changes. They didn't see him as often. So that sudden and precipitous change is a sign of brain injury. Diagnosis of concussion. The VA diagnosed it. Multiple physicians diagnosed it. All the defense experts admitted it. Every one of them admitted it. They minimized the extent of it, but they all admitted he had a concussion. Every one of them. Every one of them.
I don't know if everyone admitted he had a concussion, but I do think
Dr.
he
Giddy,
had
Dr.
an
Fong, Dr.
impact.
Goldstein, Dr.
I absolutely agree.
The only question was severity and permanency. But every one of them,
The
they
sound
didn't
just
wanna
got so much
admit it,
better.
but they gave different
Oh,
numbers
sweet-
between 5 and 20%
Sweet Jesus.
of people
That's
that get
so
a
much better.
concussion. It's permanent.
Oh, don't cough into
They
that
have
mic,
permanent
sir.
problems. 5 and 20%.
It's so much easier to follow
Dr.
you.
Fong thinks it's higher than that even.
I like Dr. Fong a lot.
Now, the physics. Dr. Boehme explained
Damn it,
the
pick
physics.
the mic back up.
I think second day of trial, and a little bit today. But he's a neurologist, but he's also a biomedical engineer. That's different than Dr. Scher. He's a biomechanical engineer. But Dr. Boehme specializes in how force affects the body. Very highly respected in that field. That's very rare, not very many of them. Terry talked about the loss of friendships. Mark Harath, good example. They were good buddies, went skiing, and didn't like him anymore. He talked about, excuse me, the woman that he was going to Europe with. Don't remember her name, you remember it, but
He doesn't even care.
she changed her mind at the last minute and had an empty seat. That's how Jenny got to go. The experience of his granddaughter, tearing into her for
I
how
don't
to
know
tie
if this is a
knot.
new behavior, though.
Big
Talk
changes.
about the issues, the
Greg
multiple
Ramon said
divorces
Terry,
before.
after the accident, it seemed like he could talk to the wall for an hour.
Talk
Have a
about
good
before.
conversation. Faking. Every witness you heard from
That's true. Being a lawyer is very
embedded
stressful.
in his tests to find that. No evidence of that at all. And by the way, the VA records continue up until the present day.
We've heard.
They didn't show you any single VA record where that was ever suggested of this man. NPH. They suggested, that could, it's the normative, what is it called again?
Normal pressure.
Normal pressure hydrocephalus.
Counsel.
He's got it, but no symptoms.
They're focusing so much on
And
damages
it
and
didn't
not on
change
cause.
over about a 13-year period.
I want to hear more about cause, but I guess we're just not going to.
2009 to 2021.
Deer Valley did not have cameras
Dementia,
at the
they
time
kind
they
of
do now.
implied that maybe he's got that, but when we cornered them on cross-examination, not a one of them said he had dementia. And there's no reference in these thousands of pages of records.
No, there was
any
references.
diagnosis.
There was not a diagnosis. There were references, though. There were references, though.
Degradation.
Degradation.
Of imaging, okay?
I can't
We had
pronounce it,
imaging,
so it's
I think,
not.
from 2009 to 2021. And all the defense experts, plus our own.
The microphone.
said
Thank you, counsel.
There's no degradation on these imaging. He's got white matter abnormalities, probably half of us do. Nothing showed in there.
Sir, my brain has
No
a lot of
problems.
abnormalities, but
No
don't talk about my white matter
increase.
like that.
You heard that just as recently as yesterday.
It gets sensitive.
Now, I'm going to say just a few more things here.
Promise.
And turn some time over to my colleague, Lawrence Bueller. This is actually his case. He asked me to help.
Why? He's famous. He's related to Ferris.
That day when Terry left his home to go skiing in Deer Valley, that meetup group, February 26, 2016, he anticipated, like many, many other days in his life, a fun day of skiing. Okay?
You should have started with this.
And he
Should have started with
he
this.
never returned home that night as the same Terry. He never came home, figuratively speaking. Terry has tried to get off that mountain, but he's really still there. Part of Terry will forever be on the bandana run, figuratively. People who are just after money, and that was suggested. He's just after money and fame.
You should have opened with that.
Somehow going through all of this and spending all the money he spent on experts, you know.
Travel.
He's
We
doing
want to
it
know
for
about the
fame.
travel.
Give me a break. But he spent hours and hours trying to get better. If you heard anything about him, he
Is a doer, a
almost-
goer, a poster, a skier.
That's a good word. Extreme and trying
Sir,
to get
don't
better.
talk.
He does everything he can to get
Terry,
better.
why are you talking?
Anyway, we hope that you will help bring Terry home off that mountain with a fair verdict today.
It's very dramatic.
Now, before I turn it
Do
over.
you like it or do you hate it? Is that too
I want to
dramatic?
say one more thing about
Bring Terry home off the
executive
mountain.
function.
Does that feel
Okay.
too much for you?
I had an experience up here that taught me about that. 40 years ago, I was in the legislature with a guy named Glenn Brown. I think
Long-
he's still alive.
Young country lawyer?
He's in Colville, has a dairy farm, or did. And I used to kid him about milking cows, you know. So he invited me up to his farm.
From skiing to milking cows,
Young
not
lawyer.
on my bingo card.
Gonna show me how to milk cows. Never done it. Got up there, and he showed me around his barn.
I've done it on the
It was
Nintendo
really
Switch.
sophisticated, 40 years ago. I mean, it's probably better now. But when you think about why Terry never came home, think about this story and executive function. Because
With milking cows?
he put a little stool out there for me, and I sat down in my jeans and tried to milk a cow by hand. It's very hard to do for a
Country lawyer?
like me. I grew up in the city. But I was
Country
able
lawyer that grew up in the
to,
city.
squeeze
Fucking
out a
hell.
little bit of milk, you know. He gave me some to take home.
I'm glad you got to take the milk home, sir. Did you
but
get
I
eggs
asked him
too?
about this situation. I said, how do you do all this? He showed me this very sophisticated situation that milks cows automatically.
Holy shit!
Does it automatically.
Farm
He says,
equipment.
without this, Bob, I could never make it. Couldn't do it. Can't get enough people to come help me do it by hand, like my grandpa did.
People used to have a lot
That's
more
executive
kids.
function. That's what it does for us. We're able to do a lot of things.
Y'all, executive functioning milks cows.
And that milking mechanism
tweet that.
was executive function
That's what I've learned today.
for Glenn Brown's farm to produce milk.
I don't love this
Yeah.
analogy.
This is one of Terry's saddest problems, his loss of executive function. Okay? He cannot organize and manipulate his life to do things like he used to do. It's the saddest thing. And that's why part of him is still up there on that mountain.
What is it like
Thank
to
you.
not have
Lawrence?
executive functioning? Tell me more, sir. I've been ADHD my entire life.
That's why.
Tell me more about the executive
Sit down.
functioning. Also, did you notice how close Terry is scooted towards the jury? He is sitting well outside of where the boundaries of counsel table is and is in like the doorway of where you come in and out, closest, like as close as he can be to the jury without sitting in their lap. I don't know if anyone on that jury's ADHD, they're going to be like, okay. The milking cow is just... Yeah, organizing all of that travel called and wants to know your executive functioning. I still have travel anxiety because packing is so difficult with the ADHD. So is organizing flights because I often plan them on the wrong days.
Still, good morning. Good morning, everyone.
Oh yeah, no, Plaintiff was talking, Rob, under his breath. We could
Okay.
look at how close to the jury he's sitting. He is scooted well out. Maybe it's because his attorney's sick. That could be fair. Elizabeth said, I just scared my cat yelling right. I don't think Sykes is terrible. Cincinnati, you don't have to couch it. Your opinion is your own, and I'm not going to tell you that you're wrong. I don't think Sykes is terrible. There are things I just did not like.
Let's change the batteries.
There are things I just did not love. I thought bring Terry down off the mountain felt a bit overdrawn.
My lucky day.
But I'm also a former criminal prosecutor, so I've dealt with a lot of cases where people have been a lot more injured. I realize for Terry, this is probably the worst thing that's happened to him, but it felt a bit overdone, and he should have started with it. If you're starting with the dramatic storytelling, start there. So it felt overdone for this, and it was hard for me to get past the coughing in my in-ear monitors because they were so loud. It was hard. I'm glad that he explained it to the jury, though, and explained to them, I don't have COVID, blah, blah, blah. But the milking cows isn't going to help the jury. Telling the jury that automatic milkers are like executive functioning is so fucking lost on me, and you don't have a lot of time. And
This case is simple.
Tell me, please make it fucking simple.
You've heard the first two parts of this.
Help me.
Who hit whom?
Bueller, tell me.
What are the damage that were caused to Terry?
Who hit who?
And then the next question is, how much are those damages? And that's the part of the case I'll deal with.
Damn it.
This case is about answering the simple questions the law asks us
Who done it?
put on the form that we call the verdict form, which you'll get in a few minutes.
I'm glad he's walking them through
Maybe
this.
this
Those things can be
afternoon.
confusing as fuck.
Verdict. That's an interesting word. It comes from Latin. It's actually two words.
Wait, where's ancient Greek?
Means verus,
Oh, God.
truth,
Latin has entered the
or
chat.
dicta, or to tell, or told. So
Can we go back and
combined, it
talk more
means
about dicta?
Truth told. And that's what you're here for. is
Lawyers
the
love our
truth
Latin. I have a
told.
tattoo in Latin. Not sorry.
So
We
what
feel
does the
fancy.
law want us to tell the truth about? Well, let's look at what the verdict form says.
I don't mind the linguistic breakdown of verdict. The nerd in me appreciates it. But also, I don't think jurors
The first
care about the
question is,
history lesson of law. But
was
we
Gwyneth
know Owens
Paltrow
is
at
going to do the
fault?
same thing. Well, this is very helpful.
As my colleague Bob Sykes said, the evidence is clear.
Wait, go back to that. Court TV,
4 broken ribs,
put it back up.
an eyewitness.
The verdict form's really helpful.
There's lots of other evidence too, circumstantial evidence that Miss Paltrow hit Terry Sanderson on February 26,
I thought you were doing damages.
2016.
Oh, there we go. Thank you.
The stories have been
Emily
consistent
approves.
for 7 years.
Damn it. Go back.
So the first question, we answer yes.
Okay, back on the screen.
Now, earlier, it was in jury instruction number 27, the judge
I just wanted a
defined what
screenshot.
negligence is. And judges around the country have a hard time defining what it is. It's very abstract, very abstract.
Here, there's
What
a
it
duty.
means, basically, is They knew it was dangerous to ski while distracted. They knew that someone could get hurt if they continue to do that. And they did it anyway.
So distracted skiing is what they're going with on negligence for Paltrow.
Did they know the damage would be this serious? Well, we've all heard about collisions.
Eggshell.
Collisions happen on the football field.
Collisions on the mountain are
happen even on
dangerous.
sidewalks sometimes. People get concussions. And Terry, there's no doubt, suffered a concussion. But Terry's damage is not just a concussion that goes away in a few minutes or a few days or a couple weeks. You know that Terry's damages, or his concussion, persisted for more than a year and a half. And that's been verified by Dr. Fong, Dr. Gibby, Dr. Goldstein, and Dr. Boehme. Even the defense's experts admit that he had a concussion. They quibble on how long it's lasted. But none of those defense witnesses actually examined Terry. And as Bob pointed out, none of them really acknowledged that Terry had problems. One of them
They acknowledged he had
refused to
problems.
acknowledge the before and after witnesses.
They just said the problems were from before.
His two daughters, actually three, but two daughters that testified in this trial, Shay and Polly, his friend Mark Harath,
This courtroom.
finally, or the first witness after Craig Ramon, was Carlene Davidson.
Y'all have heard me
his
say courtrooms are
ex-girlfriend.
disgusting.
They'd known each other
I
for
feel
18
like this
months before
trial
the
has
crash.
illustrated why I think
6 months
courtrooms are a
after the
pit of
crash.
germs.
She testified that the damage continued, thus making it a permanent,
I had a friend get MRSA from court.
permanent, this is a tongue twister,
I got exposed to TB in court and had to get treated. It was awful.
persistent concussive symptom. And that permanent persistent concussive syndrome is the long-term brain damage that we're talking about. So what it means is every waking hour that Terry has, he's got this brain injury that causes so many problems for him, from executive function to just,
See, some of you
being
don't
able to
like
deal with people.
his
And as those witnesses showed,
delivery.
Terry has a problem. He looks fine. It's an invisible injury.
I find this a
People
little
know,
easier
that's
to
what they say
follow.
about brain injury. It's an invisible injury. You see someone with a brain injury
Chad
and they look
disagrees
fine.
with me.
What's
This
wrong
is
with them?
painful.
If he has a brain injury, why isn't he in bed and moping around and not doing anything? Well, that's the opposite of Terry. The crash took much of what he had and left it on the mountain. Terry still has that drive to get better. And even though persistent concussive symptoms are permanent, they last a lifetime. They last forever. So 16 hours a day, Terry is dealing with this injury, such that,
What's he doing with the rest
as
of his
Bob
time?
mentioned, when people get to know him,
Wait, why 16 hours a day?
after a while, they don't
Chat,
want
why?
to deal with him anymore. I'm sorry I have to say this, but I've known Terry now 6 years. This is just argument,
He's
but
a real pain in the ass.
it's real. Now, the 4 broken ribs, those were painful for maybe 3 months or so. But the brain injury is persistent
His attorney's like, it's real.
to this day and will last until he dies. The executive function, the social abilities.
The hours he's awake. Thanks, Chad. The chat's done the math.
The mental problems, driving to the store, not knowing where you are, and having to use GPS just to get home. These are real injuries that Harry, who was a very bright person, you would not know it just talking to him for 10 minutes. But once you get to know him better, you realize he's got these problems that just change everything. So, as I talked to someone left me a message.
Are you talking about damages or are you talking
Every
about
time I
causation?
hear this voice message, it just makes me cry.
You're going to retell it?
just because it's so just kind of flat, but he says, you know,
Who left
this
you the
person
message?
suffered a similar injury 30 years ago. A persistent concussive syndrome or injury, permanent brain injury.
Okay.
And she said, it's permanent. Your personality change is permanent. And you lose everybody who knows you. You lose everybody.
And that's heartbreaking.
Yeah, your family, they'll put up with you, and maybe the lawyers, but really, they're just putting up with you.
Oh. Terry, your lawyers don't like you very much, big guy.
So let's go to the next question.
The thing is, they're going to come up and bring up his past relationship
I'm
troubles.
going to go through, because this is a complicated case, Ms. Paltrow is suing for $1. We're going to
Are you going through
go through
damages?
these next questions.
Damages? I love it when you go through the
Terry Sanderson
questions.
at fault.
I find this very helpful.
Terry was hit from behind. Craig Ramon saw it. The rib injuries show it. Now, Dr. Scher, for the defense, who's not a medical doctor,
I find these so
he's a
helpful.
mechanical engineer,
This is the verdict
deals with
form the
ski
jury has to
bindings
deal
mostly.
with. They have to
He
answer
says
these
that
questions.
Terry Sanderson likely skirted under Gwyneth Paltrow and somehow twisted around and broke his ribs. As Dr. Boehme confirmed again today, that's impossible.
I find this
it
very,
defies the law
very
of physics.
helpful.
So I think you have to answer no. I mean, it's a clear no. Was Terry Sanderson at fault? Number 3, no. So then you skip to go to 5 below.
I like that he's
And
explaining this
since
to the jury
one
very
is
much.
yes,
These can be
this
confusing.
is like a puzzle.
Yeah, they can be confusing.
Here, I got a pen. I've got one.
He's going to
So
show
was
them what he
Terry
wants them to
Sanderson at
do.
fault? I'll go back to the first page. Was Gwyneth Paltrow at fault? Yes. Oh, I forgot to
This
do
might
number
feel,
2.
Chad, I see some of
And
you
have to
might
go in
feel
order.
tedious
Was
with this.
Ms. Paltrow's fault the cause of Terry Sanderson's harm?
Jurors filling
It
out
clearly is.
verdict
Terry
forms
Sanderson
wrong
was hit from behind. There was a scream.
is very
and
common.
And he was hit from behind. So
very
the answer is
frustrating.
yes. So then we go to 3.
This is very needed. They need to understand how to do
Because
this
we answer
clearly.
number 3, no, we skip to 5. If your answers to 1 and 3 are both no, you should not proceed. Well, we got a yes, 2 yeses. Otherwise, continue to question 6. Gwyneth Paltrow, what % of fault do you assign to Gwyneth Paltrow if your answer to either 1 or 2 is
Hundy.
no? Then
Hundy.
enter 0. And to be honest with you, this is the first time I've seen the form because it was just finalized just before we started the.
Rob, you make me feel so
I
much
have to
better
think about this one a little bit.
about
but
not,
let's think about it together.
Not overstating the importance of this. It is
What % of
critical.
fault do you assign to Gwyneth Paltrow if your answer to either 1 or 2 is no? Then enter 0.
It's so
Well,
confusing.
both are yes.
So then we enter 100.
So we have to, because Terry Sanderson did not cause this crash. You can't cause a crash when you're hit from behind.
Gwyneth. Gwyneth. Do you see her sitting there
What
going,
% of fault do you assign to Terry Sanderson? Well, it has to add up to 100, so you
this
have
is
to.
their closing.
put in 0
you sit there and you listen. Defendants on trial for murder react less.
Terry Sanderson's fault is less than 50%.
Just
Answer
see
question
that?
8. Well, it is. So we
These
skipped 8.
parties, man.
What amount fairly compensates Terry Sanderson for non-economic damages? Non-economic damages.
I think she's actually chewing gum too. In court.
Our time on Earth is the most valuable time we have, that we know of, at least in this existence. Our time on Earth is one
let's
of the
get
most valuable things
existential.
there are. There are paintings on a wall that
People in the
are worth
audience are
$50, $100
sleeping.
million. There are houses in these mountainsides that are worth 5, 10, 20, much more millions of dollars.
Things that Gwyneth Paltrow
There's
can
even
afford.
racehorses that are worth tens of millions of dollars. Well, Terry's none of those.
He's not a racehorse?
Terry's in the last
Fuck.
days of
Where-
his life.
I'm in the wrong place.
He probably has at least 10 years left, according to what a lot of people
Terry's
think.
not a racehorse.
He guards his health, he
Or a
doesn't
house.
smoke. He's trying to pursue a healthy lifestyle every single day.
And he's
Yeah, he
almost
goes to the
dead.
doctor.
Why the fuck are we here? He's in the last days of his life.
So since the crash, it's been 7 years.
Does he sun his balls?
And
sorry, that was a goop
let's say
reference.
another 10 years.
I realize there's 35,000 of you
Every
here
single
that
day,
might
he's
not
got a
understand it.
16
That's
hours
goop
of
reference.
dealing with this brain injury, this persistent concussive symptom that causes all these problems.
Last days of his
So
life.
how do we calculate that? As the instruction says, for non-economic damages, jury instruction 35, which you all have, it gives a detailed instruction about that. Pain, suffering, loss of enjoyment of life, and a retired person, well-to-do person like Terry, who worked all his life, these are the golden years. These are the most valuable years when you can enjoy your retirement and actually do things like travel. But now he has to travel with other people or he gets lost. Dr. Fong,
I'm singing golden years in my head.
Most of his therapists have said, what's the best way to deal with, your brain injury? Well, do the things that make you happy. Be active. He could sit around and mope around and be an obvious brain injury victim, but no, Terry doesn't want to be brain injured. He wants to live life to its fullest. So 16 hours a day, he's got this issue that where a big part of him was left up on that bandana ski run.
Left a big part of him on the hill. Sorry, I'm still singing golden years in my head.
So you have the power.
There's a movie with
here.
Heath Ledger.
This is, before we were just
Some of you know where my brain is trotted off to.
arguing and
Like a
presenting
$10 million
evidence, and
racehorse.
the judge was ruling on it, but now the judge is going to pass the case to you. And this is where you decide what happens next.
Ooh, choose your own
So
adventure.
I'm going to suggest, I'm not going to ask, this is not a, Terry asked me several years ago when I first learned of his case, well, what do you think it's worth? I said, well, Terry, could you?
No! No. What?
If you could turn the earth backwards like Superman, and he says, I'd rather go back in time and never have this.
Not a time turner?
So how
Not a
do we
TARDIS?
calculate this?
Turn the earth backward like Superman?
I'm going to suggest
when your
a number.
opposing counsel looks like Clark Kent? Is that the analogy
This
you
is just a
want?
suggestion that we do it with
Pick
16 hours a
Doctor
day.
Who. Wrong analogy.
About the formulas, Dr. Boehme and Dr. Scher gave you a lot of formulas, but
Oh, this is how we're
hopefully
trying to
these
get
will
to
be simpler.
damages. 16,
Or simpler than all those.
16 hours.
So that's 16 hours a day, year.
Goth Boy UK, you needed to have Superman on your card because James looks like Clark Kent.
Then the next question is the years. Well, it's been 7 years since the crash.
My heart is going to keep stopping if this keeps buffering.
Terry's likely to live
Weather.
another 10 years. Probably, we hope longer, much longer. He wants to live at 130.
Did he just laugh?
At least 10 years. So 7 years
These
since the
parties
crash,
are
10 years,
wild.
that's 17 years. So we're going to times the next number, 17.
My fan.
Then the question is, how much is, not the price, there's no price that you can give for Terry's
No,
time.
the price is not right. You're looking for the
What is the
value.
value that's been taken away from Terry? What is the value? I mean, there are lawyers and experts and lots of people here that are making low wages, but a lot of people are making $300, $400, $500 an hour. Well, I'm
And?
just suggesting a number, and you can put in whatever number you want. This is for the non-economic damages.
Come on
Terry
down,
deals with
Terry.
every day.
Claim your next ski
So-
vacation.
That's the next number. 16 times 365 times 17. I'm going to suggest a number. You put in the number you think is fair for Terry. The full value of the
His
harms
time?
and losses that he's dealing with every day. I'm going to say $33.
Why'd you pick 33?
$33.
Why?
And I've done the math because I told you.
Why'd
in
you
the
pick
opening,
33?
You know, except for the small change at the end, you know, a couple $100.
Small change.
This equation,
$3,276,000 on the nose.
is $3,276,000 for the 17 years that Terry has to deal
So
with
can
this permanent brain
everyone
injury.
stop
Yeah, you could
telling
you could
me
say,
he's
well,
suing for $300,000? He wants
it's priceless. but,
3.2
an old shoe
million.
that's priceless. No, this is the most valuable time of his life.
Are you trying to make a Payless
And it-
joke?
So that's the amount that I suggest you consider. So what is this case not about? It's not about celebrity.
It's
It's not
not?
about that. Yeah, there are lots of indications of that, but this is about a man's life. What does the defense want to make this case about? They want to make it about Terry's multiple issues. The 69-year-old Terry that was on that hill, oh yeah, he had all sorts of medical problems, but the defense
He
wants
did.
to make it about that.
Well, you want to make it about him
But that
changing
didn't mean-
afterwards.
I mean, he was skiing on that hill at Deer Valley. I can't think of any place that I'd rather be skiing than Deer Valley. Maybe, you know, backcountry powder, but the point is he was healthy enough to ski, and now he doesn't
He's
ski.
like, well, maybe backcountry powder.
Now I'm going to
funny.
tell you a quick
That was
story
actually kind of funny.
about the legend of King Morgan.
Oh, God, no.
King Morgan was the real king back in England about 1,000 years ago. Back then, the kings were the law. Someone had a dispute, a farmer knocked
Damn
an
it.
eye out of his neighbor. It was eye for an eye justice. They'd take the eye out of the guy who did it,
Not on my bingo card.
and what did the victim get? Nothing. Well, King Morgan one day said, you know what, I'm going to invite 12 of my nobles, you know, the
Wait, was there a round
guys that have the
table?
littler castles, and I'm going to have them come in, and I'm going to have them listen to a case. And he heard their case. The nobles heard the case, and then they said, well, we think it should be decided this way. And the king said, yeah, you're right, and that's good. So they did it a few more times, and finally the king said, you guys decide the cases. I'm going to go off and do what kings do and hunt and fish and fight battles. Well, that's the same system that was adopted in the Magna Carta almost 1,000 years or 800 years ago.
I did not have Magna
And
Carta
it's the
on
same
my
system that was
bingo
brought
card,
over
but I should
by
have.
the pilgrims that we celebrate
you have
Thanksgiving
ancient Greece,
for.
you're gonna
And it's
get
the
to
same
Magna
system
Carta
in
from one of these
our
lawyers.
country. And we're the only country that still has the jury system where people like you decide the cases. Winston Churchill, the Prime Minister of England, during World
Challenge.
War II, he said, America is a great country. And one of the reasons it's so great is its jury system, and no other country has it. And if you want to weaken America, take away its jury system.
What?
Thank you.
Sir, I challenge on all of
We'll
that.
take a short recess before we continue, maybe about 15 minutes.
Wait, you're not breaking for lunch? They're gonna go through lunch? Oh, they're gonna go through lunch. Because lunch would be now. Huh. I didn't see that coming either. I should have seen the Magna Carta coming. If I had thought about it, I probably would have put that on my bingo card.
Break.
They're trying to figure out how much time they have left. I guess we are taking a 15-minute break, and then we are going to go to lunch. Or no, then they're going to go to the other closing. So For a minute, I might have to bop out, but we will leave this up and running here for you. I thought they would have taken a lunch. I guess what they're going to do is finish closing and then send the jury back for lunch, probably in the jury room, to let them start deliberating. I think we might have a verdict this afternoon. He's going to let the jury just get to it. All right, Your Honor. That's what we're doing. And with that, let's go ahead and give a quick summary of where we are and get to some questions. We've got about a 15-minute break. Sounds good. So this morning, we have gotten through legal argument, jury instructions, and the plaintiff's closing argument. What's coming next is the defense closing argument, and then the plaintiffs will have time for a rebuttal. I'm sure they are working with the court to see how much time they actually have left for their rebuttal. Their closing did some things well and some things oddly this entire trial. We did get to the Magna Carta, milking cows, and the fact that a part of Terry was left up on that mountain, which fell flat with most of the chat. The thing they did really well is going through the jury instructions, and the verdict form, which can be very confusing. It's absolutely critical to do. And I think he did it very well, just walking through, this is how you fill in all these checkboxes, and this is what it means. He also stated that the US was the only country in the world that had a jury system which challenged. I think his historical accuracy was off in this closing, which was distracting to me. But we also learned that Terry is not a house nor a racehorse, and that they are asking, indeed, for $3.26 million for non-economic damages. What does that mean? Non-economic damages means for things other than the bills that were paid for doctors. It is pain, suffering, loss of enjoyment of life. And that's what he's looking for with the non-economic damages. We also learned that the country lawyer, who's like, I'm just a country lawyer, grew up in the city. I thought that was fascinating. That was maybe my favorite part of all of the closing argument today. But they didn't, I think, spend enough time. Chat, let me know. I want to know what you think. Did they spend enough time covering who caused the collision? They jumped very quickly into damages and the impact this has had on Terry. Maybe it's because they don't have much more to say, but they didn't cover enough how this happened. They're like, Terry was hit from behind naturally. And then he said, I could go into more detail, and then didn't. Like, I'm not going to go into more detail. The most critical question for me is not damages at this point. The most critical point for me is still who caused the collision. And they really just skirted right over it. And. They opened their entire closing argument with the fact that the defense counsel believes Gwyneth Paltrow's version of events and just thinks that maybe her truth is not the truth. That's me paraphrasing. And then there was a conversation about a car collision at a Costco parking lot. And he went over to check and see if everybody was fine. And he didn't think they were fine, but they all said they were fine. That story came after, as I go real time, there are things I am remembering that bothered me about this closing. That story came after he said, it is inconceivable that Terry Sanderson was hit the way he was hit by Gwyneth Paltrow from behind, broke his ribs, and then Ski Patrol asked him if he was okay, and he said he was fine. Inconceivable. And then the lawyer goes on to tell a story about the collision in the Costco parking lot and says, I went up to the parties and I didn't think they were fine, but they all told me they were fine. It's like when people are under stress or have had trauma, sometimes they don't perceive that they're not in fact okay until much later. It's completely conceivable to me that Terry told everyone he was fine until later he realized he wasn't. He didn't go to the ER that night. He had 4 broken ribs and did not go directly to the hospital. No, he didn't pass go and go to the hospital. He went home. So what? Why tell the story that contradicts your own argument? Terry, there must have been a cover up from Deer Valley because Terry never would have told them he was okay. Let me tell you the story about people who weren't okay that told me they were okay. What? And then they go on to talk about the fact that from their perspective, Terry was unconscious for 2 to 3 minutes. And that does not square with any of the evidence that I've seen. I don't know if these points will be pointed out when we get back to closing arguments in 5 or 6 minutes, but we will see. There will be a period where I will have to scoot, but you are in good hands. The mods will be here, the chat will be here, and I will be back. So we will still be streaming. I am not taking a break. I might just. I will have to pop out. Tem says, EDB, it's to say if Terry loses, he believed, not lied. That's a fair point. That's a very fair point that, even if the jury doesn't agree with Terry, it's because both sides were telling the truth. Let's get to questions. Connect the dots. I saw in the chat, Emily's. I will be gone briefly, but I have a TV interview that I committed to that was supposed to be during the lunch break, and it looks like they're working through the lunch break, and I'm not going to leave extra hanging. So I have a quick TV interview that I have to go to. But I thought they would be breaking for lunch now and we could just take a quick pause. They are working through lunch, but I still will need to go and honor my commitment, and then I will be back. So no worries with that. Question: how much, if anything, is awarded do you think it will be? We're going to do a poll on that later. I haven't really thought it through very much. Why did Gwyneth Paltrow hire med mal attorneys? James said his focus was in med mal. I wonder if Gwyneth Paltrow had insurance that hired these attorneys, and the insurance companies are very used to working with med mal attorneys. And there are some similarities here when we're doing a highly medical testimony that somebody with a med mal emphasis is very familiar. And James was doing the damages and the medical experts, that this would be a field where he's very comfortable in. But it seems their firm does a number of things. Margaret said, what about when TS said he had multiple personalities and it was Gwyneth Paltrow's fault? I wonder if that will come up in Gwyneth's closing, that he said it felt like the other Terry inside him since this accident. Squishy said, after ALS diagnosis, I went on 8 country cruise. It was exhausting. He did separate trips dealing with airports, driving, camel, impaired, doubtful. And that's the thing. For me, a lot of times I prefer a cruise because I only have to get onto the ship and then the ship takes me to places where I need to go. And it doesn't take as much executive functioning as arranging flights and trips. And it's not even arranging them. I could have help with that. Travel agents are a thing that exist, but it is then remembering to get on the next plane. And I think I would spend half my trip worried that I was going to miss the next flight. It's like when you're ADHD and you have an appointment in the afternoon and you spend all morning getting nothing done because you're worried you're going to miss your appointment and then still end up running late. It's like that. I would feel that way the entire trip if I was plane hopping. Do attorneys get to poll the jury after verdict? Yes. Either one could choose to do so. Some courts just do it as a matter of course. Alexandria said, I used to sing closing time to my son, just turned 1, but sang it with his name. I know who I want to go to sleep. Grace and John, I love that. My kids have to deal with snippets of song that pop into my head quite frequently. And now my teen has started doing it and it's delightful. Terry said, why wouldn't they pick up non-hacking attorney from the team to do this? It's very distracting. I believe the attorney who has the cold, Sykes, was brought onto this case probably years ago. And it is not uncommon that lawyers get sick when they are in trial. Running up to trial, you sleep very little sometimes, and the stress is very high. So the circumstances that lead you to getting sick really are all lean towards trial. So it does happen that lawyers end up sick in trial. He apologized to the jury for it. It is distracting. I think people try not to hold it against him, but it makes it hard to listen. I am going to remind you one more time that we will be on Verdict Watch, this afternoon. If you want to stay in the loop of when I'm streaming, lawnerdalert.com, because I can't always stream, for 15 or 16 hours at a time. So when I need to set up new streams, lawnerdalert.com will keep you in the loop. Marvin said, is he trying to save their side from the court costs by speaking nicely about Gwyneth Paltrow? I don't think so. I think he perceives that the jury found her to be likable, and attacking her would not benefit him. trust. If these lawyers thought that Gwyneth Paltrow was unlikable to this jury, they would have attacked her a little bit more. Instead, they attacked Deer Valley. Deer Valley's the one that's covering this up. It's not Gwyneth. She's lovely and all. You know, she seemed very sweet. I'm sure she's a good mom. They're not attacking her. They might also have done it to point out the difference when Gwyneth's team gets up and starts attacking Terry Sanderson. It might be to juxtapose it. It's like, oh, they're attacking him. That's unkind and unfair. Based off of closing example, it doesn't matter who actually hit who. He believes Gwyneth Paltrow's testimony was his opening line. And that's hard too. Miguelina, I'm going to have to leave in just a few minutes. Can you add your feed? The one we've been using, I will send you the link to. But can you add your feed to stream? Because I am going to have to leave in a moment. Thank you so much. Thank you, Chad, as we do some production. Let's see. Jen Gerard at home today, elevating my foot. Glad to be able to watch closings. Me too. I'm so glad you're here. Why are they using first names? Sykes' office is in a posh part of Salt Lake City. It might be appropriate for this jury. It might be to humanize them to the jury. I think that's a strategic move. They've done it the whole trial. Plaintiff has seen the polling numbers and has seen that an overwhelming majority of those polled believe GP's story. So this closing is an attempt to lean into GP. I don't know. It might be to argue for the tie. Thank you, Emily, for adjusting the window. You're welcome. The snort is distracting. Those types of noises kind of are difficult for me as well. Michael said all he does is ski and scuba dive. Seems like someone who does not suffer from a significant injury. He does a lot of he has been very active. I never want to discount what people are able to do and still be injured. Some people can do things and it exhausts them for a significant period of time. But what I do want to say is the picture painted by his daughters and him, and then the picture painted by all of the pictures of his travel are very different. And that divergence is the problem for me. People can be active and still have injuries. Before my spinal fusion, when I was having horrible back pain, there were still things in my life I had to go do because you do have to keep living. But it took a toll and it was at a cost. And I'm not going to say I can't do that. I did that. And then for 3 days, I was kind of out of commission because of pain. And then you talk about those things. But the picture painted was so vastly divergent that it's a problem for me. With head injuries, doctors give you a list of things to avoid. If you act against medical advice, delayed or incompetent recovery is your own fault. We will see. Obsession will force people away. That is true. And I think we're going to hear some of that from the plaintiffs or the defense when they get into this. Fun perspective. Blanche on Golden Girls was 47. I'm older than a Golden Girl. Blanche was 47 on Golden Girls? Wait, the character was set at 47? They were portraying 47-year-old women as old biddies? That's not fair. I didn't know that. I beg the chat's indulgence. James is Utah lawyer Brendan Urie. We've seen a number of comparisons to Urie, and he does have singing. Terry has been everywhere but on that mountain. Yep. We need a bigger bingo card. Yes, we do. Yes, we do need a bigger bingo card. Closing. GP did it. Evidence. TS said so. Give TS lots of money. Yeah, it's Ipsy Dixit at this point because I said so. Casey Cat said, I love Latin too. Grew up in Catholic schools and had to study Latin. I miss terribly Mass being said in Latin. You and my grandmother would get quite along in that. She did as well. So I'm going to leave this one up, Tech Valor, so we have it. Thank you, Miguelina. Wait. I'm doing this because now I can hear the audio a bit. So hopefully, I know the court audio is kind of muted, but hopefully we get some audio from, let's see, from this if I add it there. Miguelina, if you'll just put audio on just a little bit so I can hear if court comes back. I appreciate that. I've been hearing kind of the white noise from it. Tammy said ADHD, impossible to not overpack because I need options. Every option is painful. Same. Heather said EDB, I agree, but you would think Sanderson would point out that I had to recover for days doing stuff. I agree with you, and that did not happen here. Have you seen video of GP on a scooter almost hitting a bus without blinking an eye? I did not. They were trying to bring that in here. I've heard reference to it. They were trying to bring it in, but I did not see that. The Contralorian said you lose credibility points with the jury if you went all country lawyer repeatedly and then tell them you grew up in the city. Yes. Yeah, I'm just a country lawyer. I mean, I grew up in the city, so not really a country lawyer. Why play that? Why play that shtick though? Like, why is that the shtick you want? Lacey said, ADHD lifer here, also 7-year TBI patient. Please tell me more on milking executive function cows. It was special. It was absolutely special. It was absolutely special. Give me 1 second. Burley just said Sykes covered causation. I didn't hear Sykes talk about causation. It was briefly. The only thing I will remember is TS still being on the mountain and milking cows. And the Costco parking lot collision sticks out for me as well. Mariah said, I may be in the minority. I believe she hit him. That's okay. However, I do not believe that caused such severe behavior changes as he claims. And that's a fair interpretation. Who plans all of his trips he took? They didn't say. So Terry is milking it. Ooh, cat. I like the connection between the two. Maybe you don't want to bring in a milking cow reference when counsel's going to come up and say, you are milking it for cash. You give them an opening. Will Owens drive a bus right through that? I don't know if he will. I don't know if he won't, but maybe he will. I use Google Maps to find my way off the mountain due to my difficulties with executive functions. I use maps to find everywhere because I can't visualize streets in my brain. The milk cow closing, I'd be in such trouble if I was on this jury because I wouldn't be able to contain my laughter. It's fair. Which is more believable, that Terry manipulated 3 women or that dozens of people conspired with a corporation to cover up this accident? And I don't know if he manipulated his daughters. I just think they're his daughters. Raise your hand if you've been personally victimized by executive dysfunction. Chat, I expect to see you raising your hands, chat. I expect you to play along. Expectation that you play along. Half of him is on the mountain. The other half is on vacay in Thailand. Thailand is such a long flight. It's such a long flight. Questions. Do you think they still eat bananas after all of this? It's BANANAS. I don't know if they do. Cannot lie. James saved this for me. He's so clear, concise, and he's adorable. James did save it. And it's a bonus that he also has albums out on like iTunes and Spotify. Closing reminds me of Into Thin Air. If only a Sherpa would bring him a mug of tea. And Emily, yes, ADHD. All can't pack. Yell it, son. Scuba diving within a week of resolution is appropriate. If symptoms go on for a month, diving isn't wise until after resolution of a period of observation and medical reassessment, especially with any symptoms beyond headache. It would seem that scuba diving being risky would be something you would need to consider. Is it possible this lawyer is... No, I don't think so. The lawyers are sick. Everyone in this courtroom is sick. So just filter all of it through Dayquil and the fact that they are in trial. And so in trial, you are sleeping maybe 4 hours a night. So they are running on little sleep. They are sick. It is high stress. And that is some of the quirkiness, and some of it is just them. Amy Yost, from someone who's worked in civil lit for 20 plus years and tried many cases on both sides of the gavel, this is awful. Ridiculous closing. It's odd. Loss of friends, that's only his fault, not Gwenny's. He's alleging the change of behavior is her fault. Janet said, woohoo, just bought myself a hoodie, mug, and sticker. Enjoy the Lawnard shop, Lawnards. And with that, you all, I am sorry that I have to run. Miguelina, do we put up the backing track music? Because we can put up the backing track music while you wait. Let's see. Let's pick one together. But then can you turn it off on your end, Miguelina? I think so. You let me know. Let's see if we want to pick something out. and I will be back soon. Let's see. We got this one. I don't know how I feel about that. We got some lo-fi. I think I prefer the lo-fi. Lo-fi at a low volume. Maybe not that one. This one might be better. Chat, I hate to leave you. I'm going to leave you with a little bit of music and the court feed. I will be back shortly. I will be on Extra. When there are links for that, I will share it. So I will see you soon. I know you're in good hands with the mods. They should be back from break in just a moment. So play closing time. I can't. YouTube will yeet me. All right. With all of that, thank you so much. I will be back very, very shortly. Miguelina, we can also put up a banner if you want to. Let me just do it. I will be back soon. Chat, law nerds, I adore you. I will see you in a few minutes. Hopefully I'll get to see the beginning of this closing. If not, fill me in when I get back. Bye.
Thank you. Are we ready for the jury? We are? Okay. We're ready for the jury.
Can we be clear on time? I think they took a full hour. And do they?
7 minutes left. All right, Jerry.
All right. Thank you. Mr. Owens, you ready to proceed?
Thank you. Just to be clear, because James is going to share the time with me.
Sure.
And is the plaintiff reserve any time for rebuttal?
They reserve 10 minutes, which I grant them.
And so do they have an hour and 10 minutes? And do we have an hour and 10 minutes?
They reserved. You proceed.
Country in this way, just like Lawrence mentioned. You're plucked and really against your will, even if you had to fight it. Peaceful manner. So, thank you. I'm Miss Paltrow's, and I'm going to just call her Gwyneth. I'm Gwyneth's lawyer. I'm her spokesman this week. So she sat there for 2 weeks and been a punching bag. We've blown through a lot of these cute little Post-it notes where she's sending me stuff. But I take it very seriously because she's comfortable in a lot of worlds I'm not comfortable in. But she is not comfortable in this world. It is not a nice thing for someone to throw a press conference and say, like King Kong, you knocked him out and walked away, skied away. That is not what happened. And the court has actually dismissed the idea, and that's one of your jury instructions, that this was a hit and run. That took no small amount of work, by the way, but that is what she was faced with. It takes a lot of courage, does it not, for her to sit there for 2 weeks and be pounded like a punching bag. What did she lose? Did she lose? Oh, that's too bad. You had to come in early and have a massage. No, this is what she lost. She was in love with Brad Falchuk. Dated for 2 years. They both had, very interesting, I think, 9-year-old sons and 11-year-old daughters. It's kind of cool. And they said, how are we going to get these guys together in a loving, fun time? They're very busy, where we can kind of all be together for a couple days and see if this will work, if we can blend our families together. We're going to make it relaxed. We're going to put a lot of planning. She put a lot of planning into that trip. And so here they are. It's a little delicate because anyone who's been through like trying to blend families, it's a delicate thing. So what happened? They got there. They're organized. First day of skiing. They have ski instructors. By the way, I thought it was cool. I don't know if you did. Her dad taught her to ski at Alta. And she has tender feelings about that. She's been tearful with me in describing those ski trips with her dad, because her dad died in his 50s. In fact, it was so painful, she didn't ski for a long time after that because she would miss her dad. But when her kids were of this age, and we're talking with Brad was a big skier. We didn't get to hear from him, unfortunately, lack of time. But they were gonna come, okay, let's get our kids together. So what did they lose? They lost a half day of bonding and even more because now everyone's stressed. That was the day when they bond up going up the ski lift. They bond having hot chocolate mid-afternoon. They bond relaxed, laughing around the fire at night. They lost that because he hit her. He hit her. He hurt her. And then he asked her for $3 million for the pleasure. That is not fair. And I'm grateful that we have a court system that permits anyone to sue anyone for about a $250 fee, and that they can have their day in court. And I think Mr. Sanderson, by all accounts, will have some peace after this trial, regardless. But it's come at a steep cost, a deep cost to my client. I told you when we first met, I wanted to concentrate on a couple things about Lady Justice here. By the way, if I didn't make it clear, you are Lady Justice. All right. Blindfold eyes. Because she's blind? No. She's smart, but she's not going to be distracted by chaos around her. Chaos like media, chaos like sympathy. Oh, don't we all feel bad for him? I would have liked, by the way, at least a discount on the camel ride on your request for damages, but that's another issue. The idea is, okay, we're going to focus. We're going to focus, and we've tried, and the judge has given you all these warnings. Don't be talking to people. Don't even talk to yourselves yet, because we want you focused. And that's Lady Justice. Now, I talked to you earlier about the scales of justice. This is a civil claim, meaning the preponderance of the evidence. The plaintiffs brought the lawsuit. That's why we're all here. His daughters say, isn't it terrible? These two daughters that he's brought here, his life is laid open. It's because of him. He hit her. He hurt her, and he wants $3 million for it. That's not fair. The easy thing for my client would have been to write a check and be done with it. But what does that tell her kids? It's cost of business. No, it's wrong. It's actually wrong that he hurt her and he wants money from her. And that's why we're here. All right. So back to the scales here on Lady Justice. He has the burden to tilt. Okay? Tie goes to her. Now, she has a $1 counterclaim. My wife said, don't waive the dollar, and I'm not waiving the dollar. But a dead even tie means neither get anything. And I'll walk you through that in just a minute. But let me suggest it's not even close. Let me suggest it's like this, the evidence here versus here. And let me talk to you about that. Let me mention a couple other jury instructions. So I talked to you about no sympathy, passion, or prejudice. We don't want you making decisions on that basis. I talked to you about the burden of proof. That is theirs. And then from today, let me talk to you about a few things. By the way, the burden of proof was evident because they get the last word. Because they have to tilt the things, you may have noticed this morning they could call a witness, and after I'm done, they can speak for a few more minutes. And that's what we do to the people who have a burden of proof. Instruction 30 that you were read today. Gwyneth Paltrow did not leave the scene of the accident without giving her contact information. Press conference 4 years ago. King Kong came out of the jungle, left me unconscious, and brushed off and went away. Utterly BS, and it's been discounted. It's not even before you. The judge took that away from you because it was so obviously false. 31 deals with spoliation. That's the GoPro issue. Spoliation is probably a word you've never heard before. It's a legal term. But the idea is if they destroy evidence, you can assume that it was bad for them. All right, so Terry, in fact, I should say Mr. Sanderson, in fact, owned a GoPro. All right. He talked to his daughter that night, 6 p.m., so about 6 hours after the collision. She got off the phone with the understanding that he had a GoPro video of the incident and typed to him, I am so glad that there's a GoPro and that you're okay. All right, no one has the GoPro, but I'm telling you this, if you find that there was a GoPro and that he said, that will not help my case, delete. If that happened, you can conclude that it was against him, that it helped us. And wouldn't it have been nice if it had been around? Do you remember when we talked 8-9 days ago? I said, you're going to hear so much stuff about damages, so much stuff. But if you find that he hit her, you can ignore it. So we heard like a week of testimony about Mr. Sanderson's brain and how he thinks. He does like to be the center of attention. He likes to be in the spotlight. His own daughter said he would be dishonest for money or notoriety. Does that make you like uncomfortable? It makes me really uncomfortable. When Dr. Gibby was up there, he said, oh, he has a great relationship with his daughters. It's like, who? He says, two daughters. There are 3 daughters. You can't just pretend this stuff away. 3 daughters. It's pretty important, isn't it, for a witness to know that he's not in the least good relationship. And why? Because she said he was abusive, and a lot of other adjectives that I'm not actually will defer to you to remember. So Ms. Paltrow is asking for her dollar, but it's not about the dollar. It's not about, think of what her time is worth sitting here for 2 weeks. It's not about the money. It's about kind of ruining a very delicate time in a relationship where they're trying to get their kids together. That's what Terry Sanderson caused her. Pre-existing conditions, oh my gosh. How do we not talk about what was going on right before and what versus what's happened after. He's 76. I mean, my parents, I'm not being flippant, they were dead by then. They certainly weren't taking 10 trips around the world. So we have to look at that. Those are the jury instructions. I do want to tell you the special verdict form that was appropriate. Can you bring that up? Lawrence walked you through it, and I don't think there's any harm in me telling you what I want. Is there? I'm going to ask you to fill this out. This is what you go to the delivery when you deliberate. These 3 pages. The last page really is nothing. So it's essentially 9 questions. And I want to show you how I want you to fill it out. I'm not trying to be subtle. All right, so was Gwyneth Paltrow at fault? No. If you answer no, go to question 3. So next page. Then you have to, that means Terry Sanderson's not going to take any money away from today. If you write no, so no on 1, you are done kind of in terms of his claim. Then you go to paragraph 3, which is our claim. Was Terry Sanderson at fault? Yes. We want you to say yes. Was his fault a cause of her harm? Again, we're asserting $1, but it was so much more. It made everyone nervous all afternoon. Was Terry Sanderson's fault a cause? Yes. And then, James, if you answer, regardless of your answer, go to 5. If your answers to question, so this is like a tax form where you have to like read it 4 times, sorry. If your answers to questions 1 and 3 are both no, 1 was, is Gwyneth at fault? You should not proceed any further. And you go to the end and sign it. And this is because you're trying to figure out, was she at fault? Yes or no. Was he at fault? Yes or no. Did it cause any damage? You can actually find today that neither were at fault. Skiing is an interesting thing. We strap sticks on our legs at the top of a very high hill and go down for fun. It's breathtaking. I've done it. I love it. But it has inherent risks. So the back of every ski pass you've ever seen.
Judge, objection, you've excluded this inherent risk scheme.
We
Uh-oh.
referenced this, Your Honor.
What's
You
our
said I
objection
tried.
count?
It applies to resorts and not to people.
Uh-oh.
No, the argument is improper, so overruled.
So inherent risks, you've seen it on
What's
the
our-
back
what's
of
our
every
objection
ski
count,
pass.
chat?
And even your own common sense
Good to
says,
see you.
hey,
Thank you for waiting for me.
if I don't go down this hill right, I could actually kill myself.
He argued this in
So,
open too, even though he wasn't supposed to
Skiing is
argue.
different. It's
This
even
is his
different than
first?
driving.
Okay, so it's been
I mean, we
3.
don't
We're on
drive
3 now.
cars down hills, right? Down the icy hills. But we do ski down icy hills. The Deer Valley guy would say, we're never icy at Deer Valley. But nevertheless, it's kind of a dangerous thing.
Oh, I'm fixing it.
And so you can actually say no. Don't get me wrong. I want Gwyneth paid for the hardship Mr. Sanderson caused her.
I'm trying to fix the echo.
hit
Sorry,
her,
y'all.
He hurt her, and he's not entitled to sue her. I'm sorry, he's entitled to be here today, but he's not entitled to be rewarded for hurting her. That's not how this country works. All right, James, let's see. Then if we go,
Thanks, Chad.
if your answers to 1 and 3 are both no, you should not proceed further. So if you
I'll
found
switch to you
not
to a
at
minute,
fault, not at
and then
fault,
we
you're
won't have that
done. You
problem
go to the
again.
end and your 4-person signs it. But if you keep going, otherwise continue to 6, James. I couldn't do this without James, if you can't tell. What percent of
Oh,
the
we
fault
can
do you
tell,
assign
sir.
to Gwyneth
We can
Paltrow?
tell.
So then you have to figure out a percentage.
It's been more
It's possible that both people are at fault. And how this works is you take 100% pie and you find out, okay, Gwyneth's 10% at fault, Terry's 90% at fault. So a lot of things aren't just so obvious, like gray and white, black and white. we would, obviously, if you get this far, we'd want you to put 0 apportionment to her, Terry, 100%. I guess you could find that Gwyneth's entitled to 75 cents and not $1, believe it or not. Okay?
So they
Then
could find
we
a
keep
dollar
going.
or less.
Whatever you can.
All right. I switched
Amount
feeds real quick.
compensates Terry, and we just want you to go to 9 and give us our dollar. There was a little issue raised about whether her
think they're going
attorney's
through this
fees could be
well.
added to that. The judge has said, I'm going to deal with that. That's not in front of you. All right? So
could do 1 penny.
your topic is
They-
this dollar.
Chat.
Believability
cheers.
of witnesses.
They
This
can't
was
give
one
her
of
a
your
nickel back.
earlier instructions. How do I figure out who's telling the truth here? And I'm going to put Craig Ramon. First of all, Terry doesn't remember much. There was one just blatant misstatement in their closing, which was Terry could talk to a wall for 2 hours and have a pretty good conversation.
I mean, I
That
probably
was
could too.
before the incident. That was misrepresented as
honest.
being after the incident. Every time that issue came up, I said, before? Yes, before. All right. Let's go to talking about evaluating witnesses. I'm telling you, if we were in law school and we had a class about eyewitness, how an claimed eyewitness is actually
Where are we
sees
going
what
with
he thinks
this?
he sees, Craig Ramon would be the definition of a bad witness. And I'm going to give you some objective statements about that.
Tell me.
He's at the end of the court. He says, I'm skiing,
The world as we
and there
know
at the
it.
end, I'm colorblind.
Melissa, I saw that.
I have imperfect vision.
But I get to be on extra tonight.
I don't know what they're wearing.
I'm excited.
I'm looking at other things. I'm not focused on them. He said he hears and turns. Well, guess what? Eric Christensen, the ski instructor, who they accuse of a cover-up, which was dismissed, heard and turned.
Heard and turned. Turn and burn?
They're the same. They heard and turned. Craig describes himself as an eyewitness. Eric said, I didn't see the collision. I just heard and turned. They saw the same things. Interestingly, Eric came right over, and now's appropriate time to watch our little fun video.
Ooh,
I don't
fun
know if
video.
you like these animations, but we kind of put them together so that you guys can kind of envision all this information coming
Just
at
a
you.
fun little video.
So Eric Christensen, did you like the guy? The guy is like, oh my gosh, I love this guy.
You didn't call him
He's
a
been doing
nerd
it for 40
so-
years. He teaches art.
Do you like
on
him?
the side. He's been a lifelong resident. He's married to someone whose whole life is skiing. And he is not a liar. He is not someone who covers
I also
up.
love a fun little
He
video.
is not someone who falsifies reports. All of those allegations were
And yes,
thrown
today
out.
this was Rose Hill.
So we're not dealing with Deer Valley. Interestingly, it's not just Ramon versus Christensen, because all the Deer Valley people.
Every time he
do you
says
remember
Ramon, I
the
think of Romeo and
cool
Michelle's
Whitney
high
who
school
took
reunion.
The toboggan woman. I mean, she's an amazing witness. She's up there, I'm assessing things all left and right.
I
No,
loved
nothing,
Whitney.
Nothing, but that's a little different. So we're going to play this, and I think Moses is an orange.
I think I like.
And there's Terry.
I think I like
So
Dayquil
Eric
Owens the
Christensen
best.
says he sees Terry out of the corner of his eye. Well, he looks and sees because he's in charge of sort of protecting
I'm in charge
these
now,
kids.
Phasma.
So he says he's always looking up the mountain, and then he hears and turns, and then the next view, the next one.
Thank you, Michelle M.
By the way,
You knew exactly where my brain was.
No one but Craig has the guy spread eagle with his head down the hill. There's no facial damage to his face.
To his
skis
face. Your
stayed on.
face.
You've heard from these structural bioengineering people.
All these nerds.
If he came and got hit like Craig described, his skis would have popped right off. You don't keep your skis when you get blown. Sanderson says he was airborne, that he was flying. First of all, I'm not going to get into the weight, have him sit on scales, but twice, by the way, not once, twice. Mr. Sanderson
That's the
said,
quote.
I'm 3 inches shorter and
What are you
15
doing on the
pounds
mountain,
lighter.
sir?
We're not talking about today. We're talking about then. Then he was 3 inches. I don't know if he shrunk 3 inches since then, but he described himself as pudgy. He's coming downhill at a faster pace. I mean, anyway, the structural engineering people, which is kind of interesting, not structural, biomedical engineering people. I don't know if you got bored in that part or was interested, but I'm telling you, the science does not work for Craig's theory. Okay, so we're going to play this. Mr. Christensen, am I in your way, Judge?
No.
There's Moses, Carrie Oaks, Apple. It's a little hard to absorb, but here's Gwyneth, and there's Sanderson.
Sorry, Chad, I can't.
Now, let me tell you what Sanderson said. And he said it just at the end of the day yesterday. I said, tell me what's going on right before the incident.
That was the visual I needed.
He said there was a lady on his left that was kind of tentative. So I deliberately, I think I said, passing on the right. Pretty sure I did. So there's the woman he describes in green. And he's trying to he's watching her. He is blind in his right eye. He said, I use that term loosely. He's an optometrist, for heaven's sakes. He's blind in that eye from a stroke. He is helping contribute to his retirement.
I'm a professional.
Okay, so he's watching, and imagine this. I'm blind in my right eye, and I'm really mindful of not hitting this woman to the left of me.
You have turned me,
said,
sir. I might be a fan now. Because he just he blew right by it.
Passed on my left, except the gal I just passed.
That was the giggle we needed. Thank you, sir.
I was real conscious of because I still worried about her. And so as I went past her, I went inches per second past her. I just remember it took forever for me to get past her, and there were skis. And then that's when the collision happened. All right, so maybe run it one last time, James.
Owens, he's not funny when he tries to be.
With a blind right eye.
Very funny when
he
tries
he
to
doesn't
not be.
Hit the woman.
I'm glad they're playing these again. I think this is very effective. Oh, shit.
To
Emily,
his
be more
left.
helpful.
And what happens? Gwyneth described, and praise to the judge for not letting this be reenacted with Gwyneth and being assaulted in front of us all.
What?
She is skiing,
sir,
and 2 skis come in between her, and this is not a big hill. By the way, I mean, these are kind of photographs. This isn't just claymation here. And comes in, and she's like, what is happening?
Claymation.
They're not going that fast.
It's an
but Terry's going
animation.
faster because
I would have objected
his
to that.
skis are coming in between her.
I would have objected because it's not a true
looking
photograph.
With his one,
it's an animation.
By the way, he has like half an eye because he has a cataract in the left eye. Hearing's shot.
Amy, yes.
And he says, I'm getting too old.
Oh, I've lost it.
I can't do everything I can. Well, I stopped playing church basketball after my knee injury. I'm like, I love it, but I can't do it anymore. Okay, so sometimes we have to give things up, especially when we're 76 years old. I'm sorry. I mean, that's life.
Both sides have oversold things.
He comes in between her legs. She's going, what is going on here? It's not like a ski collision hit, you're out. And he's
Would that be
grunting,
the blown version
his
of
body's
it?
against her.
Oh, God.
She's thinking, am I being assaulted? Like, because this isn't really a ski collision. And then they go for a little while. She said spooning.
Remember how I
And
said
then-
closing is
and
supposed to
whatever
make
the
things
next
clear?
imaging
next animation would be.
Is this making
James.
it clear for you?
And then they go to their right. Now, I don't know, you've heard the ribs issue. By the way, if you're 76 with osteoporosis, you can break your ribs. You may see in this records in your documents, these weren't dramatic breaks. I mean, two were not even distended, dislocated. What's the right word?
Broken ribs suck, Owens. Don't downplay the broken ribs.
Place.
Back up.
Thank you.
Back up.
Two
Danger.
were not displaced and two were just very minor displaced. Did they hurt?
Have you ever
I'm sure
broken
they
a
hurt
rib,
them.
sir?
I'm sure they did.
Danger.
All right,
Danger.
so she is on top. Eric Christensen said she
Don't
was on
downplay
top.
the ribs.
And their skis are intertwined.
Not blown.
And what is she doing? She's like, okay, I see I'm not being assaulted. And he may well have hit his head. He does have a helmet on. So does she, by the way. Craig Ramon's like, no helmet. He tried to change his testimony on the stand, but I had questioned him like 5 years earlier. No, she didn't have, I was really surprised. No helmet, no mask. Give me a break. For anonymity purposes as well as safety, this is a person skiing with her kids. She's pretty focused on safety. Let me just tell you that. All right. So what's the first thing does? Eric Christensen, is this the last one? Is this the last of the
There were only
animations?
3 admitted, Judge.
There
Only 3 were admitted.
I think there were 5.
3 full ones.
3.
Whatever you can take us to next.
James, whatever you say, my guy, we're in your hands and we trust you.
Videos that were
Eric.
that were
Some in the
entered
chat want to be in your
their
hands
total,
more than
and then there
others,
were two
James.
Only partial. Is that right?
Correct.
Okay.
So whatever you can give
Two
me.
partials that didn't show the actual impact.
They want the
Only
full
Craig
impact.
has their heads downhill.
They want the full
Moses,
impact, James.
who
Give them the full
you'd
impact.
love him if he's a cute little 16-year-old now. But we didn't get it. We only got to hear him.
Sir,
He skis over
Owens,
because he doesn't hear anything.
you're
but
on a time.
His instructor comes
Bring it
over. He
back.
comes over and he sees his mom on the ground. Now downhill because she's gotten away from this guy. Okay, I'm safe. The idea of an assault just entered her mind. She said for a couple seconds because she's going, "What's going on?" This is the overhead view and run it as you can. Here's Miss Paltrow.
Just run it and run it and run it.
Apple Moses. Here's Miss Paltrow. Here's the beginning skier woman. Here's Sanderson. And she's making these small turns on the right. He's making big turns. He's a lot faster. He's a lot more advanced skier, I should say. All right. Here's Christensen. You remember we placed him. Carrie Oakes went on ahead with Apple. Apple told me she heard a commotion, but she was hangry for French fries, and she just wanted to get down the hill.
Relate.
Moses is here. And so there we go.
I like where Apple's head's at.
Any other animations?
Apple's like, it's time for fucking lunch. Me right now. Me right now.
Looking uphill.
Owens has been delivering on the entertainment
Paltrow
this
in
afternoon.
black. Sanderson. Beginning skier in green. Woman.
How do you know
Watch
woman's
Sanderson,
a beginner? Rude.
And then we're done. So it's probably that third one, that 2 back, that's probably the most powerful of them in terms of showing you the layout. All right, how am I doing on time, folks? I want to leave James 10 or 15 minutes.
If you say powerful
30
impact,
minutes so far.
we're going to lose it.
So I'm going to.
He asked the judge.
Thanks, Judge.
Your Honor, how we doing on time? What the fuck is happening?
After they've separated, Brad
I've given up,
Paltrow,
and now I'm in love. I've given up. I love
comes
it
up,
now.
She skis down.
I love the
but
quirkiness.
there's then this period of time.
I'm
so
here
here's
for it.
Eric Christensen.
We're just going to be delighted.
Eric Christensen said, I came over to find out what had happened. They say he came over to bully him. Deer Valley employees who
smiling.
bully their guests get fired. He's been there 40 years. You could see if his grandfatherly demeanor makes sense under Craig Ramon's story. It doesn't. It doesn't.
Well, he did lie about giving
Eric
the kids
comes
candy,
over
though.
and he says, first thing I'm doing, I'm taking off skis. Remember, under all stories, no skis came off.
I wonder if Gwyneth
That tells
Paltrow's
you
kids were
something about
rushing to get French fries
the
so she
manner of
wouldn't
the
stop
collision,
them.
doesn't it? It wasn't like Ramon describes,
It wasn't a
flat out straight.
Deep impact.
By the way, Ramon, oh my gosh,
It
he
wasn't a
says he's
hard
out
impact?
cold for 2 or more minutes.
He did say that.
Do you know what did you do about it? Nothing.
Which is, I find unbelievable.
Could you imagine looking at an unconscious person
For 2.5 minutes, face down in the
splayed
snow,
out, head down,
face down.
skis on for over 2 minutes?
I can't.
Could you imagine?
Good point.
Did you call 911? Did you check for breathing? No.
Did you scream at the ski instructor? This man's unconscious.
Good grief. Give me a break.
Oh, sir, back it up.
All right.
We were doing better like 30 seconds ago.
Eric Christensen comes over and says, okay, let's take skis off.
He's
Remember,
letting you
he
know
had
it's
some
utter
personal
BS.
knowledge because he knew kind of where Gwyneth was, and he kind of knew where Eric Christensen was. He knew where they were, downhill versus uphill, and he knew their skill level. He could tell, he said he could tell because Mr. Sanderson was an advanced skier because he didn't slide. I didn't really know this, but if you do kind of, you skiers will maybe know. If you can work your edges and you don't slide, apparently that means you're a more advanced skier. Okay, so he comes over, he's trying to figure out what's going on, but he
I've been
actually
rendered
knows some
silent.
things.
I don't know what to say.
Gwyneth is pissed off. If you hit someone, do you yell at the person you just hit? No. The hittee, and I've been hit skiing, is usually the unhappy one. But she recognizes these things happen until he says,
Yeah, she
you
was
hit
clearly
me?"
pissed.
And she's mad because not only has he hurt her and hit her, but now he's saying,
Lisa, it's a
"No,
good point.
I think you caused this." And then she's like, "Are you kidding me?
That's not what she
You
said.
just ran in my effing back."
Say it.
And Moses heard it.
I want to hear Owen
Moses
say
heard
fuck.
it.
Chat.
All right.
I want it to happen.
So then
I want to hear Owen say
who I
fuck.
think
Just
is just
do it, Owens.
a fabulous witness. I think everything he
Release.
said is just utterly true.
Cursey words.
It's consistent with everything. He took off skis. I said, was Sanderson ever out cold?
No, go to the other camera
No.
angle. I just want to see Sanderson.
If he was, it would have been like that. Gwyneth, was he out cold for 2 minutes? No, he wasn't out cold at all.
I know he's not going to swear, but I'm still rooting for it.
Don't you think people would be going like crazy if there was a man splayed out on Deer Valley, head down, out cold for minutes? That's not a believable story. Eric Christensen now is engaging people. Gwyneth's mad, but she's okay in the sense that she doesn't need help. She can still ski, but she said her knee, which she'd already had surgery on, hurt.
No, I know he's not
And
going to
she
swear.
has sustained a blow. I mean, I don't know if you've ever been hit, even if you're in a football game and you're all padded up. She had sustained a blow. She was upset. And then this idea of him not sort of, she says, you just did this. And then what did he say? I'm sorry. Does the person who got hit say they're sorry? No. The hitter says, I'm sorry. And he said it. I'm sorry.
Yeah, I can't recover.
Sorry. Okay, now she's okay. Okay. He's not denying the stupid thing he just did. But okay, now we got to sit around and kind of we'll sort things out. Then Eric Christensen goes to
I prefer
Sanderson.
this camera angle. Go back. No, Owens isn't going to swear. I'm just rooting for it because Gwyneth
Tell me
Paltrow
what you want to
swore.
say. And he said, She appeared right in front of me. That's what he said in his report.
I just
She
wish he had said
appeared right in
victim
front
instead
of
of
me.
hitty.
That's consistent with Gwyneth being mad and saying, you just skied into my effing back. And it's consistent with Christensen seeing kind of what was going on. He was the uphill skier. He knew that. And there you go. That's, if everything's consistent. Now, if he'd said, I didn't do it, she hit me. Okay, whoa. Now we got to investigate. And then you recall,
Sir.
Okay, it's clear who did what.
No, that was not
Christensen says to
clear.
Ramon, your buddy just took out Gwyneth Paltrow. I think this was just after she skied away.
But I do like being able to see
And
Sanderson's
what did
face.
Ramon say? Did you correct him? No. That's the time to say, no, I saw it. And she hit him. That was the time. Ramon didn't say a word.
And
He just
Ramon
sat
didn't
there.
tell Ski Patrol that Sanderson
He's
was
not helping
unconscious.
his unconscious friend, and he's not denying under his story what the ski Deer Valley representative has just determined. Your buddy took out her. All right. So that's the time to do it, not later. Remember, one of the things I said in opening is rely on the evidence before there's thoughts
Did he pull out a dollar yet? Did he pull out a dollar yet? Where did my dollar
People
go?
aren't thinking, okay,
Where's my dollar missing?
10 minutes later, oh my gosh.
Where's my
Gwyneth
prop?
Paltrow.
Did he pull out a dollar yet? Did I
Wow,
miss it?
that's something else. We were just in a collision with Gwyneth Paltrow. Now people are thinking, okay, wow, I'm famous.
Wait, his wife told him not
They're
to?
not thinking that yet. In real time, he's saying, I'm sorry. And then, are you okay? Everyone
Okay, I kind of
always
love
asks
that.
this question.
I kind
"Are
of
you
love that.
okay?"
His wife told him not
And
to.
he said, I'm okay.
Okay, I
And
kinda-
we tried
I kind
to
of-
change
I
it
kinda
a
love
little
that.
bit, and we had to go to his transcript. But he agreed.
I missed
He
it.
said, I'm okay. And then ski patrollers come by. So, I mean,
I missed the dollar.
there would have to be a pretty vast conspiracy against Deer Valley for this to be a cover-up. And remember, they were already
That's kind
dismissed.
of endearing, actually.
Ski patrollers come by. They see some stuff going on. Everyone all right over there? Eric Christensen did not answer that question. Because this is a contact now between injured skier and ski patrol. Eric's a ski instructor. And so what happened, Eric? He said they talked. So this isn't, we're not in there like trying to bully someone.
We?
Craig spoke to Terry privately. He said, Eric said, I couldn't hear it. And then, which obviously Terry at some point said he remembers Terry saying, are you okay? Are you okay? So there's a connection. And then what did they say? We're okay. And the ski patrollers left. All right, so that's what's happening in real time. Now we go to the paperwork.
How long has he been closing? Because he's still on causation,
Why
and I
don't
appreciate
we-
that he's focusing on
Why don't we
causation
fill out
more.
a big deal, get everyone's statements and everything? Because
he
if
said he was
this
okay.
happens all the time on ski resorts. If everyone's okay, I mean,
Ramon was in court earlier.
we don't have a scene about it.
I don't know if he
But
left.
They go down a little longer. They know that
40 minutes of him
that
wandering
Ms.
around
Paltrow
this
was
first part of the facts.
collision.
That's rough.
And then Terry, and you can believe him, but they now know I'm not skiing too well. I don't feel that well. All right, fair enough. It did come 10 minutes after they found out who they had been involved with. All right, bring in Whitney. Whitney's an awesome, geez, I thought she was a fabulous witness. She pulls up.
She seems
and
like a kind of awesome
she's all
human.
business, like, okay, I'm going to assess for unconsciousness. No. What happened? She says, what happened to Terry? He didn't say, I got hit. He says, I don't remember. I don't know.
I like that he's spending most of the
Did
time
Craig-
on
immediately
Causation, though.
go in on that?
And James will do damages a little bit. I don't think.
We'll have to defer to a report. That was a legitimate question of mine.
I don't
I'm trying to remember.
Think, I
James,
don't
when are you up?
think now. I don't think plaintiffs spent
Are you
enough
up in 5?
time
I can do that.
on causation.
That gives you 5 or 10.
Gives me 15.
We want 15 for him. We love that for him.
Thanks. I'm gonna be done in 5 minutes, folks. Okay. So Whitney's delightful, loads them up, takes them
I'm
down,
just here
says,
for it
hey,
today.
before,
I'm
I
just
want you to
here for it
remember
today.
5 things.
I have given
And
up,
this isn't like man,
and
woman,
I'm here
dog.
for it.
This is like, I got my degree in Michigan. I was Deer Valley Grand Slalom.
Can somebody
person,
explain the
whatever.
man,
All
woman,
these
dog comment to
really
me? I don't
detailed.
get it.
I like horses, my horse's name, all this stuff. Remember it. Terry says, I remember. I knew I
okay.
was now having a cognition memory test performed upon me. He goes down and she then says, do you remember? And oh my gosh, he remembered. In fact, he remembered so well, he decided this is a good opportunity for me to text and post a picture of Whitney smiling.
Not texting.
And just talk about how
Posting.
wonderful she is.
Not texting.
Whitney, meanwhile, is sitting there trying to figure out, okay, are any problems here? Are you seeing any signs of concussion? No.
Blue smoke. Yes. This.
I'm not.
Blue snow 24. Blue snow 42.
Do you remember
That.
Dr. Edgley? I don't know if you thought that was cool that a
Oh,
guy
it's just growing on me
who heads
too.
up the U's acquired brain injury clinic
I think he
has
does better
had
on
an
Dayquil.
acquired brain injury. I thought it was kind of cool. Anyway, he goes, what
You
do you
didn't
look
call
at?
him
You
a
look at,
nerd, though.
period of unconsciousness. We have Craig versus all these people saying he wasn't unconscious. They even imply like Christensen didn't even care about us. He's yelling at us, he's bullying us, and then he's abandoning us on the conscious, drooling on the mountain. Give me a break. Is
Oh.
that what you know Deer Valley
He's
to be?
not convinced.
So, then, okay, he checks out at the main clinic. Then he's down to the
Ian.
Instacare. What is that Instacare PA looking? He's looking for, no, I don't see any signs of symptoms of unconsciousness or concussion. Because they're looking at memories, they're looking at periods of unconsciousness, and they're looking at, what was the third? Do you recall?
Wait, you get to phone a friend in
Memory.
closing?
Ataxia.
That means
You phone a
inability
friend to
speak. So I don't
opposing
think that is
counsel?
what they were looking for. In any case, they're looking for any signs and the symptoms of
I love that Sykes just
concussion.
pitched
No.
in.
Now, that doesn't mean he didn't have a concussion, but it does mean this isn't anything severe at all. I mean, okay, next day he goes to the VA. These are the people he knows. CT, guess what? They're like all the same abnormalities as you had on your brain before. The problem is, and by the way, he then goes for 3 neuro assessments. And they all say normal to above normal. In some
The
ways,
sidewinding
really
is
above
hard for me to
normal.
follow.
So no assessments. Those are all his treating providers. Why would we have our experts go do neuro assessments when 3 separate treating providers that he knows and trusts and that no one's paying say above normal?
Ooh,
Why would we do that?
Sanderson's saying things under his breath.
But the problem is he then goes to Gibby and Fong.
Leave this.
And he just
leave this angle.
self-reports. Everything was normal beforehand. Wrong. And now everything's terrible. Wrong. Doesn't tell him he's flying all over the world, that he's biking, that he's the poster boy for a fitness at age 75. He's posting every darn thing. I mean, this isn't like me sending out a private investigator and trying to find pictures. All I have to do is put Terry Sanderson. Oh my gosh, the guy's Mr. Activity.
He's a
Heaven help
poster.
me if I can be as active as he is at 75.
Put it in the burn book.
All right, I have 1 more minute. I'm going to go back to Lady.
How are you
Lady
able to keep
Liberty.
time like that?
So we talked about the blindfold, Lady Justice, excuse me.
Oh, Lady
We
Justice
talked
came
about
back
the blindfold, and we talked about
The shield and the sword.
The scale. The sword.
It's a good Pokemon series, Sword and
The
Shield.
sword, we want you to use the sword. This sounds harsh because we're not beheading anyone. The sword is to defend a meritless claim. This is a meritless claim. You don't throw a $3 million bombshell in the courtroom,
3.26.
call her King Kong, and walk away. You shouldn't
trying
reward
to.
that. And Gwyneth, who could have just paid it out, paid the
In the
ransom.
audience asleep.
No, I'm not doing that.
He called it
I'm not going to have
ransom.
someone hurt me and then ask me for a lot of money. I'm not going to do it. I'm going to sit here. I said, you're going to have to sit here for 2 weeks in Park City. And you can't even look at your phone.
She has
And
been.
she said, I'm going to do it. I'm not paying it. We
It's
asked
good
you
argument.
for the dollar, not because she had to go in and get an early massage, but it screwed up a very carefully planned, important time in her life.
Say
Thank
she's
heavens
standing in the
family
truth.
melded well together,
She's standing in the truth, and even opposing counsel believes her.
but we want our dollar. Thank you for your time.
She is standing in the truth,
Coach, briefly.
Sure.
and even opposing counsel believes her. They're approaching. Are they approaching on time? Because he has a stop clock on his phone. I think they're approaching on time. Hi, everybody. Good to see you. I think they're approaching on a time issue. Thank you for your chat's indulgence. Chat, I begged your indulgence. I had to go. I promised I would go do an interview that I was really excited to do. So tonight I will be on extra talking about this case. I was happy to go do it, but thank you, chat, for letting me come back and stay with you. Yes, I will go look at the beginning of Owen's closing when we're on verdict watch and the juries go out, and then I'll answer questions. So thank you all.
Mr. Egan, you may proceed.
All right, thank you, Your Honor.
Hello, James.
Are you guys hearing this? Okay.
Can you believe what counsel said? You can't keep your skis on.
Okay, so
I know they're approaching
it's
mid-close.
my job
I've never seen it.
to talk about Mr. Sanderson's claim
It's
that he's not
just-
living the life that he used to live, and it's Ms. Paltrow's fault. Hope I can be helpful to you.
I think
As we
he's the
walk through
perfect
some of
attorney to do this on the
I wanted
team.
to start by just pointing to this document. This, you
Christy.
remember, Whitney Smith was the ski patroller that arrived and wrote this report that day. A little bit later, Mr. Owens could not recall an important fact. This is the witness section at the bottom is not filled out. Mr. Ramon did not.
I would too.
come
I would be
forward and
watching.
say,
I would be
"This is
watching
what
Owens
happened.
and
Let me
Paltrow
tell
during
you about
closing.
it."
They can see them both.
Whitney Smith would have written that in there if he did.
I would be watching both parties.
She also pointed to, we also pointed to the fact that she did not write an X at that concussion and head boxes where she could have noted possible injury.
This is a good use of exhibits,
To use one of Mr.
James.
Sykes' phrases, she has no dog in this fight. She would have put X's there if she was concerned about that.
Good
She didn't.
exhibits.
You
Address
also
that
heard
it's not
her
a cover-up.
talk about mild disorientation in her report,
She did.
and that shows up here. And I think you've seen that the point. Gosh, I'm sorry. I'm sorry. This thing can be finicky. You've seen it. I'll just move forward for the sake of time. There's those mild disorientation notes, right? And she explained that she didn't see that as indication of concussion. She just saw it as being kind of rattled from a ski collision. And that's relevant to damages because Mr. Sanderson is claiming that he had a concussion, and all of the symptoms that have come from the collision relate back to that concussion. I think there's considerable doubt that he even had one. He may have, and you could certainly find that, but you might find that he didn't have a concussion. I think, though, that I want to kind of frame this with a certain theme. Maybe you've seen a pattern over the course of these last couple weeks, or the last 2 weeks.
It feels like longer, James.
On the one hand, you have real events.
We
and then
understand.
On the other hand, you have embellishments. On the one hand, you have objective tests, and on the other hand, you have subjective reports. On the one hand, you have what happened, in the past, and then on the other hand, you have perception of what happened in the past. The realities of life, sometimes difficult
Alan,
realities.
I applaud this.
And on the other hand, you have anxious exaggerations. I think Mr. Ramon took the reality of the collision and spun it into an attention-grabbing story for friends about dramatic injuries and celebrity. He was talking a lot about that. Ms. Smith overheard it as she was caring for Mr. Sanderson. And then there were those comments that we found in the middle of trial where he talked about it, and you heard him explain that he'd been talking about it with friends. He knew a lot about Ms. Paltrow. He was very interested in this. I think he took that reality of the collision and embellished that what happened, what he saw. And Mr. Sanderson's taken the reality of his aging body and he's turned it into a profound injustice perpetrated by Ms. Paltrow. It isn't that. The facts show that his health challenges started long before the collision, and they've progressed in a predictable way. I think you heard Dr. Hesh yesterday say, if you look at his medical records, you look through the history, you take the collision out of that timeline, it reads coherently. The prior stuff would predict the next stuff. You don't need the collision to explain what happens afterwards. It's not to say that he didn't have injuries in the collision. Nobody disputes the broken ribs. And those were certainly painful. They did heal.
James is easy to follow.
And then the concussion, if he
He's
had
clear,
one, was very
he's
brief. As you
linear.
heard multiple experts say yesterday, and had very mild symptoms that may have even resolved within that day.
He's
so
easy
even
to
if you
listen
find that Ms.
to.
Paltrow caused the accident, I think you only have
He's not
sufficient
overly
evidence
dramatic.
to find damages that relate to those broken ribs.
I like
and
James's court presence the best.
Concussion that resolved very quickly.
Of all the attorneys we've seen in this case.
The slow degeneration of bodies is hard to accept, and mental health challenges are hard to face. It's obviously human to want a concrete explanation for these difficulties. But as the court has instructed you, Mr. Sanderson should not receive the money he asked for if you find that his perceptions do not match reality. The law requires that he convince you that more likely than not, he has suffered real harm, that Ms. Paltrow is and that Ms. Paltrow is the cause of that harm, and he has not done that. Through the course of the trial, you've seen that Mr. Sanderson does have genuine problems, and I don't want to minimize that.
Good.
Experts from both sides have talked about his anxiety and depression and the trouble he's had with family and relationships before and after the accident. We've seen brain scans. Dr. Black came in here, and he was the only expert, I believe, that took you through all of them and explained how they.
And I liked that
back in
expert as well. I thought it was really
looked
helpful.
Very similar to what you've seen going forward.
Yeah, I bet the jury likes James
connected
too.
to abnormalities related to aging and other conditions that might explain his problems. But Mr. Sanderson's argued that you should believe his experts because they evaluated him personally. The problem, I think, with that argument is that, as you've learned these past 2 weeks, these experts didn't carefully review his medical history, and they relied heavily on his unreliable reports about it.
Yeah, and
they
I
also
appreciate
want
that
you to believe what they've been calling the before and after witnesses.
Kindly
the
attacking
family
the
and the
damages
daughters,
with
the
empathy.
daughters,
It comes across
friend,
better
and
than
then
just
the
a
girlfriend.
really
And
angry attack.
I think that you've learned these past 2 weeks that they didn't know Mr. Sanderson's health as well as they thought they did. And he was
true.
actually, they had, I think,
That's a good
acknowledged
point.
that he's good at hiding some of those issues, maybe totally understandably, and reluctant to share his troubles. So you have objective facts and then subjective reports. And the law requires you to find evidence, reality, not just the perception of problems.
Also,
From
I don't
our
want my kids
experts,
to know
you've
all
heard
my
a
problems
consistent,
either.
compelling account
I get that.
that Mr. Sanderson had these problems before that the concussion occurred, potentially, again, very briefly, if at all, and that those conditions that he's experienced afterward that he attributes to Ms. Paltrow are the predictable consequence of that prior history. They were, you heard them all yesterday. I guess you had Dr. Edgley the night before, but you heard them all, and it's a coherent, consistent story. I think you got a sense that they've read the records carefully, the objective records of treaters who have, again, no dog in this fight, just reporting what is going on for many years before and after the collision.
I need a better analogy for no dog and a better idiom for no dog in
I
this
have
fight.
till 25. Yes. Okay.
He's like,
5 more minutes.
time.
I got a lot. I'm not going to get to all of it, but again, I'll try to get to the helpful stuff.
I think they did cut time a little bit because he is really trying to
Mr. Owens went through
decide on the fly what he's
various
not going to
evidence about
say
loss of
because they are
consciousness,
at a deep time
and the
disadvantage.
different witnesses that have
Chat, we need a better idiom.
persuaded you that Mr.
For
Sanderson did not
no horse
get
in this
knocked out
race.
for
Much
multiple
better.
minutes.
No
But
axe to
Dr.
grind. I
Eastwell
like
gave
it.
you some interesting testimony yesterday.
No
She
hamsters
said
in
that
the wheel.
the medical records
No skin
after
in
the
the game.
accident
Thank
are
you.
actually inconsistent with serious concussion injury. There was the cognitive assessments.
Lawyers
she
use
pointed to
dog
that
in the
were
fight
normal.
so much.
There was the balance assessment that was normal. You wouldn't expect it to be normal. And then there was the alcohol intake that actually increased, even though a concussion would reduce
Marvin,
your
I like that
tolerance
one
for
too.
alcohol. Again, careful looking at the events in question, which I don't think you heard plaintiffs' experts do. Mr. Sanderson's perception is different, obviously. He not only thinks he was knocked out for minutes, but he said he had a profound cognitive trouble during this time with Miss Smith, who said he was cognitively intact, could speak to him. He was writing articulate posts about her, could carry on conversation for hours. So you got careful evaluation on the one hand, and then you have extreme exaggeration on the other. And the law requires you to be careful in your evaluation. Mr. Sanderson sees the time immediately following the collision as a grim period that began a spiral, began spiraling his life out of control. I think he described the bright side before and then the dark side afterward. And I think it's important to recognize
he became a
that,
Sith?
As we've probably told you too many times, a few weeks just prior to this collision, he was reporting some of the symptoms and the concerns he's saying connect to the collision, right? He's said he was getting old all of a sudden.
Why are we so
couldn't do
zoomed in
things
on
that he used
James's
to do,
ear?
Get preoccupied
Thank
with
you.
paperwork and other little things. And that's difficult. And I don't mean to make light of that kind of reality that aging brings upon all of us. But it's important that at that time, there was no litigation. He's just reporting. And you heard from experts that point to that as a telltale sign of the kinds of things you would expect after the collision that he's attributing to Ms. Paltrow. Mr. Sanderson's told you that the collision forced him to be a recluse. And if we had time, I would pull up those pictures. We went through a lot of them, and I hope that wasn't overboard. You got a sense of just how much he has done since the collision, traveled more than some people have traveled in their whole lives. And I think it's that this $3 million, I don't know where the board is, $3 million claim, I think doesn't acknowledge that reality. Mr. Sanderson is better than he realizes that he is. And it's not that he doesn't have problems, it's just that he is better than he realizes he is. And it's hard for him to accept some of the decline that he's experienced. And he's, again, grabbed onto this collision as the event. An explanation for it.
Yeah.
You've heard from Dr. Hesch and Dr. Edgley about how litigation contributes to problems like he's had, and you heard even from his own expert, Dr. Goldstein, that he's obsessed with this case, and it's not good for him. That moving on.
I thought that was powerful testimony too.
Helpful for him, and I think that we all want resolution to this case. Mr. Sanderson's asking to be compensated for a ski injury that the evidence shows that he himself caused. And the evidence also shows that his life is not the mess he perceives it to be.
Thank you, James.
Ms. Paltrow wants him off the mountain too, but she should not be responsible for the cost of that. And so we leave you with that argument. Hope that you can, hope you're persuaded, and thank you for listening.
Thank you, James.
Thank you, Mr. Egan.
We appreciate you. He went after the plaintiff with dignity and compassion instead of just straight attack, which is appropriate.
Thank you.
And I think it was very clear and helpful. This has been a strange trial, to say the least. Owens was somewhat endearing during closing.
We appreciate the time and attention that you've spent with us the last couple of weeks going on kind of this journey.
Wait, they've got 3 lawyers closing.
A lot of hubbub about this. You've seen a lot of technology. Some has failed, as we've seen today, but some has worked. And through all of
I think
that,
I like him
wanna
best on
remind
the
you of,
defense side.
Jury instruction number 24. Okay. And it says, when the lawyers are giving their closing arguments, keep in mind that they are advocating their views of the case. What they
Okay.
say during closing arguments is not evidence.
Why is this the focus?
If the lawyers say anything about the evidence that conflicts with what you remember, you are to rely on your memory of the evidence. If they say anything about the law that conflicts with these instructions, you are to rely
He sounds like
on
he's
these
already rushing
instructions.
too.
Now, you've heard some pretty amazing narratives, a spin on the facts and you could probably say it cuts both ways, both sides. But I want you to remember about this case that there are two stories here. One is Gwyneth Paltrow, and you've heard her defense attorneys lay out her case. You've heard her side of the story. But there's also another side, and that is Terry Sanderson. They've done a really good job of telling you about what Craig Ramon says about how he describes this whole thing happening, and what Gwyneth Paltrow says, or what Eric Christensen says. But the two stories that are important to remember are Terry Sanderson's and Gwyneth Paltrow's. Terry remembers skiing down the mountain, hearing a scream directly behind him, and then bam, as he put it, lights out. Okay? He's knocked unconscious. He's left on the mountain figuratively, as we've talked about.
You've also said literally
He's
left.
trying to figure out what's going on. When he comes to, it's chaos. He doesn't really understand what's going on.
And he doesn't remember.
On the other hand, we have Gwyneth Paltrow, who says that she's skiing along and all of a sudden she gets hit from behind. It's up to you now to weigh that evidence, to see
His future is in your hands.
what you recall, not the way that the attorneys characterize the evidence, but what you see in the record. And I will tell you that what you see in the record corroborates the story of Terry Sanderson. Terry Sanderson, I just walked you through his tale of what happened. Okay,
I wouldn't call it
versions
a
of
tale if
facts
he's
that
my
happened.
client.
When he's hit from behind,
The truth.
he has to
You
rely
call it
on
the
the one
truth.
person.
When you call it his
Remember
tale,
that. The one person
I'm
that says that they saw the actual
concerned.
collision and saw what happened. He has to rely on that. But it doesn't mean that it's not part of his story. It means that
His
he's relying on
story?
an eyewitness that corroborates what he said. Also, we
What about
have
the truth?
the meetup group post that's been talked a lot about, and the comments to that post.
That's odd.
Contemporaneous evidence the day of that corroborates the story that these two have shared with you. It says, and in Craig Ramon's own words, says, it scared the hell out of me. It scared him. Scared what he was scared. So that might be an account that you weigh as to why he didn't step in to try to give life-saving or life-supporting measures to his friend. He's scared. He doesn't know what's happening, and the person that he's relying on to take charge of the situation comes over and starts screaming at him. It's also important to remember that Brad Falchuk, who we didn't get a chance to hear from, and Carrie Oakes both contradict in major ways
So, Your Honor,
his
he
story, his
cannot
testimony.
reference the testimony of Brad Faltrow.
Oh, there's
He
a
admitted, Your Honor, and that was
Just a minute.
there's
He
a
admitted, Your
fourth
Honor, that he did
objection.
not see it.
Your Honor, that testimony is
Just
not.
Just a minute. Just a minute.
fuck,
Yeah, that's
stop.
true. That was a stipulated fact.
That's a stipulated fact. So
Thank you.
Brad Falchuk did not see it. Okay. Eric Christensen, in his own reporting, didn't see the collision. But yet, right afterwards, he injects himself
So your phone's
into
hitting the
this chaotic
microphone.
event and, according to him, takes control. He has enough time.
They stipulated
Think
it.
about this when you're weighing believability of testimony, okay? Eric Christensen has enough time and is all aware about the students that he's being paid to watch and to teach how to ski that are beginner students. Watch what someone's doing on the other side of the run at the same time with, as reported in the fact show, many people skiing on this run. It's a converging run that goes down to the bottom of the run where people can go and have lunch. He has the ability to pay attention to a young child who he's teaching, someone across the way, someone skiing, supposedly out of control, and keep track of all this. He hears a scream and looks over and sees, as the animations that you've seen, sees him laying on the ground, or sees these two people laying on the ground. He then has enough time to be the first on the scene, supposedly, after telling Carrie Oakes, take care of the kids, watch them, because I got to go over and take care of this.
The kids just wanted some
And he
French
does that
fries. I've
all
never
in
related
just
to anything more.
Fractions of a second. Is that believable? I'll leave that to you to decide. I know the way I feel about it.
Maybe
So
tell
this
them then your
witness
client is telling the truth
who
instead of calling
the
it a
defense
tale and a
has
story,
said,
maybe.
This grandfatherly, who's this perfect witness, is not really that perfect. Again, I'll leave that for you to decide. Now, a lot's been made.
They get to decide, but you get to
what
argue
Terry
to them
Sanderson
what
was
they should
saying or
decide,
doing
though.
after the incident.
I love that he's
Right.
like, I'm not going to tell y'all what to do.
You've
Good
heard,
luck.
and I don't want your eyes to
God
glaze
bless.
over. That's why I'm not using any of the props. I'm just talking to you. But
I love a prop.
you've heard a lot about this email, right? The email Terry Sanderson sent later that night, or the first email and then the response back. Okay, and I want you to remember this.
I'm
The GoPro
famous.
incident,
At
or the
what
GoPro
cost?
video, I guess. We'll talk about this GoPro email.
How much time do you
Is a
have?
response from his daughter, who sat here and testified 3 weeks before she'd been in her own ski accident. She was laying there with her leg up. She was under, as I think she said, she had pain pills at the time. She was aching an injury. And there might have been kids coming in and out of her room. She didn't remember exactly why she wrote what she wrote. Nonetheless, she admits that she wrote it. And she said here in front of you that it was clearly a misunderstanding to something her dad might have said when he was on the phone with her. That's the shred of evidence that they want you
They're
to
trying to
cling
undo
on
the
to,
spoliation.
to try to say that Terry Sanderson did something like destroy a video of this
Untoward.
event. That's our only piece of evidence that they put on in front of you
I think he's arguing this
to
well.
that fact. Now,
I don't know how the jury
again,
will receive it, but I think he's arguing that point well.
there are many contradictions in this
He's the easiest for me to
telltale
follow on the
and
defense
the
team.
cartoons you've been forced to watch a few times. And I want you to remember, okay, there was testimony that Brad Falchuk was on the mountain,
cartoons.
but he's not in their videos. He's not in their animations. Okay? You didn't see it? But there's testimony that he was right up there close. They left him out.
How up
They
there?
left out Carrie Oakes and her testimony. We had to read it in because she also contradicts the positions of the bodies after the incident. So they've done a really good job of trying to razzle dazzle and trying to get you to look at a lot of other things that are not important, because we told you in the very beginning when Lawrence
Good
Wheeler
use
stood
of
up
razzle dazzle, client.
here, you'd hear a lot of
Counsel.
so what. That's what they're saying about Terry
You called your
Sanderson's
client's
injuries.
testimony a
So what?
story twice.
He was injured before.
So tell me
Injuries
more
carry
about the
through.
razzle dazzle.
So what? So sorry he's left on the mountain. We'd like him off. So what? That's what you're hearing. Now, we have shown facts that are corroborated by his medical records that show that from the day after this incident happened, there was a very serious decline. The people that knew him best testify under oath in front of all of us as to the changes that they experienced with Terry. His closest family members have seen those relationships affected. Terry's seen it affected. Again, I want you to weigh this evidence in the way that only you can. And I think that you can do it.
And find.
I've seen all of you be very attentive. I've seen all you pay attention, and we appreciate that.
And
Because
find.
This is a very real situation for two people. The two stories that are at play in this.
No, there's
I also want you to remember
Gwyneth Paltrow stories,
there's
and
been
then
a
there's
lot
the
of talk
truth.
about what Jenny Sanderson said, what Jenny Sanderson reports. But she's the one that went on one of those international trips with him. So it can't be too strained of a relationship. You're not getting the full picture when you have excerpts taken out of context from a deposition that are read to you. You're not.
That's a good argument.
He has 3 daughters.
Why
They all
didn't they
love
bring it
him.
in?
They
Why
all
didn't
said
you
that.
hear it?
Unfortunately, we didn't get the chance to hear some of the positives from Jenny. But their relationship is strong. She loves her dad.
He
And
could have
he
argued
looks
that
for-
more.
But she even said she's seen changes.
Assumes facts, not
Now-
evidence.
Yesterday, you heard Terry Sanderson say it's a hard thing to bring a lawsuit against the celebrity.
It's a hard thing to bring a lawsuit.
Said they destroy your
period.
life. And they turned around and said, it's your fault. It's your fault that this happened.
Your Honor, I object and would like a little
Another sidebar
conference unless you want me to state my objection
during
right here.
closing?
I think just overruled, and you
Celebrities.
can make a record later, but let's let him finish.
That's our 5th objection.
I don't want her lumped in with
Terry
other
Sanderson.
celebrities.
Thank you, Judge.
Thanks. They point the finger at Terry Sanderson saying, it's your fault. You did this. You brought this on yourself.
That was
Terry Sanderson believes in justice, just like you've seen. Right
big
here.
fan of
Been waved
justice.
all over.
Ding, ding, ding.
And he wants the weighing of the scales the same way that Miss Paltrow does.
Big fan of justice.
But Terry Sanderson believes, and I think we've shown you, that on those scales, someone has facts that are weighing, and someone has a lot of fanfare that when you really pry it, it's a so what? It's nothing. So I charge you, and we thank you again for your time, hearing the evidence, listening to all of us, listening to the coughing, listening to the objections, listening to this, sitting through the sidebars. We thank you, but now it's on you. And we invite you now to weigh the evidence, and we empower you and trust that you will weigh this evidence the way you've heard it properly.
It is
and find
1:38.
on behalf of Terry Sanderson.
It's 1:38 in the local time.
Thank you, Mr. Sorensen. In a civil case,
Final instruction.
only 8 jurors are allowed to deliberate and reach a verdict. Because this trial was scheduled to last over this 2-week period,
Final instruction.
and because jurors may need to be excused because of
done.
an emergency
They're gonna
or
pick
other extraordinary
alternates.
circumstances, 2 alternate jurors were selected in this case.
Good
Prior
job, Chad.
to going back and deliberating, the court is required to excuse the alternate jurors.
We all did it.
Some jurors are relieved when they are
8
excused
deliberating, 6
prior to
for verdict.
deliberations, but most are disappointed and even frustrated that they've invested their time and energy in the trial, but are not going to be able to deliberate. Those of you who are excused, those 2, thank you for your service on the jury.
I
Remember
try to bring the claps.
that you're actually you're not being released as a juror
You're not
until
done
the
yet.
verdict comes in.
Correct.
Because there is an outside chance that one of the 8 during deliberations may be called away for an emergency.
They're like, Your Honor, we got
And
this
so the
today. Thanks,
2 of
Boo.
you that are
We
allowed
good.
to leave, you may be called back to
They're
finish
going
the
to get from like
deliberations and to vote on
1:45
the
to
verdict
5. They've
form
got a lot
with
of
the
time
others.
left today.
So please do not discuss the case with anyone. Please do not read anything about the case. Just keep the existing restrictions in place until further notice by the court, which will be after the verdict is rendered. Please leave your cell phone number with the bailiff so that they can notify you when the verdict has come in and
Can I
even give
can
you
I
the
call and
results
give
if
mine
you'd
as
like.
well? Excuse
Again,
me.
we appreciate your time
Can you
and
text me
attention
too?
on
That
this
would be
case.
super helpful.
So I've got in here all of your names, and I'm just going to look the other way and pick 2 out,
Can someone text me as well?
or your juror numbers rather. And so the 2 that are excused are number 15
Sorry, number 15.
and number 24.
Sorry, number 24.
Those of you who are not being excused right now, you've been given all of the evidence and instructions on the law regarding this case. Before you retire to deliberate, I need to give you a few final instructions. First, about questions.
This is the last
As you deliberate, you
instruction
may
before
be
they
tempted to
deliberate.
seek more information. If you do have questions, please write a note and give it to the bailiff, and I will review that note and the question that you have that pertain to the case, and I'll review it with the lawyers and decide on how to answer your question, if it's appropriate. However, it's quite possible, and in fact, it's probable that we will not be able to answer your question. You should understand that no further evidence can be provided to you, and the instructions given to you contain the law which you need to reach a verdict based on the evidence presented to you. What to take into the jury room. Let me first say that you cannot take your cell phone and you can't have any outside contact during deliberations. So the bailiffs will give you some time before you begin deliberations to text or call anyone and let them know, hey, I'm about to go on a be blacked out here while we're deliberating.
We're
and then they'll take all of your cell
deliberating.
phones and they'll keep them in a safe place back by your deliberation
I'm
room.
about to go deliberate.
You may take the following things in there with you. Your notes that you took, the jury instructions and any notes you took on those jury instructions. All of the exhibits admitted into evidence, they are being assembled. The lawyers will agree that, yes, we do have this is the correct exhibits with the clerk, and then they'll be brought back to you in a little bit. You're also the same with the verdict form. I have the original verdict form. It says original on top. This is the one that will be filled out, and the bailiff will bring this back to you as well. When you get to the jury room, please do the following before beginning your deliberations. Read over the instruction on selecting a foreperson and select a foreperson, and then you may begin. At this time, I'd like the clerk to administer the oath to the bailiffs.
All right, they're just about to get charged. They have plenty of time to deliberate today because court runs through 5. We'll hear from the court how they want to handle the verdict.
Swear that you will take charge of this jury and take them to some private and convenient place where they may deliberate upon their verdict,
Let them
allowing no
deliberate
one to
in
speak to
peace.
them, nor to do so yourself unless so ordered by the court, and to return them to the court when they have reached a verdict or when so ordered. So help you God. Thank you.
You may now take the jury back. Thank you.
Goodbye, jury. Enjoy deliberations. We will see you soon, I think. All right, I'm going to put up a poll on how long they will take to deliberate.
May be seated. Thank you, counsel. Mr. Owens, did you need to make a record on anything on that last objection?
Yes, thanks. There was just a reference. It's hard to sue a celebrity. I thought that was an unfair statement given
Owens.
it's this person. This is a person here, not a celebrity. And I thought it was unfair to sort of slime her with
Slime her? You mean goop
Hollywood.
her?
And the
Goop
court
her with Hollywood?
anticipated that and noted, what I was thinking about was the fact that the plaintiff basically said the same thing on the stand, and I think he was just repeating that. So as far as
Slime her with Hollywood.
well, are there any exceptions that need to be taken on the record otherwise? Okay. I wonder if there's been a motion filed by some members of
Hollywood
the press
Slime would
concerning how
actually
to
be a
handle the
great
reading of
band
the
name.
verdict. Mr. Raymond, are you in the courtroom? Mr. Hunt, is that right? Why don't you come up and present your motion?
Is your first name Mike?
If you could first identify yourself, your
Who
bar number,
is
and then
this?
who it is you're representing.
So I think Hollywood Slime.
Good afternoon, Your Honor. Jeff Hunt.
Damn it.
My bar number is 5855.
Who are
I
you?
represent Court TV,
Oh.
ABC News,
Oh.
CNN,
Oh,
Daily
shit.
Mail, the Associated Press, and NBC News.
Jeff Hunt.
Ready
Sir.
to hear your motion.
We did file a motion, Your Honor, to modify the court's
The decorum
electronic
order.
media coverage order and decorum order, which previously through the trial has restricted EMC coverage of counsel tables.
Thanks, Jeff.
And as the court knows, this is a case that's attracted substantial national and international attention. I think it's actually been a marvelous opportunity for the public to observe how the court reaches decisions, how cases are litigated.
I
And
agree.
we all benefit from that transparency,
Oh, we love
that
you, Jeff.
accountability. That is what the EMC rule that was adopted by the Supreme Court was intended to serve. And as Your Honor knows, under the EMC rule, Rule 4.401, electronic media coverage is presumed within the limitations of the rule. And subsection 6 of the rule, there's several limitations for not showing the jurors, showing minors, showing exhibits that haven't been admitted, etc.
Get it,
Counsel's
Jeff?
table is not within subsection 6. So as the rule stands, the presumption is that there should be electronic media coverage of counsel's table. And we just simply wanted to clarify for the court that when the jury
Jeff Hunt
comes in and announces their verdict, that the videographer and the still photographer for the Associated Press be allowed to show the public, as everybody here in the courtroom would see,
the reactions of the
table.
parties.
I mean,
yes,
that is the most important part of the trial. This is what we've all been leading up to.
Yes,
everybody
it
here in the
is.
courtroom will be able to observe counsel and the parties when that verdict is announced. And we simply believe that, consistent with the rule, unless there is an overwhelming, and the rule says a compelling interest,
This is magic.
not to show the parties and the lawyers during the announcement, that it should be allowed, and the court should modify the order to allow still camera photography and the video coverage. We've participated with Court TV in over 30 years of trials, live coverage. We've never had once a situation where the public wasn't allowed to observe the parties and the counsel when the verdict was announced. And that's for good reason. You've had 7 years of litigation, as I understand it. You've had 2 weeks of trial. And the most important people, the people that have the most interest in the outcome of this litigation, is the parties and their counsel. And the public ought to be able to observe them when the verdict is announced.
Yes.
And again, under the rule, Your Honor, the burden is on the party seeking to impose an additional limitation.
Yeah, Owens.
Under the EMC rule, to come forward with some explanation for why that would be particularly
I just made an
harmful,
Insta story.
or
I just made an Insta story.
prejudicial. And there's simply
This is my favorite part of the trial right
reason
now.
for that. If you look at the reasons, the factors that are in the rule,
I love this shit.
all those factors weigh in favor of allowing EMC coverage of the verdict announcement.
Yes, 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 yes,
Vision
yes.
is happening physically.
I'm not sure.
We've got
where
the
Wes
cameras.
would like to be
Just let us point
positioned,
them.
The still photographer. I imagine.
There'd be a still camera right here,
Okay.
but without an operator. That is be remote. Is that possible?
I'm not sure if that works for still, but the video would just be
It's
as the
there.
video would normally work.
Right.
For
And
the still.
You just need to pan out. They're arguing to modify the decorum
Yeah, there
order.
was a still camera up here before, Mr. Hunt, but I don't know how much control.
This is the only
photographer
trial
had
I've
over
seen this
that
be
camera.
such a big
And it had a
issue.
very big, long lens, and it was focused on one individual.
He says he could fire it remotely from that position, the camera,
But can they, I mean, if it's,
the aperture.
well, I'm just wondering if it would be, if it would be focused on one individual or be focused on both council tables at once?
EMC is
I mean,
extended media
how do you foresee
coverage,
that?
meaning media in court with audio, video, etc. This is the still photographer from the AP.
So at this point,
This is the
physically,
only
what
time
it
this has
would
come up.
require
It is a public
photographer to be
trial.
standing over here
We should be
and taking
allowed to
pictures.
see
Is
it.
that what I'm hearing? Okay. Okay.
He didn't bring the remote because
And,
y'all told him no.
I mean, the court TV camera is very unobtrusive. I don't see it. I don't hear it. It can pan and move
Yes.
and
Does all the
and
things.
do all sorts of things without
Extended
anyone
media.
noticing
I think
it.
it might be
realize that right
electric,
now,
electronic, but a lot of courts call
I
it
mean,
extended
this will
media
be the
coverage
end
in
of
their
the case. So
jurisdictions.
the concern of
So it
of
could
an
be
interruption
electronic.
of the proceeding is different,
Depends on the
but it's still there
jurisdiction.
in terms of decorum. How can we maintain court decorum and still meet the request?
It is there, Your Honor, but we could station the photographer there.
Some call it
in a
expanded
place
media
that's
coverage.
unobtrusive. The jury's here. The focus is going to be here. It's going to be very brief. It's not like we're asking.
And why can't the still photographer take stills off of the court TV feed?
Oh, because they're shit. Because it goes through the video feed. The still photographer should get to
Just
be
different.
I'll hear from both sides.
Yeah,
in
there's
a
just
bit.
different modes of capturing the image. The still photographer is just set up, designed
Much
just for that.
differently.
The images are richer.
And in your experience or your client's experience, how have other courts handled the still photography?
They've allowed them in
usually
the
had the
witness
still
box.
photographer positioned in a place that's unobtrusive.
The witness box.
And for limited periods of time and not able to go in and out of the courtroom.
And sometimes
It's
in the
just
jury box.
Thank you. I'll hear from you again, but I just want to hear from the parties.
Jeff! Thank
Mr.
you,
Sykes?
Jeff.
You're on behalf of the plaintiff. We
And
have
thank
no
you-
objection to this. We think it's reasonable.
Court TV.
They're
They're gonna make
there's,
Gwyneth look like the asshole.
this tripod over here with the camera on it is covered with a black robe, like two judicial black robes here.
Shroud of
So I think if
justice.
Mr. Boehme was to stand there, and we'll take the screen down, I think that would be fine for us. We don't think that would be obtrusive or
Well, your
violate
client
the
wants to
court.
be famous. The other
So
client
we're in
is
favor of it.
famous.
Mr. Owens?
What do you guys think of this request? Court is a public proceeding.
Thanks, Your Honor.
But the public can only see the back of heads. Is this more obtrusive? Should they
First
only be
Amendment's
allowed
important to us.
to see the back of their heads? Like the audience?
There's certainly been a public benefit, I think, to having
To the
this,
First Amendment, sir? You let me know what you think.
in the public sphere. We've noted 3 violations of the decorum order.
You've noted more than that.
The very first day my client walked into the court, after I assured her there would be no photographers in the lobby, there was one right in her face as she went through security. Then suddenly one day another camera appeared, and then a third violation we felt. I don't know if you found a violation, but I have still photos
You've
of
asked
her
it.
being taken just yesterday. So we're all for the First Amendment. The idea that the public
challenge
should see what we see. The public isn't seated in
That's
the
what I
well
just
of the
said.
court.
Yep,
the public is seated
behind.
behind Miss Paltrow.
So they can shoot from behind.
The jurors have an interest here. This is stressful for jurors.
They need to be
To have
able
a
to
still
evaluate the
photographer
parties'
standing
faces.
right where that screen is as those folks come in. I think even if their picture isn't taken, I think it's strange.
I don't think
it
they're
will be
scared of
stressful.
photographers.
Mr. Sanderson
He's been
actually
there the
has a
whole time.
privacy interest here too.
He didn't argue it. I love
I
this
thought
so
it was
much.
insightful of Your Honor to ask about how this would physically change. If nothing
Compliment the
would
judge and keep
physically
arguing.
change, and if they're looking at the defense counsel in its totality, defense counsel's table,
And yours.
we would have no objection.
Wait, but what about you? Okay,
Mr.
defense
Hunt?
counsel table in its entirety.
So the defense wouldn't have any objection if nothing changes physically in the courtroom from the way it sits right now?
That's fine, but I still think it would be unobtrusive and completely consistent with court decorum to have the still photographer there for the minute or two that it took to announce the verdict.
It's gonna take
not
longer than
going to-
that,
They'll
Jeff.
have already determined their verdict. It's not going to add any additional stress. They have known that there's been media coverage throughout the trial.
The photographer's
We
been sitting there the
disagree that
whole
there's been
time.
Any violation of the decorum order. Counsel has not approached me about that. We're not.
It'd be so good.
I didn't even know you existed in this case until an hour
I've
ago.
only represented the media in Utah for 30 years.
I know you, but I didn't know you were even involved in this case.
So we're not here about that.
I've only
We're here
represented the
about
media
my
in Utah
motion.
for 30 years.
And it
Throw
sounds
it
like
down,
we squared
Jeff.
away the court TV, the video. We'd ask Your Honor for the 2 minutes, unobtrusive. Mr. Sykes makes a good suggestion of moving the stand-up.
The
And
lawyer,
we think that can be accomplished,
squabbling.
and the public will be richer for it. We're going to have descriptions about the reaction anyway. the press is going to report that. So why not have the images and the video
Let
that actually
the
show
world
what
see.
the reaction is, so the public can judge for itself what the reaction is.
Yes.
That's the most accurate way to report this to the public.
Instead of
Thank you.
filtering it through the
Thank you.
press's perception.
Well, given the fact that there is a presumption in the rule, and given the First Amendment, the
I
court
didn't know
will
this
grant
was
the
happening.
request as long as, for the reasons stated, for as long as that that is used to sort of stand between the photographer,
I
the
like
still
it.
photographer, and the jury.
Good job,
So we
Jeff.
can turn that sideways. The still photographer can stand quietly, and I assume your camera makes no noise?
It makes
There's
a
no
small
flash?
shutter click.
Okay. You can stand next to the existing camera then, and when the verdict is read.
Thank you.
All right. Is there anything else before we adjourn at this time?
Can I throw out an issue that
Sure.
will need to be addressed at some point? Your Honor has had a protective order in place in terms of speaking with the press. After the verdict is delivered, is that protective order lifted as to speaking to the press or issuing press releases? I ask because we've received a lot of inquiries. I think the protective order and the decorum order, I think, talk about the evidence, for instance, depositions being held confidential in perpetuity. But the press issue, I think, is appropriately lifted once the verdict is delivered. So there you go.
I don't quite understand your request, your
Sure.
clarification.
Neither does
Are you-
he.
So are you asking to continue the protective order, or are you asking for confirmation that the protective order will be or are you asking for confirmation that the protective order will be released?
As to the press,
As to the
You want to give
press?
media
we
interviews?
want it to be released. We don't want certain, for instance,
You want to give interviews?
depositions that were taken that were marked confidential, anything that was not, for instance, I have boxes and boxes of things that didn't come into trial.
Right.
I don't want that. I want those held.
Everything that was marked confidential according to this court's confidentiality order remains confidential
Correct.
in perpetuity.
If it's been entered into evidence in this court, it's obviously not
Then it becomes
confidential.
public.
And then
Obviously.
we do want we do want to be able to speak to the press.
Yeah, you want to give a
after
press
the verdict.
conference. So there will be a press
Do
conference
you have any
post
objection
verdict.
to that, Mr. Sykes? Okay. So once the
We got a
verdict is
long day
read,
ahead of us, folks.
the informal agreement between the sides that they won't talk to the press until after the
the
case,
verdict.
that's then no longer there, and they can talk to the press. And the press can talk to witnesses, the press can talk to
They want to control.
jurors if they so desire, and I'll explain that to
Woo!
the jury. And I'm going to ask the press to
I'm
please
surprised.
um,
Wait outside.
acknowledge and respect the wishes of the witnesses and respect the witnesses or the wishes of the jurors. And if they don't want to speak to
So
them,
he doesn't want
or
cameras
if they want to
at
wait or maybe
verdict,
later,
but he
please respect.
does want
So I expect
to be able to give a
that'll
press
happen.
conference. Got it. 10-4.
Just mentioned. The decorum order prohibits any cameras in the courthouse. I think that should be lifted now. I mean, because
To give a
it's
press
cold
conference
out there
inside because it's
and wet
cold.
out there, and they shouldn't have to be
It's
out there.
cold and wet.
You shouldn't have to go out there to talk to the press.
Can we give a press conference inside?
Well, I'll consider that, but it's the reason that
Don't you have a
there's a
press room?
standing order that there not be press doing things other than inside the walls of the courthouse, other than through a decorum order.
Don't you have a press
is
area or a press
special orders
room?
is for other reasons. There's security reasons, things like that. So
Don't you have a press?
I'll
area?
talk with those that have some control over that and get back to you on that.
That's fair.
Anything else before we adjourn? Not finally adjourn, but take a recess. Okay, so what I'm going to do is
What's
when
the
I'm
procedure? What's the plan, man?
alerted that there is a verdict, I will let the head of security operations, Chris Palmer, know that that's happened. And he will then let all the press know that in approximately 20 minutes or longer if we need that. At least we'll wait at least 20 minutes before we bring the jury in and read the verdict. So if the lawyers will please leave a cell phone number contact with Jody, then we'll have, we'll call you as well if you're not on premise. All right. Thank you. We're in recess.
We're in recess. Well, that was eventful. So we have about a 20-minute lead time when there is notice. Oh, Paltrow walking out right behind Sanderson. We have about a 20-minute lead time. Oh, back into the witness room. We have about a 20-minute lead time when there is word that there's a verdict. The jury has only been out for about 15 minutes. I'm going to answer some questions. I have not had lunch yet. Here is my plan. Well, no. First, let me tell you, if you want to know what my plan is, lawnerdalert.com. I see that there are 37,000 of you here. We are going to go to answering questions. And then if there is no action in court, I will take a break and get some lunch. This is going to be a busy day. I wouldn't be surprised if we have a verdict today. I think we will have a verdict today. They're giving a 20-minute notice to the media when there is a verdict. So we should start seeing those things on Twitter, etc. So with all of that, go sign up for Law Nerd Alerts, and I will keep you in the loop when I populate another live stream. If we don't finish this one, we have put up the poll, and right now the poll's at 51% of you think this verdict will be in less than 2 hours. The jury went out at 1:43 local time. So it is now 2:03 local time. So the jury has barely been out. So we will, I'll answer questions and we'll go from there. LawNerdAlert.com is where you want to stay in the loop. Yes, I'm getting hangry for french fries. Okay. We're going to do a summary. We're going to do a summary. We're going to do questions, and then we are going to take a break. You are going to do, chat, this is on you. You are going to do the likey, subscribey things. Liking the video actually helps in the algorithm. And then subscribing to the channel actually helps not only prove to my children that I do have a real job, but also helps boost the channel up above some other media outlets. So with all of that, let's go to a summary, and we'll go from there. So let me take, well, we're just going to leave it. Summary. Today has been a day. It is day 8. This judge said this is an 8-day trial. And you know what this judge did? This judge landed the plane in 8 days at lunchtime, exactly like he said. There was no running over by 3 weeks with this court. It was everybody's got 20 hours. Go. Clock is a ticking. I wish he had the chess timer like Judge A did in the Depp v. Heard case, where you were just chess timing the sides. But this judge kept diligent time on the parties and moved this case through to the jury in 8 days, as he said he would. The jury has lots of runway this afternoon, since we're sticking with our plane analogy, lots of runway this afternoon to come back with a verdict. The conversation that they have to have first is anyone at fault, yes or no? And if nobody's at fault, then they can go 50-50 or 0-0 and just walk away. Is anybody at fault? Where you start getting into issues is apportioning damages and apportioning fault. So if both sides are at fault, how much at fault are they, etc. That can take a little bit more time because it can be confusing. Also, just keep in mind that this jury has not gotten to talk to each other about this case. We've gotten to talk to each other day in and day out, all day long. They have not gotten to talk about the case. They're going to want some time for chitty chat. They also need to pick a foreperson. So coming back sometimes this afternoon is really what I expect. But I don't expect a 15-minute verdict. I expect them after 8 days in a celebrity trial with media that they're going to want to have a little bit of a, so what did you think of this testimony? What did you think of that? Just a little bit of a kiki, right? They're going to want to talk. So I don't think it's going to be who do you think liable's done? And then come back with a verdict. Could they come back pretty quickly? Absolutely. Do I think it'll be in 30 minutes? Not in a case like this. But they could. So what else? We saw legal argument this morning, the finalization of jury instructions, and then we got into one rebuttal witness that was an absolute disaster, and my brain has already blocked it out. Then into closing arguments. I'll put up a poll later on whose closing argument you felt was more effective for you, more linear, and brought things out with or for you. I actually liked the closing argument from Owens more than I thought I would. I did not love his opening, but I actually found his closing to have little unintentional moments of lightness. And though I don't always find him easy to follow, I did like the way he presented the story. I prefer he's not the greatest storyteller for me. I prefer a more linear closing. There are moments where it feels like a lane. It's like, but there's this, and then there's that, and then there's this, and then there's that. When a lawyer is telling me a story, I want to hear this is what happened. But we didn't hear that well from either side. We didn't hear from the defendant either. The defendant argued against themselves, and the plaintiff argued against the plaintiff today with their expert witness. The one thing that happened with their expert witness today was that their expert witness said Terry clearly wasn't flying through the air. Well, that's what he testified to. So their witness is already diminishing or discounting Sanderson's version of events. And then the defense attorney called Sanderson's testimony a story and a tale. I thought that was very telling. And I have to wonder how much these attorneys believe their client, because they kept saying there's two stories here, not saying there's Gwyneth Paltrow's story and then there's what happened. They did not lean in to their client's side. And that was really interesting. You guys are saying you haven't seen the beginning of closing. I promised I would go rewatch the beginning of closing, and I will. I will back it up and go watch it. Give me just a moment to pull up a second feed so I can monitor one feed and then pull up the other feed to watch it. So I will do that in a little bit. I will go pull up the beginning of it. So what else happened? We got the closing arguments. The jury got charged and released. And then after the jury was charged, we had a unknown lawyer, now known to us as Jeff Hunt. And Jeff Hunt, not Mike, Jeff Hunt came up and argued on behalf of Court TV and other media regarding the extended media coverage in this court, arguing that the court's decorum order should not prevent the cameras from being on both parties, being focused at counsel table when the verdicts came in, because this decorum order had limited the cameras to being on the person speaking, so that while a lawyer was speaking to the jury or a witness was speaking, the camera was on the witness or the lawyer, but you didn't have a split feed, right? You couldn't have a camera on Gwyneth and on Sanderson and on the lawyer speaking. I'm sad that we didn't, because both of them, every time they panned over, both of them were making faces. And during closing, Sanderson was talking under his breath. I wish we had seen their faces this whole trial, but we will get to see their reactions during the verdict being read. And that, I think, will be very interesting. So the court granted that order. That's what happened. Chat, I promise I will go eat. I'm going to just answer a few questions. I'm fine. I'm not ready to go eat just yet. So chat, thank you for taking such good care of me. I beg your indulgence for a few more, because I have to close the loop on the beginning of closing and some of the questions. So, and if you sign up for Law and Order Alert, I promise I will go eat. So with that, let's continue on. Tirsa said, just received my Nintendo Switch. You are why I bought one. They're so good and I love them. I love them. I got it with Zelda. I love Zelda. However, buying Mario Kart so my granddaughter and I can play next week when we vacate together, need the break. I love Mario Kart. I also love Mario Party. Mario Party is just an absolute blast with my kiddos. I find it to be a lot of fun. So with all of that, I'm a big fan of justice. Slim Jim said, can we help James's music career take off so he doesn't have to work with Owens anymore? James is a good lawyer. I haven't listened to his music. I'm sure it's delightful. But yes, we can the Emily show is trending in the charts for podcasting. You can get James trending in the charts too. If you are new here and didn't know I had a podcast, the Emily show, this week I talk about Murdaugh. I thought it was a good episode. I was really happy with it. So if you haven't checked that out yet, absolutely do that. EDB, love you. Theory of GP motivation. Say GP hit TS, loudly blames him to save face in front of Falchuk and kids, pride, personality. That day was a big deal situation for GP. First experiment as a blended family. I can see the argument. No one argued it. I think it's a better argument than anyone else made because nobody really argued what Paltrow has to gain or lose. So I like it. Very real, but they didn't argue it. Defense or plaintiff got up and said, and I'm going to mix the parties so much. Plaintiff got up and said, we believe Gwyneth Paltrow. And then they called their own client's version a story. It was odd to me. I wonder how much these attorneys like their client at this point, because they did say, we deal with Terry Sanderson, but we deal with him. Ohio Palm Mom said he just told a story about a woman saying she was okay when he didn't believe that she was. Exactly that. I'm not going to be Mohawk River Blues. This trial has been very age discriminatory. Just because he traveled and did things doesn't mean he did it easily. He didn't testify that it was difficult though. And may have had to keep a high maintenance lady happy. I think he was very impacted. He didn't testify to that though. And yes, this trial is going to lean in to both sides and the realities of their life. That's what trials do. Trials are not polite. They are adversarial and often very aggressively adversarial. So yes, they are going to lean into his age. They are going to lean into pre-existing conditions. He's asking them for $3.26 million. They're going to lean in to all of it. But his picture got painted very differently between his daughters and his reality. And he didn't testify that any of those things were hard. He didn't testify at the cost to travel. So I think it's a fair point, but he didn't put that in evidence. Stina said, if I'm a juror, I want to be thorough, but also not spend any more time than absolutely necessary and just be done with this sick infested courtroom. Yeah, courtrooms are disgusting incubuses of germs. And I was sick often working in court. I imagine it's much like working at an elementary school. Ellen said the switch to milking cows isn't utterly confusing. He had been milking everything else in the closing. Alan, I brought this up earlier. I wanted to applaud it again. This is why this is the best chat on the internet. Y'all are fucking funny and I love it. The speed and the wit of this chat is literally one of my favorite things. It just is. So thank you. Christine, thank you for the super chat. How does an attorney reconcile when they realize during trial that their client is lying? Not saying this happened, but I'm sure it does. I think dealing with the realities of trial takes some effort and some mindfulness. But in a civil trial, I don't think these attorneys are caught off guard because there's nothing new here. Right? These attorneys aren't like, oh my God, he's saying this. They've been with him for years and they've done all the depositions. They've seen all the evidence from both sides. They know. So I don't think they had a realization in the middle of trial. I think they were picking their words carefully because remember, we still have an argument. If Paltrow wins, this is not done. I want to just remind everyone of this again. If Paltrow is found to not be liable, if Sanderson is found to be liable, there is another component here. And that is the component that Paltrow is asking the court to determine that she gets attorney's fees because this was a claim brought in bad faith. And that's another evidentiary hearing. So if Sanderson, he stands to lose, not beyond the ego, but he stands to lose if he's found liable. So that's an interesting point. I wonder if they were trying to downplay it and trying to downplay the bad faith. You never know. J. Michael said, I have multiple TBI and stage 4 cancer. I am sorry, J. Michael. I still work full time and live life. I conquer events, not let events conquer me. That has to be a lot. It has to be a lot. Don't forget to take care of yourself as well. But I also think it is a good point. You do have to continue to live. But when your life and your lifestyle is what you're asking for $3 million for, this is what gets brought up. It's why a lot of people choose not to go to trial. And it's a conversation you have to have with clients saying, this is how they are going to rip into your entire life. This is not an easy process. Haven said, just now catching up on this trial because my mom had a stroke last month. I'm sorry to hear it. And I've been busy with her coming home. I imagine you've been tremendously busy. Speedy recovery and good recovery to your mom. Living Sweetly said something isn't right. In general, people who have severe TBI are not medically cleared to dive, particularly if they are directionally challenged. The diving was a big one. Are non-economic damages equal to punitive damages? PB&J, this is a fantastic question. Thank you. No. Punitive damages aren't at play in this case because they don't attach to every type of cause of action. So with this negligence cause of action, there are no punitive damages. Punitive damages are to tell the party that loses that they suck. They are you suck damages. They're like, hey, punish. What you did is egregious. So if you look at examples, and I talk a lot about pop culture, it's my favorite thing to cover, talk about YouTubers. If you look at like the David Dobrik, Jeff Wittek situation, I'm using that fact pattern as a hypothetical. This is a hypothetical. If that ever went to trial and a jury found that David Dobrik swinging Jeff Wittek around on an excavator was so egregiously dangerous that they wanted to punish that behavior, punitive damages can get awarded in a very large way. And it's like, no, that behavior is so bad that you are getting punished for it. Or you get a car manufacturer that knows brakes are faulty and they still roll cars off the line knowing the brakes are faulty and some people will die. And you're like, hey, fuck you, don't do that. That's awful. And that's where you start seeing the big punitive damages saying what you did is terrible. They are meant to punish and to deter behavior by charging money because we're in the civil world. Non-economic damages are for pain, suffering, loss of enjoyment of life, things that don't relate to cost, things that don't relate to bills. Hopefully that helps. Did they explain why Terry didn't sue right after the incident? No, they didn't. Terry sued right at the cusp of the 3-year statute of limitations. Do you think the photo of Terry climbing Mount Everest blindfolded holding what? Do you think the photo of Terry climbing Mount Everest blindfolded holding a bear hurt him? Yes. But I think there was also a horse and a camel involved. Let's see. Living Sweetly. So Terry Sanderson is severely incapacitated, can't find his way home. Does he require a full-time caregiver, constant supervision? We heard nothing of that. The lawyer is historically inaccurate, and false flattery of GP was belittling. I find their closing argument lacking. Thank you, Living Sweetly, for the super chat and for your input. No one ever said Gwyneth Paltrow was a good actor. Oh, wait, the Academy said she was a good actor. Lol. Hide your overreacting face, Gwyneth Paltrow. She should be able to not pull faces, right? She's been trained to not pull faces. Just Googled Falchuk and he's dreamy. Maybe they should have brought him in, but I don't know the makeup of the jury. I think his wife might be a better lawyer for telling him not to wave the dollar. We're going to go back and watch that. Should we do that now? Let's go back and do that now. And watch the beginning. So this is a reenactment from earlier, or this is a non-live replay of the beginning of Owens's closing that I missed. And then we are going to wrap up here. So let me pull this back up and let's go take a look. I might do it at 1.25. All right. The judge is in court. The jury is coming in. I'm going to start at 1.25.
Mr. Owens, you ready to proceed?
Thank you. Yes. Just to be clear, because James is going to share the time with me.
Sure.
And is the plaintiff reserve any time for rebuttal?
They reserved 10 minutes, which I granted them.
And so do they have an hour and 10 minutes?
And do we have an hour and 10 minutes?
They reserved 10 minutes, so you can proceed.
So we have 1 hour.
You can take 1 hour, and if it happens to go over because you're finishing a topic or something, that's fine.
Thank you so much.
I like that the judge
Well,
gave them a little
folks,
bit of room.
We didn't even know each other 2 weeks ago, and here we are. Thank you.
Can I go back?
It's a beautiful thing, I think, that we resolve disputes in our country in this way.
You
just
said
like
that in
Lawrence
opening.
mentioned. You're plucked, and really, even if you had to fight it, in theory, one of these bailiffs could go arrest you and come and make you come here. So we don't do that with anything else.
You started by telling the jurors they could be arrested? Sir. It's a beautiful thing. It's a beautiful thing in our country that we resolve disputes this way. But if you don't show up to do it, we'll just arrest you. What?
But why do we do it? Because it's such an important thing to resolve disputes in our country in a peaceful manner. So, thank you.
Just made my eye twitch.
I'm Miss Paltrow's, and I'm going to just call her Gwyneth. I'm Miss Gwyneth's lawyer.
I'm Miss
her
Gwyneth's lawyer.
spokesman this week.
Is it because you can't
So
pronounce her
she
last name
sat there for 2
consistently?
weeks and been a punching bag. We've blown through a lot of
Oh, the blown started
these
early.
cute little Post-it notes where she's sending
We've blown through a lot of these cute little Post-it notes, and then he's talking about what his client said.
me stuff. But I take it very seriously because she's comfortable in a lot of worlds I'm not comfortable in. But she is not comfortable in this world.
Shakespeare and
It
dramas.
is not a nice thing for someone to throw a press conference
Court sucks.
and say, like King Kong, you knocked him out and walked away, skied away. That is not
Gwyneth objects
what
to being
happened.
called King Kong.
And the court has actually dismissed the idea, and that's one of your jury instructions, that this was a hit and run. That took no small amount of work, by the way. But that is what she was faced with. It takes a lot of courage, does it not, for her to sit there for 2 weeks and be pounded like a punching bag. What did she lose? Did she lose? Oh, that's too bad. You had to come in early and have a massage. No, this is what she lost. She was in love with Brad Falchuk. Dated for 2 years. They both had, very interesting, I think, 9-year-old sons and 11-year-old daughters. It's kind of cool. And they said, how are we going to get these guys together in a loving, fun time? They're very busy, where we can kind of all be together for a couple days and see if this will work, if we can blend our families together. We're going to make it relaxed. We're going to put a lot of planning. She put a lot of planning into that trip. And so here they are. It's a little delicate because anyone who's been through like trying to blend families, it's a delicate thing. So what happened? They got
sure
there.
it is delicate.
They're organized. First day of skiing. They have ski instructors. By the way, I thought it was cool. I don't know if you did. Her dad taught her to ski at Alta.
Oh, you
And
thought
she
it
has
was
tender
cool.
feelings about that. She's been tearful with
It was
me
nice to know.
in describing those ski trips with her dad, because her dad died in his 50s. In fact, it was so painful, she didn't ski for a long time after that because she would miss her dad. But when her kids were of this age,
She
and we're
testified to
talking with
that.
Brad was a big skier. We didn't get to hear from him, unfortunately, lack of time. But they were going to come, okay, let's get our kids together. So what did they lose? They lost a half day of bonding and even more because now everyone's stressed.
Well,
That
yeah.
was the day when they bond up going up the ski lift. They bond having hot chocolate mid-afternoon. They bond relaxed, laughing
She
around the
did
fire
marry Brad.
at night. They lost that because he hit her
And then had the
He
audacity
hit her.
to say, you hit me?
He hurt her.
Like my kids arguing.
And then he asked her for $3 million for the pleasure. That is not fair.
I mean,
And I'm grateful that we have a court system.
I appreciate
that
the
permits
argument.
anyone to sue anyone for
You
about a
hit me,
$250
And then you
fee,
sued me.
and that they can have their day in court. And I think Mr. Sanderson, by all accounts, will have some peace after this trial, regardless. But it's come at a steep cost, a deep cost to my client.
Do you want to talk more about
I
that?
told you when we first met,
Are you going to talk more about
I
that?
wanted to concentrate on a couple things about Lady Justice here. By the way, if I didn't make it clear, you are Lady Justice. All right. Blindfold eyes. Because she's blind? No. She's smart,
Sir?
but she's not going to be distracted by chaos around her. Chaos like
Me.
media,
When I just blind
chaos
myself
like
to the case I'm covering.
sympathy. Oh, don't we all feel bad for him? I would have liked, by the way, at least a discount on the camel ride on your request for damages, but that's another issue. The idea is, okay, we're going to focus. We're going to focus. And
He wants them to reduce damages because he took a camel ride. What is happening?
we've tried, and the judge has given you all these warnings. Don't be talking to people. Don't even talk to yourselves yet, because we want you focused. And that's Lady Justice. Now, I talked to you earlier about the scales of justice. This is a civil claim, meaning the preponderance of the evidence.
Okay.
The plaintiffs brought the lawsuit. That's why we're all here. His daughters say, isn't it terrible? These two daughters that he's brought here, his life is laid open. It's because of him. He hit her. He hurt her.
And then he sued.
And he wants $3 million for it. That's not fair. The easy thing for my client would have been to write a check and be done with it. But what does that tell her kids? It's cost of business. No, it's wrong. It's actually wrong that he hurt her and he wants money from her. And that's why we're here. All right.
I mean, he didn't call it BS
back
this
to
time,
the
but he
scales
definitely
here
called it
on
wrong.
Lady Justice.
I think that's fair. We heard him say it was BS.
He
in
has the
opening.
burden to tilt. Okay? Tie goes to her. Now, she has a $1 counterclaim. My wife said, don't waive the dollar, and I'm not waiving the dollar. But a dead even tie
My wife said, don't waive the
means
dollar is kind
neither
of endearing.
get anything. And I'll
Owens
walk you
annoys
through
me
that in
most of the
just a
time,
minute. But let me
that's
suggest
kind of
it's
endearing.
not even close. Let me suggest it's like this, the evidence
could have
here
dabbed.
versus here. And let me talk to you about that.
It's like this.
Let me mention a couple other jury instructions. So I talked to you about no sympathy, passion, or prejudice. We don't want you making decisions on that basis. I talked to you about the burden of proof. That is theirs. And then from today, let me talk to you about a few things.
Sure. Let's chat. Look, there's tabs
By the
and
way, the
highlighting.
burden of proof was evident because they get the last word. Because they have to tilt the things, you may have noticed this morning they could call a witness,
The
and after
thingies.
I'm done, they can speak for a few more minutes.
Tilt the
And
thingies.
that's what we do to the people who have a burden of proof. Instruction 30 that you were
We
read
make them go
today.
again. Okay.
Gwyneth Paltrow did not leave the scene of the accident
I don't think that's as much of a
without
big
giving
deal.
her contact information. Press conference 4 years ago. King Kong came out of the jungle,
I wish
left
they
me
had
unconscious and brushed off and went away.
I wish they had played the press conference.
Utterly BS, and it's been discounted. It's not even before you. The judge took that away from you because it was so obviously false. 31 deals with spoliation.
I think I probably
That's
would have
the
objected to that.
GoPro issue.
I'm glad he's bringing this
Spoliation's
up.
probably a word you've never heard before. It's a legal term. But the idea is if
It's a good
they
one.
destroy evidence, you can assume that it was bad for them.
I'm glad he argued that.
All right. So Terry, in fact, I should say
More.
Mr. Sanderson,
Go in
in
more on
fact,
that.
owned a GoPro.
What?
All right. He talked to his daughter that night, 6 p.m., so about 6 hours after the collision. She got off the phone with the understanding that he had a GoPro video of the incident and
I'm
typed to
glad
him,
he
I am
argued
so
this.
glad that there's a GoPro and that you're okay. All right. No one has the GoPro, but I'm telling you this, if you find that there was a GoPro and that he said, that will not help my case, delete. If that happened, you can conclude that it was against him.
Ooh,
that
he's
it
kind of
helped
smirking,
us.
isn't he?
And wouldn't it have been nice if it had been around? Do you remember when
It
we
would have been
talked
nice.
9 days ago? I said, you're going to hear so much stuff about damages.
Yeah, they did.
So much stuff. But if you find that he hit her, you can ignore it. So we heard like a week of testimony
That you can ignore.
about Mr. Sanderson's brain and how he thinks. He does like to be the center of attention. He likes to be in the spotlight. His own daughter said he would be dishonest for money or notoriety. Does that make you like uncomfortable? It makes me really uncomfortable. When Dr. Gibby was up there, he said, oh, he has a great relationship with his daughters. It's like, who? He says, two daughters. There are 3 daughters. You can't just pretend this stuff away. 3 daughters. It's pretty important, isn't it, for a witness to know that he's not in the least good relationship. And why? Because she said he was abusive. And a lot of other adjectives that I'm not actually will defer to you to remember. So Ms. Paltrow is asking for her dollar, but it's not about the dollar. It's not about, think of what her time is worth sitting here for 2 weeks. It's not about the money. It's about kind of ruining a very delicate time in a relationship where they're trying to get their kids together. That's what Terry Sanderson caused her. Pre-existing conditions. Oh my gosh. How do we not talk about what was going on right before and what versus what's happened after? He's 76. My parents, I'm not being flippant, they were dead by then. They certainly weren't taking 10 trips around the world. So we have to look at that. Those are the jury instructions. I do want to tell you the special verdict form that was appropriate. Can you bring that up? Lawrence walked you through it, and I don't think there's any harm in me telling you what I want. Is there? I'm going to ask you to fill this out. This is what you go to the delivery when you deliberate. These 3 pages. The last page really is nothing. So it's essentially 9 questions. And I want to show you how I want you to fill it out. I'm not trying to be subtle. All right, so was Gwyneth Paltrow at fault? No. If you answer no, go to question 3. So next page. Then you have to, that means Terry Sanderson's not going to take any money away from today. If you write no, so no on 1, you are done kind of in terms of his claim. Then you go to paragraph 3, which is our claim. Was Terry Sanderson at fault? Yes. We want you to say yes. Was his fault a cause of her harm? Again, we're asserting $1,
right
but
about
it
where I
was
came
so
back in.
much more. It made everyone
I
nervous.
like that they went through
all
this
afternoon.
so clearly. This is allowed,
Was Terry
yes.
Sanderson's
They
fault
can
a cause?
show,
Yes. And
they
then,
can show the
James,
jury how
if you
to
answer,
fill them out.
Regardless of your answer, go to 5. If your answers to questions,
These are
so this is
confusing
like a
jury
tax
forms.
form where you have to like read it 4 times. Sorry. If your answers to questions 1 and 3 are both no, one was, is Gwyneth at fault? You should not proceed any further, and you go to the end and sign it. And this is because you're trying to figure out, was she at fault? Yes or no. Was he at fault? Yes or no. Did it cause any damage? You can actually find today that neither were at fault.
I'm glad that
Skiing
he's
is an interesting thing.
reminding them of that.
We strap sticks on our legs at the top of a very high hill and go down for fun.
And you go
It's
down for fun.
breathtaking. I've done it. I love it. But it has inherent risks.
Oh, I was
so
here.
the back of every
I was here
ski
for
pass
that.
you've ever seen,
Judge, objection, you've excluded this inherent risk of skiing.
we referenced this, Your Honor. You said
And
I
this is where I
It
came in.
applies to resorts and not to people.
No, the argument is proper, so overruled.
So inherent risks, you've seen it on the back of every ski pass, and even your
All
own
right.
common sense
We are
says,
caught up to
hey,
where I came
if I
back
don't go
in.
down this hill right, I could actually kill myself.
Yep.
So
Thank you for that, counsel. All right. I was just correcting a tweet that I worded terribly and confusingly. So I just wanted to go out and fix that. I was like rewriting it. And this is the problem when I tweet while I'm streaming, is that sometimes I misstate myself because my brain is doing this. So with all of that, let us go look and see what is next. I was going to answer some more questions and then try to take a brief break for some food because I am hungry as can be. So let me see if there's any, I don't see anything from Court TV about any mention of a verdict. So if you guys want to stay in the loop when I go back live, the fastest way is at Law Nerd Alert and your member spaces. Goth Boy UK said, don't tweet and drive, read a book instead, right? Don't tweet and stream because the words coming into my head and the words going out of my fingers sometimes conflate, and that's not good. So to stay in, lawnerdalert.com. I had to drop out for a bit. What's the objection count? I think we ended with 5. I ended with 5 objections. That's where I ended up. So 5 objections, but they had sidebars. So that was wild. All right. Let us continue on. LawNerdAlert.com. I will come back when the jury comes back. If anything else goes on the record, I will come back and stream this afternoon. I am keeping it flexible, but I have some other things I have to attend to. So I'm going to, instead of just sitting here and filling time, truly, I'm going to answer questions and then I'm going to go. So now we have caught up to Owens talking about Lady Justice. He didn't talk about the Magna Carta, but he was very direct. And I don't mind that when he's like, this is how I want you to fill out the verdict form. This is what we prove to you. This is how you show that Gwyneth Paltrow is not at fault here. There's nothing wrong with doing that. That is the only time to do that, during argument. And that is what he was doing. He argued improperly during his opening, but during closing, it's appropriate to say, I want you to find this way and this is how. Nothing wrong with that at all. So let us continue on. All right. Getting blown and losing. Today was wild for the innuendos, right? It was just, I lost it at one point. I may be the only one here, but I think Owens is a crack up. Definitely ex-surfer who had done way too much reefer back in the day. I don't think that was Owens's experience. I think there's a reason Owens doesn't curse. I don't think Owen drinks. I think Owens is probably skeptical of caffeine. I definitely don't think he smokes. And I think maybe Dayquil is the strongest thing in Owens' system. Owens should have quoted GP's direct. Her description was super clear. I wish he would have. My client told you, and he could have quoted her direct testimony over the animation, over the reconstruction demonstrative. He could have done that. Also, how long has it been since I've asked you to like and subscribe? I don't remember how long, but we are almost at 714,000 Law Nerds. So go ahead and do those things. And where are we on likes? Because I owed you guys some more memberships and I don't know where we are. So chat, if you'll tell me. Question. I thought the actual impact animation had not been allowed to be shown. It had been. It had been with two different viewpoints. It had been allowed. So it had been allowed in that. So we're at 16,000 likes. When we get to 20, there will be more. So all right, let's continue on. Best Owens closing quotes. 1, you don't keep your skis on when you get blown, and he came between her skis. Yeah, he said both of those things. It turned into an after dark somewhere in the middle. Owens closing is much better than milking cows in a car accident. That's true. That's true. If I'm a juror, I need 10 minutes. Is there a minimum amount of time? No, there's not. But these jury instructions do take some time. A lot of blowing going on. Yes, there was. I can't get over you not doing anything for someone that is unconscious for over 2 minutes. Mountain Goat, I agree. It was the thing I had the hardest time with the testimony from Ramon. He was unconscious for 2, 3, and at times more minutes, like face down in the snow unconscious. And instead he's like, the ski instructor yelled at us and then walked off. I was like, you didn't, but if your friend's unconscious face down in the snow, you just do nothing. And then he's like, oh, Sanderson needed to do this. So it was interesting to me. That was difficult testimony for me to wrap my head around as well. So I've got a lot of, okay, there we go. Can Gwyneth Paltrow be liable, but TS just get a small or nominal award amount? Yes, they can say she's liable and then set his damages at $50. They can set his damages at whatever they want. So absolutely an option here. I don't know if they would. I think if that's the case, they would maybe go 50-50, but you never know. This lawyer has me cracking up. Today was a whole trip. For the Mom Life said, I dislike Owens so much. I want Terry Sanderson to win, but thanks EDB for going through another live trial with us. I was definitely not anticipating going through a live trial this fast after Murdaugh, but it was Tuesday last week. I did Coffee and Cursey Words, my regular Tuesday live stream, and talked about some topics. We knew opening statements were starting, so we popped in to take a peek, and then I was like, fuck, I'm hooked. These attorneys are a trip. Thor said, why can't Owens keep saying stuff was dismissed by the judge when the jury shouldn't know what the judge excluded? They allowed in some of the things that were ruled out. So when it comes to things like the other claims, those were allowed in. Deanne, with ADHD, do you have trouble in staying linear? It depends on the thing. When I was in court, I wanted a very clear story, and I tell stories in a very linear way. And I really tried not to sidebar myself, but I would often close from the podium and take notes at the same time if I had a sidebar, because I really wanted the jury to come away with a clear picture. And so I knew I needed to be the most clear, and I had very clear bullet points that I followed. So, and I did, I almost had a formula for all of my closings in how I ordered my closing arguments. If you guys ever want to hear me talk about that, we will do that at another time, or if we have time later today. James reminds me of Tom Schwartz from Vanderpump Rules. A lot of people have said that. You are not alone. I have seen that comment quite a lot. Biggest reveal to date, Gwyneth Paltrow's daughters eats French fries. And Gwyneth Paltrow's only a minority owner of Goop. Those were my biggest reveals from this trial. Yes, biggest reveals from my trial. Do you think Terry's reaction and smirkiness will have any impact on the jury's opinion? Yes. They're going to be watching both of their faces, because at the end of the day, the jury has to judge these two people and decide who's telling the truth. So yes, they will. First jury duty reminds me of this case. Spine was the eggshell. The plaintiff's witnesses hurt the cause far more than the defense. Meanwhile, slinging bags of soil, found unconscious after fall prior to minor incident. Interesting. And the juries take all that into consideration. Nope. Peanut in this butter. LOL, I tried. No juice in this pickle. This is getting to a no dog in the fight. You guys came up with a bunch of good ones. No horse in the race, no skin in the game, all of it. And I appreciate that. No GoPro in this trial. That came up. I'm glad to see how Owens argued it. Freudian slip, when people think about other things and don't pay attention, words come out like story and tale. Fair. I sure hope an employee would take control. There were multiple Deer Valley employees on site that didn't think it was serious. So there's that. Chandler said, first super chat here. Love you and your channel. Thank you. I find Owens and Gwyneth Paltrow unlikable, but the evidence is on their side. Still kind of hope GP loses. There are a lot of folks that just do not like Gwyneth Paltrow, and I understand that. We have the benefit, or Terry Sanderson has the benefit of coming into this trial knowing nothing about him. He gets the benefit of being anonymous. She doesn't. She has to overcome that in this trial, but he has to overcome that he's the party that stands to gain here. He's the party that stands to gain money. She's the one that stands to lose more. So that's interesting. Carrie said, my son had multiple concussions, 2 with loss of conscious. I'm sorry. Both times he never remembered anything. I had to tell him for 2 hours what had happened to him. I was the transfer paramedic. He stayed in. Wait, you are the transfer paramedic as well? That's hard. He stayed in the neuro ICU. So I lean to GP on the case. And your life experience helps you sort out which side makes more sense to you. Him being face down in the snow unconscious and a ski instructor doing nothing does not make sense. It just does not make sense to me. Actually, you can't. I don't want to know how you know and what's going on those chairlifts. Setting your legal-minded brain aside, which part of closing do you think will play on the jurors' minds as they go to deliberate? I don't know. I will need some time to think about it after closing because I'm still in streaming mode. It just really, I think the thing that will be most helpful for them is how to fill out the forms, truly. Emily, when you did trials, did you prefer jury instructions before or after closing arguments? Thank you for asking this question. I love being asked questions about me. I'm teasing. No, not teasing. I love getting to share this kind of stuff. I had a very strong preference for jury instructions before, because when you had jury instructions before, you can say, as you just heard the judge say, this is what you need to decide. As the judge has told you, this is what you need to decide. And they've already heard every instruction. So then they're hearing it for the second or third time from you. So they get to hear your interpretation of it when they're being reintroduced to the information. And I think it's helpful to have them hear it first, and then you're giving it to them 2, 3, or 4 times later. So it helps them absorb that information. So I preferred jury instructions before. Oftentimes the judge gave us a choice in our jurisdiction. Some jurisdictions don't. In the 90s, I worked at Anderson University for the registrar, and his name was Michael Hunt. He went by Mike. Oh, poor Mike Hunt. There is a band in Utah called Hollywood Slime. Please tell me that's true. Amethyst, I need... Yes. Yes, there is a Hollywood Slime band. It's a perfect name. Jeff Hunt is basically Law Nerds Council. Yes, we needed him. We needed him. I felt so bad when I went back and reread my tweet. I was like, shit, no, that's wrong. Rephrase. Jeff is awesome. Yes, Jeff was the best. I thought that was really helpful. Does Jeff have a brother named Mike? I mean, or Ferris? I'll take either. 1 hour to discuss, 30 minutes to fill out forms. Well, we're going to be getting to an hour right about now that this jury has been out. So we're just at an hour that the jury's been out. And I know we will keep a good look on the feeds to see when this jury comes back. And then we'll have about 20 minutes to get a second feed up and running and to be live. I'm going to just take a few more questions and then I am going to go eat. If I missed your super chat, I apologize. We had a very busy day today and I am ready to go get some food. Nikki said the reason James is so effective as defense is he comes across as not being biased. He sounds like a black and white fact person without being overly emotional and dramatic. And I appreciate that for him. He also has a level of compassion when he's having to attack claims that are difficult. Terry said he got lost from volunteering because I refused to use my maps. Does he get lost because he's impaired or because he won't use maps? Fair. Emily, please try the game Tunic. It's like Zelda, but better. I will take a look. Emily, I'd pay money to see you as a judge. Well, eventually someone will want a judge to rule over Bravo disputes, and I will be ready for the job. Will you send out a text when the verdict is in? Yes, I will. We will also send the email at Law Nerd Alert because our international crew does not get text. Did we celebrate the bang? No, but we will do that later. Crystal said, thank you for covering this trial. The issue of destroying evidence has been fascinating. I think that's a big instruction that benefits Paltrow. Yes, I want to process all of your processes, a podcast of all of your processes. I'll be a 1L in the fall. Congratulations. My advice for law school: sleep is necessary to retain information. Set your boundaries. Do not put aside your health and well-being for law school. It will feel like you must. Others will, but you cannot perform well if you are exhausted, if you are living on not real food, and if you are drinking too much. Those are the things in law school that tend to happen. Make sure you are taking time to rest. Your brain needs time to process information. So, Kathy said 3.2 million for pain, suffering, and a new house in Europe. There is that. Lorraine said, I went to Machu Picchu with a brain tumor. We accommodate our disabilities, but have to continue living. It's a very good point. It is, though, in a civil case, something that is going to come up quite a lot. Thank you for the super chat. Raquel, Emily, I've had a rough day at work fixing phones and computers, and you've helped me through the day. You're my sunshine today. Happy to be your sunshine. We also had counsel say you can't get blown with skis on, or you don't keep your skis on when getting blown. So today has been an adventure either way. With all of that, law nerds, I'm going to sign off for now. I suspect we'll be back together today at some point. So lawnerdalert.com is where we need to be. And let's see, we are at almost 3:00 local court time. So we got about 2 more hours. I think we'll probably see a verdict. I will populate a stream in a little bit. Thank you for being here. We've been streaming for like 6.5 hours. It's time for everyone to take a break. So let's all just take a break. We'll reconvene here later. I'll keep you in the loop when that's going to be. And for now, law nerds, you're my favorite place to be on the internet. Thank you. I will see you soon.
You can find all the Law Nerd goodies at lawnerdshop.com. Connect with me on social media at the Emily D. Baker. And don't forget to check out my podcasts, The Emily Show, and the new podcast, Quick Bits, summarizing everything I talk about on my Tuesday and Thursday live streams. You know, when you only have time for just the quick bits.